Why don't you go see your boyfriend?
Yeah, he's got a nice room. He won't have it long. He left a call for 7 a.m.
See if we can figure out something.
Listen properly.
Hi. It has been a minute, and StreamYard changed settings. Why do I look blurry? Welcome everyone from Court Vibes. I am actually midway through cleaning the house. We are going back to my hometown tomorrow, and it's a very last minute trip. But I asked some neighbors to check in on the cats. So I just want to make sure the house looks neat. Thank you, Kathy. You don't look blurry. So it's not blurry. It's like I've got a lot of pimples at the moment, and they're not showing up on camera. It looks like Facetune or like, I don't know. Looks very smooth. Also, Robert from Cologne is first. Let's roll, nerds. Hey, Lilith. Lilith is alive. Court Vibes raid. Okay, so here's the plan. I have a 8-hour plus marathon that is edited and ready. I might interrupt at some point to show some other things that I have gathered along the way, but I have a lot more organizing to do. So there's a slim chance, basically, is what I'm saying. Okay, why are we in like potato cam? All right. And I've set up so that one of the cats is front and center. Okay, let's go.
Hello.
Hello, can you tell me your name, please?
Harry Ingleson.
Oh, Mr. Ingleson, okay.
Yes, Your Honor.
All right, just 1 minute here. I'm getting Mr. Carey connected. And then we have one other person joining us on the phone with the last 4 digits are 7264. Can you tell me your name, please?
I'm Marie Mullen.
That's Mullins. Okay, great, thank you. And Mr. Carey is now connected, so we'll go on the record. This is Mullen versus Brzezinski, case number 2118497. The record should reflect that Mr. Ingleson is present today by phone on behalf of plaintiffs. Mr. Carey is present by Zoom video on behalf of defendants. This was set as a control date back in June by the court. Mr. Ingleson, on behalf of the plaintiffs, where are we at?
Yes, Your Honor. Mrs. Mullen's husband works for General Motors. They had a time frame in mid-July to the 1st of August, I think it was, where they could both be there, and we had the surveyor come during that time, and I was able to go also. And where we are is we have an agreement, obviously a settlement agreement What we do have, however, is a disagreement as to whether or not the survey accurately describes the eastern portion of the property that is being transferred pursuant to settlement agreement. In other words, the survey versus the on the ground, what actually occurs, rather than a rectangle. It's, we believe, evident that it's more like a parallelogram, if you will, or an odd shape. And so, rather than try to explain all that to the court, Mr. Carey and I have spoken earlier today, and my suggestion, and of course, the court gets to decide what is, I don't know if it's better for you, Your Honor, to simply say, hey, here's your hearing date, fix it by then, or come in and convince me one way or the other so that we can get this over with. And that's certainly fine with us. And I'm not trying to have a hearing date. We're trying to resolve this, but we haven't thus far survived or succeeded 100%. So the only other alternative to that, I suppose, is whatever you might do in terms of status dates. But we realize we've had a settlement in place in writing, but not consummated it completely yet. It's been there for almost, I guess, over 2 years. We want to get it done probably as much as you do. So that's my status update, Your Honor.
Thank you, Mr. Carey.
As Mr. Engelson indicated to the court, he and I did have an opportunity to speak about a half hour ago. I was hoping that I could better understand what the plaintiff's disagreement with the survey was. Survey, this is a settlement agreement reached through mediation 2 years ago. The survey was completed in November of 2022. The survey appears to accurately reflect the agreement of the written agreement of the parties reached at mediation. And I think that Mr. Engelson agrees with me that the survey, as it was completed in November of 2022, tracks 100% with the survey. Apparently, the plaintiff says that on the ground, the settlement agreement is not being effectuated, notwithstanding that the survey does effectuate the settlement agreement, and the legal descriptions on the deeds that my clients have signed and long ago tendered to the court reflects the legal description created by the survey. It's a long way of saying I'm at a complete loss. My professional responsibilities to my client are being questioned by my client, honestly, and understandably. And I don't know what the best course forward is. Again, for many months now, my clients have completed all of their tasks relative to the settlement agreement. But the surveyor, the same surveyor that did the November 2022 survey, is the surveyor that came out in July of this year to explain why his survey was accurate to the plaintiff and apparently another family member. Since July, there hasn't been another survey. There hasn't been a corrected survey. There hasn't been any communication by the surveyor that says the one I did in November of 2022 needs to be changed, and here's how. Because I don't think it can be, because I think it's 100% accurate, and I suspect the surveyor does too. in kind of thinking this thing through, maybe I should be the one being criticized for not having filed a motion to enforce the terms of the settlement agreement. Maybe we should have had that done a long time ago. I think that's procedurally probably the only thing that makes sense. And, you know, again, I have to say, and this is not a threat. This is not a threat. I'm not mad at anybody. I'm more disappointed in myself than anything else. But if our motion to enforce the settlement agreement is successful and there's not a problem with the survey in terms of its consistency with the settlement agreement, Judge, I'm going to have to push very, very hard for costs.
Okay, well, here's where I'm at with things. We keep having these status conference hearings where you guys tell me basically the same thing that you told me here today. At our last hearing and looking at the status conference order from the hearing back in June, the court did set a motion cutoff in August for the parties to file some motions if they couldn't resolve. So from my perspective, and with an appreciation for both of you and understanding you're trying to get this resolved outside having to come into court and cost your clients more time and money. But, you know, I tried to set a cutoff date here to push this to a head if there wasn't an agreement, and neither side filed a motion. I think typically it would be the plaintiff's responsibility to prosecute their claims. However, because there's a mediation agreement here, I think either side could and probably should file a motion to enforce that mediation agreement according to the terms that your respective sides believe are appropriate based on the surveys and the facts. Nobody's done that. So here's what I'm going to do to kind of force this at this point is I'm going to give the parties 60 days to file a motion to enforce the mediation agreement and get it set for hearing. If neither party does that within the 60-day period, the court's just going to dismiss the case for lack of progress, and then you guys can decide whether you want to go back in or not. But I'm not going to. There's some feedback coming from somewhere here. I don't know who that is, but there's a lot of background noise. Anyway.
Oh, go ahead, Judge.
Anyway. I'm not going to just keep setting this for hearing and pushing it out. So either one side or the other is going to file a motion and get it set within the next 60 days, or the court's just going to dismiss the case.
Would I be able to get a date from the court now? Because I'm going to dictate the settlement motion right in the next 10 minutes.
I can't do that here on the record. That you'll need to call Jennifer and get a date from her.
That's what I would have said if I were you too, Judge.
Mr. Ingleson, I'm trying to unmute you there. I think it was your phone, because when I muted you, all that noise went away. Mr. Ingleson is still connected. He's not unmuting. Either way, I don't think I need to hear anything else from counsel, though. I think that'll settle it. I'm going to put that into an order. I'll get that out to the parties, and then we'll either have a hearing or the court will dismiss. So thank you. Both counsel are free to disconnect at this time.
Thank you, Judge, and sorry for the inefficiency here.
That's okay. Okay, it looks like we have counsel connected for our 2 o'clock. This is Tresha Smith versus Thomas Bauer, case number 2319444. The record should reflect that both Ms. Bailey Quick and Mr. Tompkins are present today by Zoom video. This was set for a status conference, and Ms. Bailey Quick, on behalf of plaintiff, can you update the court on where things are at?
Yes, we filed the conservatorship action. The hearing that the soonest that we can get in front of Judge Cooper is October 15th at 10 a.m. And speaking with Ms. Parker, she, because a lawyer guardian ad litem has to be appointed, she allows a minimum of 30 days. She indicated that Mr. Brown will be appointed, and we could have gotten an October 1st date. However, I'm in a bench trial all day that day. So the next available date is October 15th.
Okay. Mr. Tompkins, anything that you wanted to add to that?
No, Your Honor. Ms. Bailey Quick did send us the pleadings. We have those. And, you know, we'll certainly will make ourselves available for the hearing on October 15th. We did submit to Ms. Bailey Quick for her consideration and that of her client a proposed release, and I'm sure that we can work out the terms of that offline, but I wanted to point that out. So.
Okay. Do you want me to set a next date, or Ms. Bailey Quick, you want to set it for a hearing following the October date, probate?
I would say any date right after that October 15th date, because that should be the one and only hearing that's necessary.
Okay, I just want to be, I don't want to keep forcing the two of you to appear when we, you know. So if I set this for November, or do you want me to wait till December to set it for final hearing?
I would think November would be fine.
I think we can make a date work, Your Honor.
Okay.
November.
All right, so the court will set this for a final status conference in November, and Ms. Bailey Quick, if you could just, you know, file a motion for the court to approve the settlement and set it for that status conference date.
Yep, I can.
Okay.
Yes, I can do that.
All right, anything else I can address for either of you while we're on the record today?
Nothing here, Your Honor. Thank you.
No, Your Honor. I guess if I could just clarify, so you want me to just submit a proposed approval of settlement? I guess I typically do that in the probate court, and so if I look a little perplexed or confused, I guess I'm just looking for some clarification.
All right, normally, excuse me, in civil cases where there's settlements involving minors, then we do have a final hearing to close out the circuit court case. So that's all I'm looking for.
Okay,
Okay, thank you. That's all for today. Both sides are free to disconnect at this time.
thank
Thank
you.
you, Judge. Good seeing you.
You too. All right, I think we've got all counsel connected, so we'll go on the record. This is case number 24-19708-CH, Kent Family Farm versus Benjamin Vaughn et al. And I can just have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Judge Paul Slough on behalf of Kent Family Farm.
Judge Jeff Shimovitz on behalf of Benjamin Vaughn.
And good afternoon, Judge Drew Norton on behalf of the Rosemary Kuratalo Trust and Michael Jonas.
Good afternoon, Your Honor. This is Indra Pandiraj, P84364 on behalf of Mortgage Electronic Registration Systems, Inc.
Okay, thank you. So we're on the record here today for purposes of a scheduling conference. I did have a chance to review just the complaint. Generally, I see that the parties did enter into a stipulated order, kind of just maintaining the status quo, I guess, during the pendency. I understand this is a boundary property dispute. Mr. Slough, on behalf of the plaintiff, do you want to take a shot at some early mediation here before we set a lot of dates or set some motion cutoff dates? What are your thoughts? And then I'll get input from the defendants as well.
I would not have an issue with that. I think that may be very constructive in this case. The parties already, before the lawsuit was filed, engaged in some discussions about how they might be able to resolve it, and having the attorneys present and a mediator to help kind of facilitate those discussions may be fruitful. So again, I think an early mediation would make a lot of sense. The facts are really not in dispute. I mean, I don't think there's a lot of disputed facts here.
Okay, Mr. Shimovitz?
I think that early mediation may be very constructive.
Okay, Mr. Norton?
Absolutely agree, 100%.
Okay, and Ms. Prayardashian?
I agree as well, Your Honor, with all my brother's counsel in terms of mediation would be a constructive place to resolve this case.
Okay, so here's what I would kind of propose then is just having a pretrial order that indicates discoveries to remain open for the time being to the extent that any parties want to engage in some discovery. Set a mediation cutoff of 90 days. And with parties to, at least at the outset, to attempt to agree on a mediator. If you can't, then the court will provide a mechanism for a mediator to be selected. And then set this for a status conference kind of at that 90-day mark to get everybody together again, see, obviously if the case is able to be resolved through mediation, then we can go down that route. And if not, then we can see where things are at. Mr. Slough, do you have any objection to that plan going forward?
None at all.
Mr. Shimovitz?
No, sir.
No objection.
No objection for me as well, Your Honor. Thank you.
Okay, great. So I will put that into an order. I'll get that out to all the parties. The court will also send out a notice of the date and time for that next status conference, which will be by Zoom, just as we're doing today. And that's all I have for today. Thank you, counsel. You're all free to disconnect at this time.
Thank you
Thank
very
you,
much,
Judge.
Your Honor. Thanks,
Have a good day.
everybody. Thank you.
All right, we're on the record in Ryan Bentley versus Riley Gauthier Parrott. This is case number 2419654. And this is set today for entry of a default judgment of divorce. And Mr. Bentley, is that how you wanted to proceed today?
Yes, sir.
All right, this hearing was set for 3:15. It's now 3:18. I don't see Ms. Gauthier Parrott attempting to join in the hearing today. So we'll proceed. Mr. Bentley, I'm going to place you under oath, and then I've got some questions that I need to ask you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. So if I could have you raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Bentley, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that your marriage could be preserved. Was that true when you signed that complaint?
Yes, sir.
Does that remain true today?
Yes.
Were there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
To your knowledge, is Ms. Gauthier Parrott currently pregnant?
No.
Under this judgment of divorce, you would not be receiving any alimony or spousal support. You understand that you would be waiving that forever, that you would not be able to come back later and ask the court for that?
Yes.
The judgment of divorce indicates that you've already divided up all the property between the two of you. There are no debts to be divided and you would each be responsible for paying any debts that are in your own name. Is that correct?
Yes.
It also indicates that you don't own any real estate or real property together. Is that correct?
That is correct.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of Mr. Bentley. The court finds that Ms. Gauthier Parrott was properly served with the summons and complaint, that she failed to answer, otherwise defend, that she was properly defaulted back on July 30th. She was provided with notice of the date and time of today's hearing, and as I indicated, has not appeared. So the court will grant the divorce. I've signed the judgment. That'll be available here for you, Mr. Bentley, if you want a copy of that for your records. Do you have any questions for me at all?
I don't think so.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you for your time. Appreciate it.
Thank you.
Bye.
Okay, we'll go on the record in Peyton Jones versus Munson Otsego. This is case number 2319251. And starting with plaintiffs, if I could have all attorneys put your appearances on, please.
Your Honor, Rebecca Walsh appearing on behalf of the baby Peyton Jones and her parents.
Good morning, Your Honor. Jennifer Sikorsky on behalf of the plaintiffs.
May it please the court, Ralph Valatutti appearing on behalf of doctors Murphy, Minor, Filey, and Jonette.
Good afternoon, Your Honor. Gretchen Olson appearing on behalf of the Otsego Munson defendants.
Mr. Quant, you're muted.
My apologies to everyone. Joseph Kwan on behalf of Acorn Health of Michigan, LLC, and Helena Broden.
All right, thank you. We do have one other person connected here under the name of Jim. Don't believe that's an attorney. I'm not sure if it's a party. Counsel, to any of you, I know that's not a lot of information, but that's all I see on my screen.
I don't know who that is, Your Honor.
Okay.
I can't help you, Judge. I don't have knowledge of Jim.
Me either.
Nor me, Your Honor.
All right, thank you. I'm going to remove that person then. It's hearing. Okay, we're on the record today. We do have a motion up set for hearing today regarding some discovery, and that motion is set for hearing as well as a status conference. I did have a chance to review the motion itself along with the responses and the replies. And I guess, just from the outset, I mean, frankly, I'm a little bit confused about exactly where we stand today, because it seemed like from at least one of the responses that, and probably from Mr. Quant, that his individual has been made available for depositions. I don't know that that's an issue, but I guess, Mr. Valatutti, it's your motion. Can you tell me what you're asking the court to do specifically today? Have there been developments that have changed what happened or where you're at since you filed the motion?
Yes, Your Honor. I'd just like you to enforce the law. There's been a waiver of any physician-patient privilege. I've had to subpoena Helen Broden for deposition to find out what she has to say. By rights and by the law as set forth in the D'Amico case, I hope Your Honor has read that case because it controls our situation completely. D'Amico versus Roe, 438, Michigan, 347. That case requires that a plaintiff assert the privilege at the time that the authorizations for medical records are sent out under 2.310. They never asserted any privileges regarding Acorn Health, but when it came time for us to investigate the healthcare providers who were providing treatment and care to the plaintiff at Acorn Health, which wherein plaintiff has listed at least 4 or 5 witnesses in their witness list. We had resistance from plaintiff's counsel indicating, well, you didn't send a subpoena out. Well, we didn't even want to take the deposition of Helen Broden. We wanted to talk to her, in which case, which D'Amico says we can. And instead, I was very happy to at least get the deposition of Helen Broden. But in a recent deposition, another name was mentioned, Rachel Adams. And I want the rights that any defendant has to talk to the healthcare providers who have provided treatment and care to Peyton. And the plaintiff has taken a unique position, and that is that I have to, in this case, for some reason that is unknown to me, schedule or subpoena each witness that I want to take the deposition of. Well, that would be true if I wanted to take their deposition. But in truth and in fact, I want to talk to them to find out if they have anything relevant to say about the case rather than go the more expensive route. Plaintiffs have executed a waiver of sorts with regard to the deposition of Helen Broden. And to your question, Your Honor, we do have the deposition of Helen Broden scheduled, and it is coming up pretty soon. It hasn't occurred yet. And the plaintiffs have executed an authorization for the taking of Helen Broden's deposition only. Well, I submit to the court that under the D'Amico case, that's a legal curiosity. You can't authorize waive the privilege as to one person that is listed in your witness list from a healthcare institution. That waiver has already occurred, and if I may read to the court from the D'Amico case, pages 355 and 356. The rules in Michigan allow the assertion of the physician-patient privilege at various stages in the proceeding. The court rules do permit, however, an implied waiver when the patient fails to timely assert the privilege. MCR 2.314, parent B, parent 1, requires that the party assert the privilege in the party's written response under MCR 2.310. That rule having to do with the request for the production of medical information, which long ago occurred when we received thousands of pages from Acorn Health. And again, reading in the case, and MCR 2.302B1B requires the assertion of the privilege at deposition. The penalty for not timely asserting the privilege under these court rules is to lose the privilege for the purposes of that action. The rule obviously recognizes, and then in a footnote cites to MCR 2.314, 2.302B as I read, and then goes on and says on page 356, it is patently unfair for a party to assert privilege during pretrial proceedings, frustrate rightful discovery by the other party, and then voluntarily waive the privilege at trial, thereby catching the opposing party unprepared, surprised, and at extreme disadvantage. Thus, the rule requires that the party choose between the existing privilege and the desired testimony. The party may not have both. The rule is rational in its design because the fundamental concept behind the rule is that one should not be forced to divulge certain information, certain communications. The essence of the privilege is the lack of disclosure, not the time of this disclosure. In this case, as in our case, in D'Amico, still reading, in this case, after the defendant sought the information under MCR 2.310, which we did long ago, D'Amico signed authorization forms permitting the release of the medical information. The privilege was not asserted in the plain language of MCR 314, parent B, parent 1, declares that the privilege is not asserted in a written response to a request to produce, is waived for the purpose of that action. See also Schuler versus United States from the case. The case concluded as that interview of plaintiff's physicians, medical providers, after the waiver of the physician-patient privilege is allowed. So what I have done is I am going to take Helen Broden's deposition, but I also want to talk to the other persons listed in the plaintiff's witness list from Acorn Health to find out whether or not I want to take their deposition. And if I do, I will then comply with 2.305. And if I don't, I won't.
So a question, I mean, isn't this, I feel like this is, you're asking for the kind of contact that you would have pursuant to either a negotiated, often negotiated qualified protective order, or one that's ordered by the court to allow you to speak. I mean, is that what we're talking about here? Is that what?
Yeah. Okay. Well, I don't understand the court's question. What I'm asking for is the right to speak and interview that is allowed under D'Amico versus Roe. Nothing more, nothing less. D'Amico.
All right, my question was because typically, I'll sign stipulated qualified protective orders that allow defense counsel to speak to various healthcare providers and so forth to determine whether or not, they're informal discussions to determine whether or not they want to proceed with discovery. Sometimes the parties can't agree on that, and there's a motion from the defendants for the court to issue a qualified protective order to allow them to do that.
Well, I think we entered.
And I'm just trying to understand if that's different from what you're asking for here, or that's what you're asking for here.
Well, I believe we've entered into a qualified protective order. For some reason, the plaintiffs have objected because they considered mental health care providers different from, maybe they don't consider mental health care providers different from healthcare providers. The Acorn Group is a mental health care provider paid for by Community Mental Health. But the rules do not distinguish between mental health care providers and health care providers. Mr. Quant was citing to section 330-1750, but that section, like all other sections, which applies specifically to therapists, that also has the same waiver provision in paragraph A. I believe a qualified protective order.
Hey guys, I don't know what the situation is with Richard, but I don't have anyone blocked except that guy that does the psychology things. So I don't know what the problem is. If he can maybe, sorry, it's echoing because I've got StreamYard on my phone. If he could maybe do a different account. Let me just block this person. Okay. Let me know, and maybe if the mods can see if there's something that I'm not seeing or something.
Order was entered into in this case, which allows me to interview those people.
Okay, all right.
But when I went to set up appointments with Mr. Quant, he said, well, I don't think we have a waiver of the privilege. Well, then I said, well, not me, but Michael Palucci, who was helping me on the case, sent over everything we had, and he wanted a specific waiver. So we sent that specific waiver to the plaintiff, trying to get it done as quickly as we could. This process all started in May, by the way. And then the plaintiff objected and said, well, you have to file a subpoena, which I think was where we got off track.
Okay.
That's in fact something we didn't have to do. And I may have not had needed to take Helen Broden's deposition. I'm happy to be able to take her deposition as it's scheduled now. Maybe she can answer all of my questions, but that's where we are.
All right, and I appreciate that. That clarifies it for me, because between the motion and all the replies and responses, it was a little lost on me exactly where the rub was here, but I think I understand now. So thank you for that clarification. Moving to the plaintiff side of this, either Ms. Walsh or Ms. Sikorsky, I'll ask one of you to address plaintiff's position throughout the time we're on the record here today. Either one, whoever wants.
I apologize. I didn't mean to interrupt, Your Honor.
That's okay. Just as long as it's only one of you, I don't care which one wants to do it.
Thank you, Your Honor. It'll be me. And I want to point out, first of all, this very same motion was brought before this court about 2 months ago. And the court, after denying the defendant's motion, ordered the defendants to file an order. I guess it probably is my mistake, Your Honor, that I didn't file one when they did not, but they never entered an order, or we wouldn't even be here today, because this is the same request for the same information. I think that Mr. Valetuti's error comes in, even if you have even if you get an ex parte qualified protective order entered, it doesn't force somebody to talk to you. And all you can do is ask. They don't have to sit down and talk to you. And my understanding is, of course, I came into this late in the game. I got a request from Mr. Valetuti's office. I didn't know they had talked to anybody at Acorn. They presented me with an authorization that had been modified from the one Mr. Quant gave to him to include additional information that I said, I'm not inclined to sign all this. Send me the communication from Acorn so I can see what they asked of you. And after they did, I said, well, you know, if you want to talk to Acorn, if we want to talk to the attorney for Acorn, at the time, I don't even think I knew it was Mr. Quant, that might be something different, but I'm not signing the authorization that you're asking for, which basically was giving them permission to do things that I don't believe they're entitled to do. So we came before you and we said, Judge, if they want to take somebody's deposition and we all can't agree on whatever authorization Mr. Valetuti wanted, then they should subpoena the witness. So they did. Mr. Quant then called me, or I called him. He sent me the authorization they wanted signed for that deposition. I had that authorization signed for that deposition, and what the court had, and so that deposition's going. But the order that this court said was, if there's not an agreement or they're not, you know, you can't talk to them, then you need to follow the rules and subpoena them for a deposition. The Acorn can say, I want this or that, or I want the plaintiff's permission to have this meeting, or I want you to notice the subpoena. I mean, that's well within their rights. They don't have to jump when Mr. Valetuti says jump. And that's what we've done in this case. And this motion should be denied just like the first one was.
All right, thank you, Mr. Kwan.
Thank you, Your Honor. I'm going to be the easiest participant in the hearing today, which isn't always my shtick, as Ms. Olson would probably attest. You know, we have no horse in this race. We're happy to cooperate with any party, provide, you know, information. My concern is that we're going to quickly get into areas of privilege with respect to the interviews that Mr. Valetuti wants to perform. I have no problem with these folks being available for interview, but if we're going to get into areas related to discretion of treatment and things of that nature, well, then we're getting into areas that I think privilege is clearly going to apply to, and I'm uncomfortable having my clients basically testify as to potentially privileged issues, or even offer information in an interview that could be potentially privileged, subjecting them potentially to professional discipline or potential, claims in litigation related to the breach of that privilege. The privilege belongs to Ms. Walsh and Ms. Sikorsky's client. They've been great to work with. Mr. Valetuti's been great to work with. We have no interest in being difficult to get along with. We just want somebody to either A, sign a waiver to let these people speak, or B, have the court order us to provide this information, and we'll comply. So we really don't have a horse in the race, so to speak, Your Honor. We're happy to comply with whatever the parties can agree to, or that the court wants to direct us to perform. So, thank you.
All right, thank you. Ms. Olson, anything that you wanted to add to this?
I don't think so, Your Honor. I think it's pretty clear now that Mr. Quant is just asking for an order of the court that the defendants are entitled to. So it seems to me that that's a simple answer.
All right, thank you. Mr. Valetuti, it's your motion. Anything that you wanted to say in response?
No, I think I've covered it all, Your Honor.
Okay, all right. I think for clarification purposes and because I am now 15 minutes behind my next hearing, the court's going to issue a written order. I think that might help with the parties going forward, understanding how they're to deal with this problem. So the court's going to issue a written opinion. I'll get that out forthwith. It won't take long. And then I'll also address further status conference issues in that order in terms of how we'll proceed with scheduling going forward. I appreciate the arguments of counsel here on the record today, and all parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
And are you ready to proceed with the all red matter?
Actually, I have Mr. Triolo here, and the individual you just put in the waiting room was Alicia Giltz, appearing under the name Jillian Wilson. I think she's borrowing somebody's computer.
Okay, so you have Mr. Triolo?
Correct.
Oh, I'll bring her back then.
Sorry about that.
That's okay. Okay, so Miss Giltz, I need you to unmute. Okay, ma'am, can you just tell me your name for the record, please?
Alicia Giltz.
Okay. All right, we're on the record in Triolo versus Giltz. This is case number 2419736, and we have both parties present today, both by Zoom. And Ms. Bailey Quick, I do have a proposed consent judgment of divorce. Did you want to proceed with taking testimony from your client?
Yes, Your Honor. Thank you.
Okay, and Ms. Giltz, did you want to proceed with finalizing the divorce today as well?
Yes, Your Honor.
Okay, so Mr. Triolo and Ms. Giltz, I'm going to ask both of you to raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, Your Honor.
Thank you. You can lower your hands, and Ms. Bailey Quick, if you'd like to proceed with taking testimony from your client.
Thank you. Matt, would you please state your name and spell your last name?
Matthew Mario Triolo. Last name is Triollo.
And at the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes.
And at the time you filed your complaint for divorce, had you been a resident of Otsego County for at least 10 days?
Yes.
Were you and Ms. Giltz legally married in South Boardman, Nebraska County on October 22nd, 2022 by a person authorized to perform marriages?
Yes.
And are you aware whether or not Ms. Giltz is currently pregnant?
I am not.
Did you and Ms. Giltz have any minor children born of the marriage, either natural or adopted?
No.
At the time you filed your complaint for divorce, you had alleged that there had been a breakdown of the marital relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
Yes.
And is it true today?
Yes.
You've electronically signed the consent judgment of divorce and you've had sufficient time to review that judgment of divorce. And in essence, it provides that you keep all of the personal property and household goods that you have in your possession and automobiles and recreational vehicles in your possession. And that Ms. Giltz will keep all of the personal property and household goods in her possession.
Yes.
There is a vehicle that Ms. Giltz currently has in her possession that is financed and titled in your name. And the judgment allows her 60 days to get it financed in her name to remove your name. And in the meantime, she is to pay you the monthly payment via Venmo. You understand that?
Yes.
And if she is unable to do so within the next 60 days, then the vehicle is awarded to you for you to sell or do whatever in order to get rid of the liability.
Yes.
You understand the judgment also awards you the separate property that's your real property that was not a subject of the marital estate.
Yes.
Okay. Each of you will keep your own pension retirement accounts or IRAs, your own bank accounts, and your own debts and liabilities. You understand that?
Yes.
And in the judgment, it also provides that neither of you will receive any spousal support. And after entry of the judgment of divorce, neither of you can come back to the court and ask the court to modify that in any way. You understand?
Yes,
Are you asking the court to enter this judgment today?
yes.
I don't have any further questions for my client, Your Honor.
All right, thank you. Ms. Giltz, I have a couple of questions for you. Are you currently pregnant?
No, sir. No, Your Honor.
Okay, and as Ms. Bailey Quick indicated, under this judgment, you would not be receiving any alimony or spousal support. You understand that you would not be able to come back later and ask the court for that?
I do understand that.
And I reviewed the proposed judgment. It does have your electronic signature. Did you in fact sign that judgment electronically?
Yes, Your Honor.
And did you read and understand all the terms in that judgment before you did that?
Yes, Your Honor.
Okay, and by signing that, is it your intention to abide by all the terms in that judgment?
Absolutely.
All right, thank you. Ms. Bailey Quick, did you have any questions for Ms. Giltz?
Do not.
Okay, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both the parties in this case. The court will sign that judgment. Ms. Giltz, do you have any questions at all?
I just need to know how to get the paperwork for the vehicle, as I have tried to reach out to Matthew Triolo for that said paperwork. As of right now, the tags are expired. I need to get insurance on it. Other than that, everything else is very understandable, and just need that paperwork.
Ms. Bailey Quick, can you address that issue?
Yeah, Alicia, I can give you a call later today. I have one more hearing or first thing tomorrow.
And so you broke up a little bit.
I can give you a call after my next hearing, or so a little bit later today or first thing tomorrow if you want.
That would be perfect. Thank you.
Okay, very good. Thank you. Ms. Giltz, you're free to disconnect. And then Ms. Bailey Quick, do you have Ms. Allred at your office, or is she signing in separate? Okay,
Nope,
thank you.
All right. And we're
Okay, we're on the record now in Allred versus Allred, case number 2419730. The record should reflect that Ms. Allred is present by Zoom with her counsel, Ms. Bailey Quick. This matter was set for a hearing at 3:30. It's now 3:50, and Mr. Allred has not appeared or attempted to sign on. Did you want to proceed with taking proofs from your client in this case, Ms. Bailey Quick?
Yes, Your Honor, and we actually expected that he wasn't going to appear.
Okay. Ms. Allred, if you'd raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Ms. Bailey Quick, please proceed when you're ready.
Thank you. Would you please state your name and spell your last name?
Jill Anderson Allred, spelled A-L-R-E-A-D.
Thank you. And at the time you filed your complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes, I did.
And at that same time, had you been a resident of Otsego County for at least 10 days?
Yes,
Were you and Mr. Allred legally married in Brighton, Livingston County, Michigan on August 4th, 1990 by a person authorized to perform marriages?
yes, we were.
Are you currently pregnant?
No,
Do you have any minor children, either natural or adopted, of the marriage?
no,
At the time you filed your complaint for divorce, you had alleged that there had been a breakdown of the marital relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at that time?
yes, that is correct.
And does that remain true today?
Yes, it does.
Are you asking the court to return to any former maiden name?
No,
You've had an opportunity to review the consent judgment of divorce that both you and your husband have electronically signed.
yes,
And for the most part, you both negotiated this yourselves. And by way of that, you and your husband still own one joint property together.
Correct.
That is listed for sale.
It is.
You've sold another joint property and have paid off some marital debt or all of the marital debt.
Yes.
Right. And then you divided the net equity consistent with that identified in the judgment of divorce.
Yes, we did.
Contemporaneous with the filing of the complaint for divorce, you had also acquired separate property and purchased your own real property, correct?
Yes.
And that is awarded to you in the judgment of divorce. You've agreed that Mr. Allred will retain 100% interest in all business and real estate associated with Mayfair Accessories, and that includes all liabilities with that business.
Yes.
You and Mr. Allred have divided all of your personal property and household goods, and that is resolved. It is. Okay. Both of you will each retain the vehicles currently in your possession, and that's outlined in the judgment of divorce as well. And each of you will also retain your own pension and retirement accounts, which are specifically identified in the judgment of divorce. The judgment also specifically identifies specific bank accounts that each of you will retain and or sign off from. You agree with that division? Yes. Likewise, the judgment provides certain debts and liabilities to be assumed by each of you, or that was paid off from the sale of the real property. You agree with the division as outlined in the judgment of divorce?
I do.
There are certain debts that there are judgments against your husband, and those are specifically awarded to him as his separate debts, and you are not responsible for those at all in the judgment. Is that correct?
Yes.
Okay. In the judgment, it also provides that neither of you will receive any spousal support, and after entry of the judgment, spousal support is forever barred, and you cannot come back to court and ask for any modification or change to that provision. You understand that?
Yes.
Are you asking the court to enter the judgment of divorce?
Yes, I am.
I have nothing further, Your Honor.
All right, thank you. The court has reviewed the proposed consent judgment. I do note that although Mr. Allred is not present today for the hearing, that he did sign that judgment along with Ms. Allred. The court finds that it contains all the provisions required by statute. The court is satisfied based on the testimony of the plaintiff that the statutory grounds for divorce have been met. The court will grant the divorce, and I've signed that judgment as presented. Anything else that we need to address for this file today, Ms. Bailey?
No, Your Honor.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Your Honor, my car is not moving. Just not that you're too concerned, but I'm just at my son's football practice. But I didn't want you to think I was flouting the rules and driving.
No, I can see the trees behind you are stationary, so.
Yes, sir.
Unless you got some really, really good CGI going there, except that you're not driving.
It's actually it's a good idea.
Okay, and we have, we've got both counsel connected, so let's go on the record that in Amur Equipment versus Stuckman, this is case number 2419661. If I could just have counsel both put your appearances on, starting with plaintiff, please.
Yes, good afternoon, Your Honor. Craig Mears on behalf of Amur Equipment Finance Incorporated.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of defendant Jacob Stuckman, who's also a cross plaintiff in this matter as well.
Okay, we're on the record here today for motion to enter a default judgment. I did have a chance to review the motion and supporting documents. Mr. Mirza, is there anything that you wanted to state for the record today?
Not if it's not necessary, Your Honor. This is a breach of a commercial lease agreement. And obviously suit was brought against the company and Mr. Stuckman. Jacob Stuckman, who Mark Dundon is appearing for today, is a guarantor. And Mr. Stuckman and the company, Frank Stuckman that is, have not filed an answer as required under the Michigan court rules, and a more respectfully request the entry of a default judgment in an amount of $133,595.92, with interest accruing at 18%, which is the default rate under the terms of the contract or lease agreement, from November 15th, 2022 until the entry of judgment. And all of that is spelled out in the affidavit that Amor filed from Carla Barron in support of this motion for default judgment. So if there's no objection by anyone here today, I would respectfully request that the judgment be entered in accordance with the motion. And as I did submit a proposed default judgment against Mr. Stuckman and the company. And again, this is Frank and not Jacob. We'll be dealing with Jacob by a motion for summary disposition in the next few weeks, I think. So with that, I would respectfully request that the motion be granted.
Thank you. Mr. Dundon?
I'm not opposed to the entry of the motion. We're obviously, I'm not going to weigh in on the numbers or what they are, but if he didn't answer, he didn't answer. So we're also going to be, just so the court's aware, we're likely going to be filing our own based on our cross complaint. I believe I'm coming up on the 28 days fairly shortly.
Okay, very good. After reviewing the file as well as the motion and brief filed by Mr. Mearswell, the court finds it would be appropriate at this time to enter default judgment against Stuckman Tree Service, Inc. and Frank Stuckman only. I do have a copy, as Mr. Mearswell indicated, her signature, so I'm signing that default judgment with today's date. Mr. Mearswell, anything else I can address for your side today?
No, Your Honor, that is all. Thank you very much.
Mr. Dundon, anything further for the record?
No, thank you, Your Honor.
Okay, thank you. Both counsel are free to disconnect at this time.
Thank you very much, Judge. Have a great day. See you, Mark.
Yep, see you, Greg.
Okay, looks like we have both counsel connected, so we'll go on the record in Martel versus Simpkins. This is case number 2218919. If I could have both counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. Dave Glenn, Kuhn Rogers, on behalf of the plaintiffs, Martels.
Thank you, Your Honor. Jason Thompson on behalf of the Simpkins defendants.
Okay, Mr. Glenn, this is your motion requesting sanctions for failure of the defendants to comply with the prior order of the court compelling certain discovery. I did have a chance to review your motion as well as the attachments. Is there anything that you wanted to state by way of oral argument today?
Not much, Your Honor. I think it's pretty self-explanatory the way it's laid out. Unless I'm missing something, the attached discovery from Amazon doesn't appear to match any of the existing knowledge that we have of those cameras. I mean, it's pretty obvious that especially that one, for lack of a better term, globe camera that faces the Martel property doesn't look like it's even close to the cameras that are referenced in the Amazon advertisement. So it's pretty obvious that those aren't the cameras that are installed on the property, and we have no actual information other than just looking at them. And I've done my best to try and Google cameras that look similar to see what their capabilities are, but without actually knowing the model numbers and the cameras themselves, we're unable to know what their capabilities are. And like I said in the motion, this is now our third motion to compel. Wasn't exactly even sure what to call it, but it's a motion brought under court rule MCR 2.313B, which I think addresses situations where you've had repeated failures to provide the discovery that's requested. And I think we have that here. I'll leave it to the court's discretion on how it wants to handle it and what relief, if any, it wants to order. But we're kind of left with our hands tied. We have a trial upcoming in October, I think even early October on the 3rd. And we don't even know what we're dealing with as far as the cameras. So I probably should discuss that date as well at this hearing, but I'll give it over to Mr. Thompson here. Thank you.
Thank you. Mr. Thompson, your response?
Thank you, Your Honor. Our position is we complied fully with the court order. We provided all the model make information from the Amazon webpage for all the cameras on the property that Mr. Simpkins uses. I got a question from counsel that there's a larger camera, I guess. Sent back a supplement that said that it doesn't work essentially. I'm probably getting out of my depth technologically, but it doesn't. He's not able to utilize it for anything. It's outdated. So it just sits there for kind of deterrence purposes, but it's not used. So those are our responses, Your Honor. We believe we fully complied and we don't have anything we need to add to our responses. Thank you.
All right, thank you. Mr. Glenn, it's your motion. Anything that you wanted to say in response?
Yeah, I just find it hard to believe that thing doesn't operate. I mean, in discovery previously, they provided photographs and video frames in the previous case from that camera. It's a pretty sophisticated looking camera to be up there as a decoy. So I don't know. I would find it hard to believe that it's up there without power or whatever. And if it is, I mean, they were pretty reluctant to bring it down upon request. So yeah, I find that hard to believe.
All right, again, I had a chance to review the motion and the supporting documents. Looking at the responses to the interrogatories, the court finds that they are not sufficient, with the exception of sub C. I find those answers to be responsive. However, the court finds that just putting a Amazon ad is not responsive to the interrogatories, particularly with at least regard to one camera, which the supplemental response, I believe, indicated was installed 10 years ago. So clearly the Amazon ad can't refer to that. And so based on that, I don't know that it's accurate as to some or any or all of the other cameras. So the court finds that the answers to their interrogatories are not sufficient and not responsive under the court rules. So in response to that, the court has
Okay.
and not responsive under the court rules. So in response to that, the court has a number of different options. Number one, the court is going to order that the defendants provide the make and model of each specific camera, that the defendants provide either a website or a link to owner's manuals that are specific to those makes and models, or to just simply answer the questions with regard to the capabilities of each of those cameras, one or the other, so that the plaintiffs have an ability to understand what kind of cameras they are, what model they are, and what their capabilities are. And then the plaintiffs can take that information and do further research, I guess, if they want. In terms of a sanction, the court has multiple different types of sanctions at its disposal for violations of discovery orders. In this case, I don't find that drastic sanctions of default or dismissal are appropriate given the circumstances. However, the court finds that this is a motion that didn't need to happen. So the court is going to award attorney fees and costs related to the filing and arguing of this motion. Mr. Glenn, I'm going to ask that within 14 days you provide the court with an accounting. The court still is required to examine attorney fees and costs for reasonableness. So once you submit those, Mr. Glenn, I will conduct that analysis and issue an order. And then the court is also going to order that the responses, as I've indicated, be provided to plaintiffs within 14 days. And so, Mr. Glenn, if you can prepare an order reflecting that the court's granting your motion for the reasons stated, and the other specifics that I've indicated. Have I been sufficiently clear, Mr. Glenn, for you to be able to craft an order?
I believe so, Your Honor. Yep.
Okay.
Your Honor, may I interject here real quick, please?
It's up to you. You can talk to your attorney and see.
No, I'd rather not. I'd rather not. So just to clarify what he provided to the court, the PTZ camera on the peak of the house is 10 years old. It was not purchased from Amazon. It was purchased from a company who is no longer in business. The software is no longer supported. So therefore, that camera is no longer functional. I put that in my note to my attorney, Jason Thompson. It clearly says the software is outdated. That camera does not function any longer. The Amazon description, because they wanted all the details of the cameras, the Bluetooth cameras that we have on the property, or the 4 or 5, are the Wise camera system. Those are the only functional cameras on that property. So we provided what the court and the council had asked us to provide to them. We did in detail. The ad from the Amazon gave you every detail of those cameras, more so than I possibly could tell you what those cameras functionalities are. So once again, back to the rooftop PTZ camera, that camera is not functional. That camera will be coming down once they start construction on the property. I don't have the ability, or nor do I like heights to climb up there and remove that camera. And I believe in our answers, we did say that that camera software is no longer supported. That camera is not functional. Those are the camera. I don't even know what the brand of that camera even is. So I understand maybe where you're coming from, but we did answer and we did respond. The Amazon, you're right, Amazon probably wasn't delivering cameras 10 years ago. Who knows? I don't know, but it didn't come from Amazon. I don't know who it came from. I have a phone number. That phone number is no longer available to get a hold of anybody. So I assume that company is out of business. But once again, the software is not supported. So those cameras are not functioning. The only cameras, once again, functioning are the ones that we purchased from Amazon, which the Martells know where all those are at on the property, because they walk around, they see where all the cameras are at. So we've exposed all the cameras, and they also want to know what the cameras would take pictures of. We also set examples of what those pictures are of, what those cameras took pictures of. So I feel that we did comply with what the court was asking for. I don't know how we did not comply. I mean, if we stated in our answer that the camera is not supported with software any longer. Now, council does have a right. They can subpoena us and they can come to the house. They can check those cameras and verify that if they want to. They have 14 days to do so. And if they want to do that, I'm more than welcome to open the doors up and they can come in and verify that that camera system is no longer functioning. I think that's a fair statement. So I just want to put that out there to the court that we did provide what the court asked us to provide. So I just leave it at that. So the cameras we have that are functioning are the Wise cameras. The PTZ on the peak is not a functioning camera. Has it been functioning maybe about a year now? I know council says, well, we have pictures. We do. Those pictures are from many, many years ago over the property dispute. Those are old pictures. You and I both know that. The court knows that. So that camera hasn't functioned. I'm thinking maybe a year, a little more than a year. So I don't know what the irrelevance of what more information are they asking for? I'm confused because we gave council what they were seeking. So I don't just leave it at that, and hopefully the court will reconsider its determination on this. Thank you.
Okay, thank you. My ruling is what it is. And so Mr. Glenn, I'll just ask that you submit the order as I've indicated today. In terms of the trial dates in October, unless one party or another files a motion, I'm going to consider that trial date to be on. And so the court's at this point not going to consider adjourning that or moving that, absent one side or the other filing a motion, providing good cause and justification for doing so. That's all I have for the record today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Good morning, Miss Beebe. Can you hear me?
Good morning, Judge. Yes, I can.
Thank you. All right, Mr. Mose, can you hear me?
Yes.
Okay, we will go on the record in the matter 24 CM 122, State of Wisconsin versus Nicholas Mose. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Mr. Mose appearing by video conferencing in custody at Red Granite Correctional Facility without counsel. We're set today in this matter for a plea and sentencing. I believe it was plead to the count for costs?
No, it was, oh yeah, it is. It was if he pays restitution, conviction for costs.
All right. And so, Mr. Mose, you have prepaid restitution in the amount of $49.38. And so you wish to plead to the retail theft for costs only recommendation to the court. Is that correct?
Yes.
How old are you?
37.
Can you read, write? Do you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Have you been deemed mentally ill or suffer from a mental disorder?
No.
Do you understand that you have certain rights, constitutional rights that you would be waiving and giving up by pleading guilty? Those rights would include the right to a trial, the right to have yourself or an attorney cross-examine the state's witnesses or call witnesses to testify for you. You would be able to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty or not guilty verdict. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand the rights that you would be giving up here today?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand the state would have to prove around August 27th, 2023, in the village of Webster, Burnett County, Wisconsin, you intentionally took and carried away merchandise held for resale by RNJ Grocery Enterprises, doing business as Wayne's Foods Plus, without the consent of the merchant and with intent to permanently deprive the merchant of the full price of that merchandise, which did not exceed $500. Do you understand what the state would have to prove?
Yes.
You understand that upon conviction, you do face a fine of $10,000 or 9 months of incarceration or both?
Yes.
And do you understand that the recommendation here is for costs only, but I don't have to follow it if I don't think that that is an appropriate sentence? Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Do you understand that you're entering a plea and being sentenced by video conferencing, but you do have the right to be here in person? Do you understand that?
Yes.
Do you wish to be here in person or to continue and enter your plea by video?
I wish to enter my plea by video.
All right, thank you. Now, are you admitting here today that you in fact did take merchandise from Wayne's Foods Plus without their consent?
Yes.
And you did so to permanently deprive them of that property and value?
Yes.
Do you have any questions for the court or Mr. Schmidt before we proceed?
No, I don't.
Has anyone made any threats or any promises to you for you to enter a guilty plea?
No.
You're doing so freely and intelligently, telling the court that you fully understand what you're doing here today?
Yes.
And voluntarily?
Yes.
As to count one, the sole count, retail theft, intentionally take, a misdemeanor, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the charge. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
This resolution is appropriate. The conviction will accomplish accountability. He's currently serving a 2-year prison sentence. So concurrent probation and jail would not make sense because they'd have no effect on the offender. A consecutive jail sentence would be disproportionate because DOC would automatically convert a consecutive jail sentence into a consecutive bifurcated prison sentence per Wisconsin statutes, which would be way out of proportion with what this offense was, which was stealing a small amount of cheap liquor. Thank you.
All right, thank you. Anything you want to add or state for the record, Mr. Mose?
No.
All right. Based upon the arguments of the state and the fact that you prepaid the restitution, I think that the agreement is appropriate. I do believe that retail theft is probably skyrocketing, especially in the Burnett County area. And I do think that there should be punishment with that kind of crime beyond restitution paid. However, as Mr. Schmidt did argue that if the court were to do any type of jail sentence for this case, then it would actually be an additional prison sentence for this case, which would make it a disproportional punishment. And so based upon your case individually and in looking at the totality of the circumstances of all involved, I will find that the recommendation for costs only is appropriate. So what I'm going to do is I will assess $49.39 for restitution. That's already been paid. $200 for DNA surcharge. I am going to order that that be paid at a minimum of $25 per month, and that would need to start immediately and can be taken out of any of your DOC funds through an assignment, income assignment. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay, not only will the court enter a civil judgment against you because you're always going to owe it, but you could sit an additional 6 months in jail. I guess it could mean an additional 6 months in prison based upon if you're still in custody and you aren't figuring out how to get this paid. I do need to order your fingerprints and your DNA, and you can, hopefully the prison will be able to take both of those and get that over to Burnett County or upload it into the system. You have, again, 20 days to appeal. I believe that covers everything, Mr. Schmidt.
It does.
All right. Anything else, Mr. Mose?
No.
All right. Then we are adjourned. Thank you.
Thank you.
Mr. Thone, we're here for a couple reasons today. Mr. Thone, we're here for a couple reasons today. One is the initial appearance, and we'll go over that. One is for a bond motion hearing, and it's to hear you on bond as well as the state on bond, because the state's asking to increase your bond from $10,000 to more than that. And you're arguing to lower that. But also, Mr. Thone, I was going to ask you and see where we are on your ability to have anyone be able to get any money.
I wasn't able to, but one of the deputies downstairs got an idea and said, well, you can have electronic check or whatever you call it. So there's a grand around here somewhere.
So you have what?
Can
you pull the microphone closer?
He said, one of the deputies said I could have electronic checks sent here.
Okay.
So anyway, that's done. There's $1,000 here. They said they got it in.
Oh, yep. And we have confirmation that that was posted. All right. And so then I'm going to move forward today and get an attorney for you. I did have a Lance Nelson reach out and say that he would take your case. Are you okay with that?
He's sure had up in Superior.
And he said he understands your Huntington's disease and he understands where you are. And he doesn't know exactly what happened, but he thinks he has an idea and said that he would take your case.
Okay.
Okay? You're okay with that? All right.
If he's being like that, okay.
Okay.
Nice.
All right. And so now knowing that, and I don't know what's going on with bond yet because we haven't gotten that, but do you want to wait for your initial appearance so you can talk to him first? Or do you do want to do that? Okay. We will go on the record in the matter 24 CF 184. State of Wisconsin versus Richard Thone. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Mr. Thone appearing in person in custody without counsel. We're set today here for a couple reasons. One is to find out about the attorney deposit from Mr. Thone for his court-appointed attorney. He was able to get $1,000 deposit to be paid, and we have received that payment. We also discussed that Lance Nelson, an attorney that represented him in Superior, has agreed to take his case if Mr. Thone is okay with that. And Mr. Thone has indicated, yes, he wishes to have Mr. Nelson appointed to the case. And so the court will go ahead and do that here today. Mr. Thone has also stated that he wishes to have the initial appearance set at a date and time in which Mr. Nelson can represent him and be here for him and with him so that he can go over the information in the criminal complaint before entering any type of plea and moving the case forward. Is that all correct, Mr. Thone?
I totally spaced everything you just said.
All right.
Because of my Huntington's.
Just what we just talked about Mr. Lance Nelson being appointed and that you want to wait for your initial appearance until you can have him with you.
Okay.
Is
I don't
that,
know if you're so mad at me when I hung up on him, my Huntington's was acting up and I wasn't real pleasant.
but
Anyway.
he said he'll take your case if you're good with that.
Oh, yeah.
Okay. And so you want to wait until he can be here with you?
Yes.
Okay. All right. And so now what we're going to do is hear the bond motions from both sides. And are we in victims' rights compliance?
Yes, Your Honor.
All right. We're in victims' rights compliance. So I'm going to hear Mr. Thone's request first. You want to have the bond lowered. Is that correct, Mr. Thone?
Yes.
Is there anything else that you would like to add as it relates to that request?
I don't know anything about this kind of stuff, so I don't know.
You right now it's set at $10,000. Is there an ability to be able to post that amount?
No way.
And so you're asking for a lower amount? And what amount are you asking the court to consider?
Well, I don't know. After I gotta do this 6 months. And then then there's like a signature bond or something.
Oh, so right now you are actually on a revocation or on a bond or on a probation hold?
Yes.
Okay, and so they said 6 months to you? All right, so there's 6 months that you're going to be in custody, correct?
Mm-hmm.
Yes. All right, okay, so.
But
Mr.
then I was thinking, just a signature bond because my house is sitting there just.
After your 6 months?
Yeah.
Okay. Mr. Schmidt, knowing that he is, I don't know if he's in revocation status or if he's on a conditional hold or anything of that nature, but are you still asking to increase bond?
Yes.
And I did read your bond motion. I'm not sure, Mr. Thone, you should have been provided a copy of the state's bond request and the jail staff member is indicating yes. And so did you understand his request?
The 10,000?
He's asking for more than 10,000.
Oh, yeah, I kind of read it over there.
Okay, and so Mr. Schmidt.
I'm not ready to read it. I want the jailers to it.
You want what?
It's hard for me to read it with my Huntington's.
Yes. Okay, so Mr. Schmidt, your argument and basis as to why you're asking for an increase?
There are two bases. First, I'll give the court the background information on DOC because I have talked with his probation agent. He is on a rev hold. His sentence that he's being held on has a state and imposed period of 6 months. That's what he's referring to. There are only 2 days credit on the JOC, so it'll be like 170. Assuming he loses the rev hearing, it'll be 178 days from the date he was arrested here because all that credit will count towards it. They are going to pursue the rev.
I'm having a hard time hearing you.
Sorry, that's my fault. They are pursuing the revocation because of the severity of the violation. I'm asking for the court to increase cash bond because I think the court had incomplete information when it was given the PC statement on 2 fronts. First, this being a second offense, elevates the offense, increases the maximum time he's facing by 15 years in this, where 10 of those 15 years is initial confinement. So the potential maximum penalty is much higher than the court was originally led on in the PC statement. To put that in some perspective, compared to OWI 10, the penalties Mr. Thone faces on this offense is 1 year longer on the initial or on the mandatory minimum and 25 years longer on the potential maximum. I think that that's a significant enough jump that it merits increasing bond based on that because of the higher penalties associated with it. I also think based upon the constitutional amendment that was passed with bail, this is exactly the type of case the legislature was thinking it should be applied in. Thone is charged with is one of the statutory violent crimes applicable to that statute. 9 months ago, Mr. Thone was placed on probation for an offense out of Douglas County. It's what he's being revoked on now. He's placed on 2 years probation. He was given state and imposed 6 months on a DC and obstruction. The fact pattern of that conviction, those convictions, was he was called in from a bar after getting in a fight, hitting a vehicle, leaving, and doing donuts in the parking lot. The patron caught it on their camera on the phone. Police found him. When the cop approached, he switched seats. His blood at that time was 0.093. They didn't end the case as an OWI. I don't know why, but regardless, it's similar behavior. About 5 months into the probation on that, he had a number of tickets in Barron County where that resulted from him rolling a 2019 black Yamaha UTV. He was severely injured, had to be taken to the hospital. They PBT'd him at 0.093, the exact same BAC from Douglas. He admitted he had been drinking. He admitted he had been speeding. So we had poor driving, the UTV, him severely injured. The same victim in our case was also in the UTV in that one. According to her sister, she was also injured in that, but the injuries were not severe enough for her to go to the hospital. Our case, he rolls a 2024 black UTV Yamaha. It appears Mr. Thone just bought a newer UTV. And this time the victim died. There was alcohol at the scene. There was an odor of intoxicants on him. We don't have blood back yet, so I can't say what his BAC is yet. This constitutional amendment was passed in response to the Darrell Brooks case in Waukesha County, where after he was released on bond on $1,000 cash from trying to hit his girlfriend with the vehicle, he drove the same vehicle into a crowd of people at a parade. The legislature and the voters who approved the constitutional amendment thought that the courts were bound at the time by this necessary consideration of likelihood to appear and then setting bond based on that. They wanted courts to consider totality of the circumstances, protecting the public. They think that when a person is showing a trend of behavior, showing they're dangerous, the court should be able to consider everything and do higher cash bonds. I think in this situation with that 9-month period, with this trend of behavior of uncontrolled alcoholism, bad UTV and vehicle operation, endangering himself and others, I think the trend is there. I think he can't control his own behavior. I think a higher cash bond is necessary. I think with the nature of what this charge is, I think that it's extremely likely we're going to hit 6 months and the case isn't going to be done with yet, which is why I'm still asking to raise the cash bond, because I think he's going to fully serve his revocation during the pendency of this case.
I'm not gonna do it again. Holy cow. I lost my girlfriend.
That's not what he said. He said that your revocation period, if you are revoked and you have to sit that full 6 months, that this case isn't going to be done yet.
No.
And that there are factors the court should consider with regards to community safety and risk.
Mhm. I'm not gonna hurt anybody. Holy crap, I lost my fiance.
All right, Mr.
After that, I won't touch this stuff. Holy cow. And this,
Well, I would highly recommend that you not make any more statements, or you not make any statements, Mr. Thone, because they can be used against you, and wait until you can have your attorney with you. Okay?
I think Mr. Thone can't control his drinking. He was placed on probation with conditions not to drink. He violated, severely injuring himself and his girlfriend. They placed him on the scram monitor for 2 months as a result of that. And he's already back to drinking with the new case. So for those reasons, I think the higher cash bond is necessary. Thank you.
And did you ask for a specific amount?
I asked for 25,000 in my filing. I think that would be appropriate too, considering the potential maximum penalties and the risk to the public after the 6 months have rolled.
All right. Anything you want to add, Mr. Thone? But again, I have to warn you that anything that you do say can be used against you. I do think that based upon that argument and the information contained in the motion, that a higher cash bond, at least at this time, is appropriate. $25,000 cash, same conditions. I will have Mr. Nelson be appointed to your case immediately, and that he will be in contact with you, and hopefully he'll be able to come and meet with you and go over the criminal complaint and all of those things, and hopefully the case can get moving. I'm not going to set a date because I need to know what works with Mr. Nelson's calendar. We are adjourned. Thank you. So Ms. Erdman, can you hear me?
I can. Oh, hold on just a second. I can turn my video on. There we go.
All right. We will go on the record in the matter 22 CF 254, 22 CT 45, 24 CF 101, 24 TR 435, and 436. State of Wisconsin versus Stephanie Current. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Current appears in person with counsel Michelle Erdman appearing by video conferencing. We're set here today in this matter for a plea hearing. The parties have reached an agreement, and Ms. Current wishes to plead today. Is that correct, Ms. Erdman?
Judge, I met with her on Sunday. She is prepared to enter her plea today, and then it would be with a PSI.
All right. Okay. And Ms. Current, that's correct and true?
Yes.
And you see your attorney over there on the left on that monitor. Do you understand that you do have the right to say, you know what, Judge, I want her to be in person? Do you understand that you have that right?
Yes.
And she's appearing by video today for the plea portion of this case. Are you okay with her appearing by video?
Yes.
If at any time you have any questions or any concerns and you need to speak with your attorney, let me know, and I'll have the jail take you back to the jail and put you into their Zoom room, okay? And I'll send you to a confidential breakout session. All right?
Okay.
All right. And so if at any time you can't hear or see something, please let me know so I can make sure that you've heard and you understood everything, okay?
Okay.
Ms. Erdman, can you please recite the agreement for the record?
Judge, I'm so sorry to interrupt. Ms. Current wanted me to inquire of her honor. She has really terrible pain in her hip that she feels needs to be surgically corrected or at least seen by a specialist. As your honor is aware, the charge that she's pleading out to will result in an immediate remand. So she wants to ask if your honor would consider bail, knowing that we do have an agreement and she is prepared to go forward with it at some point.
No. I would need further,
and then I did tell
doctors' reports and doctors' information. I would need a whole lot of information to make any kind of calculated and thought out decision as it relates to bail.
Okay. I did tell her that it would be possibly unlikely, and that I know prison is a little bit better equipped to perhaps manage some of those extraordinary requests. And so that I think is her desire to go forward today then. The agreement, your honor, as you were asking, is that she would be pleading to, I believe it's count 2, operating with a restricted controlled substance in her blood. And that's a fifth. And then it would be without the child enhancer. And then she'd also be pleading to felony bail jumping. And I think that would be one from each case that she has. And the resolution would be a PSI.
All right, and that's all accurate and true, Mr. Schmidt?
Yes.
All right, Ms. Current, knowing and understanding that if you enter a plea here today, it is an immediate report, bond and bail is revoked at that time. And knowing that you have asked your attorney to ask about a bail modification for health-related issues. And it is denied because I don't have enough information. Do you still wish to proceed and enter a plea here today?
Yes.
All right, okay. Formal motion to amend and to remove the enhancer, Mr. Schmidt.
So made.
Ms. Current, I have in front of me a plea questionnaire waiver of rights form. Did your attorney go over this document with you?
Yes.
I'm going to ask the jail if you can come and get this document so she can review that and she can see if that is the document her attorney went over, and then she will need to sign that document. Is that the document your attorney went over with you?
I believe it is.
All right, if you recognize that document, if you've reviewed that document, if you understand that document and everything it contains, please sign where it says defendant and there's typewritten reviewed person in jail. Ms. Erdman, I'm going to let you know that from today on forward, maybe I haven't told you, I am not accepting any more of these plea questionnaires without the actual signature by the defendant. I've had numerous attorneys, even in Madison, who get the signatures where we don't, but I have other attorneys that just think that it's willy-nilly and don't. This is a very important document.
Okay.
So
I
please
guess,
sign.
yeah, when they're in jail, it's a little bit harder. The jail is very awesome working with us, but it's just a little bit harder because usually they're short staffed, but we'll work on getting that done.
All right, thank you. You have now signed that document, Ms. Current, and that is the document your attorney went over with you.
Yes.
Did she go over it thoroughly with you? You can turn it into the clerk.
Yes.
And did she go over it essentially word for word?
Yes.
And so you understand everything on that document?
Yes.
If you didn't understand something, did you ask your attorney to explain it to you?
Yes.
And she did so?
Could I have a copy of that, please?
Yes, you sure may. We'll have the clerk make a copy for you so you can go over it while I go over it with you, okay?
If I'd known I needed documentation, I could have gotten that. But it's been so long.
That's okay. We'll make sure that we get you a copy so we can go over it with you.
Well,
all right, Ms. Current, so you can see that document right there. You're pleading guilty to operating with a restricted controlled substance in your blood, 5th offense, and a felony bail jump ×2. So 2 counts of felony bail jump. Do you understand that?
yes.
You're 65 years old. You have 17 years of schooling. You can read, write. You understand the English language. You are not receiving treatment for a mental illness or disorder, but you've had medications, alcohol, or other drugs in your system in the last 24 hours. What have you consumed in the last 24 hours?
Are
they prescription medications?
Yes, it's a Prozac.
And did you take your prescription as prescribed?
Yes.
Do any of your prescriptions interfere with your ability to comprehend or understand what's going on?
No.
Now, did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt as it relates to these 3 charges?
Yes.
Did your attorney go over with you the maximum possible penalty that you face?
Yes.
And so I can understand it. She's pleading guilty to 2 felony bails. Is that correct?
That is correct. I believe one of them comes.
Adding a count?
I believe one of them comes from a second case that she has.
Oh, 24 CF 101 has 1 count of felony bail. I only have 1 count of felony bail.
The intent was to add a second count on there as part of the benefit of the agreement.
All right, it's to add a count of felony bail in 24 CF 101. Is that your understanding, Ms. Erdman?
It was, Judge. When I spoke with her, we were doing some negotiating, and that was something she was willing to do in an effort to get it resolved.
And that's correct and true, Ms. Current?
Yes.
That to have other matters dismissed and read in and to have a benefit of a bargain in your negotiating, you agreed to add another count of felony bail jumping?
Yes.
All right. All right, so formal motion to add a count of felony bail jumping in 24 CF 101 based upon stipulation and agreement of the parties.
I so move.
Okay, the court will grant the motion to add one count of felony bail jumping. Are you going to file an amended information to reflect that or just count on the record, Mr. Schmidt?
I was gonna do just the record, but if the court wants me to do an amended information, I can do that too.
It makes it cleaner if we do. All right, so now you're pleading guilty to 2 counts of felony bail, 1 count of OWI fifth, with operating with restricted controlled or operating with restricted controlled substance without the enhancer. And she went over what the state would have to prove as to all 3 of those counts, Ms. Current?
Yes.
And she went over the maximum possible penalties you face, is that correct?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document in front of you. Your attorney went over those rights with you thoroughly, is that correct?
Yes.
Do you understand those rights completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes.
Do you understand that you won't be able to vote in any election until your civil rights are restored?
Yes.
Now, did you review the criminal complaints with your attorney?
Yes.
In particular, that section called the probable cause section that basically says what happened and why you were charged with these crimes.
Yes.
And for the most part, in both cases, are those facts accurate?
Yes.
Are you pleading guilty to operating a vehicle under with a restricted controlled substance in your system, 5th offense, because you're guilty?
Yes.
Are you pleading guilty to 2 felony bail jumps because you're guilty of a felony bail jump and the other one is a part of your agreement that you worked out with the state?
Yes.
Ms. Erdman, did you go over the criminal complaints thoroughly with Ms. Current?
Yes, Judge.
May the court find a factual basis and accept the probable cause statements for the factual basis in both cases?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing here today.
Yes.
And voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes.
Has she looked at these matters thoroughly?
Yes.
Has she discussed with you a potential for defenses or a lack of defenses in these cases?
No.
Well,
Yes.
She did? Okay. Now, did she discuss with you all of the facts and all of the information she found in discovery and got your statements as it relates to that?
Yes.
Are you satisfied with her services?
I am.
Any questions for the court or your attorney before I proceed?
No.
You understand that the state would have to prove as to the operating with a restricted controlled substance that on or around June 21st, 2022, you operated a motor vehicle while under the influence of a controlled substance and committed or under a controlled substance, which is a felony. And upon conviction, this shall be your 5th conviction. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you face a fine of not less than $1,200, but no more than $50,000, and that the court shall impose a bifurcated sentence of having the confinement portion being not less than 30 or not less than, I believe it's 18 months, a year and a half. Do you understand that?
Yes.
And do you understand that as to the extended supervision, it could be at the court's discretion?
Yes.
But a maximum possible penalty could be no more than a full term of a 10-year prison sentence. Do you understand that?
Yes.
That would be a total of 5 years for a maximum possible penalty for the operating with restricted controlled substance, incarcerated, 5 years of extended supervision. Do you understand that?
Yes.
That's without that enhancer. Do you understand that as to the felony bail jumps, the state would have to prove that having been charged with a felony in Burnett County case number 22 CF 254 and having been released from custody, you intentionally failed to comply with the terms of your bond by driving without a valid driver's license and another offense that you were restricted from as a condition of bond. Do you understand that?
Yes.
So this would be 2 counts of felony bail jumping because you were placed on bond and you intentionally failed to comply with your bond. Do you understand that?
Yes.
Do you understand for each of those counts, you face up to a $10,000 fine, 6 years of incarceration, or both? Again, for each. Do you understand that?
Yes.
Now, knowing those maximum possible penalties and all that we've proceeded with, do you wish to continue and enter a guilty plea here today?
Yes.
As to OWI operating with restricted controlled substance, 5th in 22 CF 254, how do you wish to plead?
Guilty.
In 24 CF 101, count 1, felony bail jump, how do you wish to plead?
Guilty.
As to count 2, an additional added felony bail jump, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those, or all 3 of those counts. The remaining counts and open cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report. Long form agent does not need to appear, but should be readily available by telephone in case any questions arise. Bond is hereby revoked. We need to set this date for sentencing. I can do November 21st at 2, November 21st at 2.
I can't date, Your Honor. I'm sorry.
November 22nd, anytime you pick.
Okay. I am going to be in 2 other counties, so I don't think I could be there in person. I'm sorry.
That's okay. We can do.
Actually, Judge, give me just one moment because one judge in that county does let me appear by Zoom, and I think I could perhaps come in the morning on the 22nd. I'm sorry, the 22nd. 22nd. Yeah, just if you could just give me just one moment. Judge, I could do that morning. I have a 10 o'clock hearing, but I could be there, earlier.
Can you do 9:30?
I can.
All right, so 9:30. Schedule it till 10:30, just in case. 9:30, we'll have a sentencing in this matter. Bond is revoked. November 22nd. Anything further from the state?
Not from me.
From you, Ms. Erdman?
Judge, I do have that 10 o'clock hearing. If you want a full hour, could we maybe back it up a little bit?
So how long is your 9 o'clock?
The only thing I have that morning is a status conference at 10 a.m. that should only take about maybe 5 or 10 minutes.
Oh, so could you do 9 to 10 or 9 to whenever?
Sure.
Yes, we can do 9 o'clock then, November 22nd. So 9 o'clock, November 22nd. I'm not sure it's going to take an hour, but I just want to cushion in enough time just in case.
Yep, I'll be there in person for the hour.
All right, then we'll see you then. November
Thanks,
22nd,
Judge.
9 a.m.
Thank you.
Thank you. We are adjourned. All right, we will go on the record in the matter 24 CF 165, State Wisconsin versus Shelley Lawrence. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Lawrence appears in person without counsel. We're set here today in this matter for a plea and sentencing. Ms. Lawrence, you're here without an attorney, and today, off the record and at the previous hearing, you indicated you wish to represent yourself. Is that correct?
Correct.
Do you understand you have the right to an attorney?
Yes.
And you understand that an attorney goes to law school and does these cases so that they're better equipped to be able to identify things such as defenses or strategies or other things that they would be able to see with the facts or negotiate with the state.
Yes.
And so you understand that there could be certain disadvantages to not having an attorney, because I'm just guessing that you're not legally educated.
Correct.
All right. So knowing that, do you still wish to represent yourself?
Yes.
And how old are you?
63.
Can you read, write, and do you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
No.
Have you been deemed mentally incompetent or suffer from a mental disability?
No.
Do you understand that because you're charged with crimes, you are entitled to certain constitutional rights? And you would have the right to have a trial. You would have the right to have the state prove your guilt beyond a reasonable doubt. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. Do you understand all of those rights?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove, I believe you're pleading to the retail theft with an agreement to a recommendation to the court of 1 year probation. Is that correct?
Yes.
And so do you understand the state would have to prove on or around July 19th, 2024, in Burnett County, you intentionally took and carried away merchandise held by sale by a Four Winds market without the consent of the merchant and with intent to permanently deprive the merchant of the full price of that merchandise, not exceeding $500. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you could face a fine of up to $10,000 or up to 9 months of incarceration or both?
Yes.
And do you understand that the recommendation is for that year of probation with certain conditions, but that I don't have to follow that?
Yes.
Said differently, I could sentence you all the way up to that maximum possible penalty if I thought it was warranted. Do you understand that?
Yes.
Now, do you have any questions so far?
No.
Now, are you admitting here today that you in fact did take some alcohol or other merchandise from Four Winds?
Yes.
And you're pleading guilty because you are guilty of that crime?
Correct.
All right. Now, has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court that you fully understand what you're doing here today?
Yes.
And voluntarily?
Yes.
Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
And, all right. And so do you understand that after today, you will have a conviction of a misdemeanor retail theft, and there could be probation and or it could be a jail sentence?
Yes.
All right. Do you have any questions?
No.
Then at this time, as to count 2, misdemeanor retail theft, intentionally take under $500, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt based upon your admission. So I will find you guilty of that count. I will waive and read in, or dismiss and read in the felony. A judgment of conviction will be entered today. Victims' rights compliance,
We are.
argument and sentencing recommendation, please.
The defendant, Miss Lawrence, is 63 years old and she has no prior criminal convictions. Up until recently, she worked at Marketplace Foods in St. Croix Falls. She lives in Luck. Basically, she was an employee in St. Croix Falls at that Marketplace Foods when loss prevention there was reviewing surveillance footage because they had a shortfall of their scratch-off tickets of $100. Just totally surreptitiously in that footage, and they're reviewing it, they happen to see Miss Lawrence taking unpaid merchandise and putting it into her purse. That triggered them reviewing 100 days of footage in which they saw she would frequently fill a shopping cart with merchandise, walk past the registers without paying, and then return with an empty cart. They estimated that $10,000 were taken during her employment at St. Croix, at Marketplace Foods in St. Croix Falls over that 100-day period. According to the complaint there, Lawrence admitted to the thefts. She also said she would ring up refunds of merchandise if the customers present and pocket cash from the refunds. She said she would frequently work under the influence of alcohol and she made bad decisions as a result. While on bond for that offense, she has not been convicted of that. She's presumed innocent of it. She came here from Luck to Four Winds out over by Siren, over by the roundabout. And she was seen putting a bunch of merchandise in a cart and leaving without paying. She was stopped before she left. She not allegedly anymore. She admitted she took stuff she didn't pay for. She also admitted to stealing before, which I assume was reference to Polk. What she had taken was normal foodstuffs and also some vodka. The total amount stolen was $65.80, but it was all recovered, which is why there's no restitution because they caught her doing it. I think there was maybe a corn dog taken, but they didn't ask for that. The reason I'm asking for probation on this is she's 63 years old. She has no prior history. There's something going on there. And the references in Polk County and the vodka taken here, maybe it's AODA. But with the period of time, with her referencing having taken before and the nature of this offense and her being on bond for what she's on bond for in Polk County, I think there has to be some sort of mental health issue going on here that would cause her to be doing this behavior. And I think with what is at least alleged in Polk County and with her admission that she's taken before, probation to get to the part of that is important for protecting merchants in our community and also Polk County. So that's why I think probation is needed on this, even though it's a first offense and it's a retail theft of less than $100. Thank you.
All right. Ms. Lawrence, is there anything you want to add? You want to state to the court?
No,
What's going on? What do you think's going on?
I don't know. I need to find a counselor.
Are you married? Are you single?
Well, we're going through a divorce.
When did that happen? When did that start?
Last week.
Okay. So it wasn't prior to the allegations.
No.
All right. Any traumatic loss in the last year or two?
No.
Any AODA issues? You think you have alcohol and other drug issues?
No. I mean, I go to AA and I've been to Ellie Phillips for treatment 3 times.
Okay. Financial issues?
Right now, yes.
Well, right now, I'm talking a year or two ago.
No.
All right, then I don't know either. Hopefully probation can figure it out because I'm not sentencing you and I can't sentence you to whatever happened or whatever occurred in Polk County. That's not in front of me. You're going to deal with Polk County courts and figure that matter out. But in looking at this particular case and knowing your history, your personal history of working somewhere, having allegations and essentially kind of doing the same type of thing that you were alleged to do in Polk County while under bond in Polk County, it's kind of serious. And hopefully somebody's going to figure something out. So I do think 1 year of probation is appropriate. So I'll place you on probation for 1 year. I'm going to do an imposed and stayed sentence. If you are revoked off of probation, you're not going to come back in front of me. You will automatically go sit time in jail. And I think at least for my case, I don't know what's going on in the Polk County case, and I don't know if you'll be convicted or if anything will occur here, but simply based upon this case here and the fact that I've seen a high rise in retail theft, and honestly, I'm not seeing any reason for you conducting or engaging in this type of behavior. You're not admitting to any AODA issues. There wasn't any marital issues. There wasn't any traumatic event. There wasn't any financial issues. So, there's no excuse, even if it's a bad one, for this behavior. So what I'm going to do is sentence you, if you are revoked, to 6 months of incarceration, 6 months in jail. And so hopefully you're going to be able to do what you need to do on probation. I'm going to order a mental health evaluation and follow through. And so hopefully they'll have some type of therapy recommendation and you will go through therapy. AODA assessment and follow through. No alcohol, no illegal substances, no drugs, no prescription medications without a valid prescription. No bars, liquor stores, taverns, beer tents, or any establishment that has the primary purpose for the sale or the service of alcohol. No casinos. All right, I'm going to say regular alcohol and or drug testing. I'm going to say gainful employment.
I am on Social Security disability.
All right, so I'm going to say employment or community service as Social Security will allow. I'm going to assess $443 in court costs and fees. But I believe that this type of crime deserves an additional punishment. So I'm going to add a $200 fine on there. So it'll be a total of $643 in fines and fees. I don't know if there's any additional surcharges or anything like that, but you have a total of $1,336 posted. So that'll cover this and more. And so as we discussed off the record, anything that's in excess will go to pay any fines and fees that you have outstanding in Burnett County. If you don't have any outstanding fines and fees in Burnett County, the rest will be remitted to whoever posted it on your own behalf, on your behalf. And it was you, then it'll be sent back to you. Is your address 27320 Pope Road?
Correct.
Telephone ends in 8978?
Correct.
All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm ordering you to provide your DNA. You need to go outside, go all the way around the building and go to the jail and provide your DNA. You have the ability to request it be expunged from the system through a written letter to the Department of Justice. You can Google it. It's pretty easy to figure out. 20 days to appeal. Failing to appeal within 20 days, you do lose that right. As soon as you're done providing your DNA, you must report to probation immediately. It's kind of kitty corner across the highway from this building. And so you should be able to see it. I think the clerk will give you a map and how to get there. I think that's covered everything. We're in victims' rights compliance, no restitution. What am I missing, Mr. Schmidt?
Nothing from me.
Ms. Lawrence. All right. Then go take care of all that you need to take care of. Do the DNA first, go to probation, and then you should be good to go.
All right.
Thank you. We are adjourned.
Okay.
We will go on the record in the matter 24 CM 113, State of Wisconsin versus Robert Heath. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Heath appears in person without counsel. We're set here today in this matter for a plea and sentencing. Mr. Heath will be pleading guilty to this count, and he will be there. It would be asking to have what were you going to ask to have on an electronic monitor for any jail time?
Yeah, it would be 5 days ECM. Do these have mandatory reports, or could he set it up with Tessa later?
He can set it up later. This is
Okay.
not a mandatory report. And so, and then it would be with additional costs. Mr. Heath, that is the agreement you've reached. And can you please pull the microphone up so the court reporter can hear you?
Yes,
All right. And so you're here without an attorney and you wish to represent yourself. Is that correct?
yes,
Do you understand an attorney is legally trained and educated to be able to spot issues and look for defenses and to negotiate with the state?
Yes.
And do you understand that there are certain disadvantages to not having an attorney, such as the fact that you're not legally trained and the attorney is? Do you understand that?
Yes.
But yet you wish to proceed and represent yourself.
Yes.
How old are you?
41.
Can you read, write, and understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
Just my prescription medications.
And you have Huntington's disease, correct?
Yes.
But that doesn't interfere with your ability to comprehend or understand things, correct?
Not yet, no.
No, all right. And so your medications you took, do they interfere with your ability to understand or comprehend?
No.
Okay. Now, because you're charged with this crime, you're entitled to what's called constitutional rights. I will go over those rights with you, but I want to make sure that you understand that by pleading guilty, you're waiving and giving up those rights. Do you understand that?
Yes.
And so you would be giving up the right to a trial. You'd be giving up the right to have yourself or an attorney cross-examine the state's witnesses or call witnesses to testify for you. You would be giving up the right to testify on your own behalf or remain silent and not have your silence used against you. You would be giving up that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would be giving up the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
All right. Do you understand also here that the state would have to prove on or around May 25th, 2024 in Burnett County, Wisconsin, you operated an all-terrain vehicle or a utility terrain vehicle while under the influence of an intoxicant to a degree which rendered you incapable of safe operation of that vehicle? Do you understand what the state would have to prove?
Yes, Your Honor.
You understand the maximum possible penalty could be a fine not less than $300, but no more than $1,100, or imprisonment of not less than 5 days, but no more than 6 months.
Yes.
Do you understand that the agreement reached between the parties and the recommendation to the court would be for the court to follow the minimum and impose 5 days of jail? Do you understand that?
House arrest, right?
And it would be argued for house arrest.
Okay. Yes, Your Honor.
Do you understand? I don't have to follow that if I think the facts are more serious. Do you understand that?
Yes. Your
Do you still wish to enter a plea here today?
Honor. Yes, Your Honor.
All right. Now, are you admitting here today that you operated an ATV or UTV while under the influence of an intoxicant that did render you incapable of safe operation?
Yes, Your Honor.
And this would be your second offense within 5 years.
Yes, Your Honor.
All right. Now, do you have any questions for the court or for Mr. Schmidt before we proceed?
Not that I can think of.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing today
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
You have any questions right now?
I had already been trying to get into AODA and will it be easier to get into AODA with a court order
With the order,
assessment?
yes. With this,
Okay.
with this charge, it should be. Because it probably, it's gonna be ordered, okay?
Okay, because I was already trying to get in it.
Okay.
So,
All right. So, how do you wish to plead to operating an ATV or UTV while intoxicated second within 5 years?
guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the crime. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Every interaction we've had with Mr. Heath in court, he's been respectful, he's been polite, he's been contrite about what he's done. It's sort of peculiar because, you know, this is second offense. It means there's a prior. He does have 2 prior normal motor vehicle OWIs. I see some forfeiture tickets, I think, out of one of the villages for public nuisance, excessive intoxication. I think doing the AODA is going to benefit Mr. Heath more than the 5 days ECM, to be honest. That's a statutory requirement, the 5 days ECM. I don't know if just alcohol doesn't agree with Mr. Heath, but I hope he figures it out. Thank you.
Thank you. Mr. Heath, anything you want to add or state?
No, I completely agree.
Okay. All right. So it's serious to drive an ATV or UTV while under the influence of an intoxicant, especially which renders you incapable of safe operation. We hear all the time of how people, there's rollovers, there's accidents, people get significantly and seriously injured. People have even died. And so it's very serious. It is as serious as a car. It's just a different type of penalty. So you're accepting the responsibility, you're pleading guilty, and you're being accountable. And hopefully you're going to
anyone else or myself.
What?
I don't want to hurt anyone else or myself.
And in all my encounters with you, Mr. Heath, I don't believe you do. I think that sometimes your Huntington's disease traps you inside your body. I don't know what that feels like emotionally, physically, anything. I know it has to be emotionally draining and frustrating. And I think, and again, my other encounters with you, that then you reach to the alcohol to try and feel better. And it doesn't make you feel better because you get into worse situations. And I think you are a good guy, Mr. Heath. I think you want to do right. And hopefully you can figure out other ways to get that frustration and the depression and the negative feelings out instead of self-medicating with alcohol. Because I think you are a good person and you want to do good. And it's just bad things happen when you let the alcohol take control. So I think that this agreement is appropriate. What I'm going to do is sentence you to 5 days of jail. You can use the electronic monitor at your cost at $18 a day. And so I believe that it would be, you would get 1 day of good time. So you would need to pay $72 to pay for the monitor. You would need to contact Tessa Anderson to get that hooked up. I'm going to give you 45 days to figure that out of what days you want to be under house arrest on electronic monitor, okay?
That'd be available today.
You would need to go talk to Miss Anderson, but you have to prepay that $72.
Okay.
So she may have one today, she may not. She may say you need to come back in 4 days, you need to come back next week. But then you can arrange with her when you want to sit that time, okay?
Okay. And then is she in the
She
government?
go down to the Department of Health and Human Services and ask for her and she'll help you, okay?
Okay.
So I'm also going to assess $250 in court costs, fines, fees, DNA surcharge. You have that posted, so you're good to go. When you're on monitor, no alcohol, no drugs, no going anywhere without permission, except for work. If you have employment, you can go to work. You can go to AA, you can go to doctor's appointments and the grocery store one time, okay? So talk to Miss Anderson, she'll go over the rules more. If you even blow a .001 on the monitor, that is a violation. You will be terminated and you would need to sit the remaining time in jail, but no good time, no Huber, okay? And so talk to Miss Anderson. Again, you have 45 days to figure that out. The sooner the better would be good. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I also need your fingerprints and I need your DNA.
Oh, my DNA.
Yes.
Okay.
And so you'll get a form up here from Jackie. You'll go outside and go around the building to the new part of the jail intake. And then you will you'll buzz in and say, you need to provide your DNA, okay?
Okay.
All right. And so once you're done with that, you should be free to go. So I don't know if you want to do the Tessa first or Tessa after. Just don't forget your DNA, okay?
All right.
And 20 days to appeal.
Okay.
All right. Anything that I'm missing?
Not for me.
All right, thank you. Good luck. We will go on the record in the matter 24 CF 170, State of Wisconsin versus Jacob Jones. The state appears through District Attorney James Reneke in person. Mr. Jones appears in person with counsel and in custody with counsel Gabriel Pollock. We're set today for a preliminary hearing. It is within time limits. Mr. Reneke, please call your first witness.
Call Deputy Henry.
Deputy Henry, please come forward, raise your right hand, be sworn in, and then have a seat at the witness stand.
You swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may begin.
Deputy, would you please tell us your full name and spell your last name for the record?
Joshua Henry, Henry,
And how are you employed?
as a deputy sheriff with Burnett County,
Approximately how long have you been employed in law enforcement?
21 and a half years.
Have you had training and education to be a law enforcement officer?
Yes,
Does that include on-the-job training?
it does.
Directing your attention to July 20th of 2024, were you on duty?
I was.
Were you dispatched to a particular location on Johnson Street in the village of Siren?
I was.
What was the nature of that call?
To report an assault that had occurred around 3 a.m. that morning.
Okay, and did you go to that location?
I did.
And did you meet with the person that was identified later as victim number one?
I did.
And what did victim number one tell you happened that morning?
That she had returned home from her employment, was taking a shower, and that a subject by the name of Jacob Jones entered the apartment, entered the bathroom, and then began to assault her.
Okay, and did she give him permission to enter the apartment?
No,
Did she give him permission to enter the bathroom?
no,
And did she give her any permission to contact her, touch her, or assault her in any way?
she did not.
Okay. What exactly happened in terms of the assault?
Victim stated that Mr. Jones punched her twice through the shower curtain and then pulled the shower curtain back, punched her in the chin, and then applied his hands to her throat, and she passed out.
Did she tell you that he actually grabbed her around the neck
Yes,
and squeezed
yes,
and she couldn't breathe
correct.
and she passed out?
Yes.
After she came to, what, if anything, did she try to do next?
She tried to get away from him, so she pushed him. He then grabbed her and pushed her back, driving her head into the toilet, breaking the toilet seat.
So did she tell you that she was actually trying to leave the bathroom
Yes,
and he prevented her from doing that?
yes,
And then he shoved her head into the toilet?
yes.
What was he telling her, saying her at the time he was doing this?
I don't recall.
Okay. At some point, did he tell her that he was going to kill her?
Yes,
And did she believe him?
she said that she did believe that he was going to kill her.
Okay. At some point in time while she was on the ground, in other words, on the bathroom floor, was she telling Jacob to stop hurting her and that she has children?
She did.
And what, if anything, did he do in response to that a second time?
She stated that he again grabbed her around the neck and squeezed, and she lost consciousness.
Based on some of your experience and training, do you believe that if a subject grabs another subject around the neck and strangles them to the point where they lose consciousness, is that dangerous?
Very.
Is it potentially life-threatening?
It is.
After she came to a second time, what, if anything, did she do?
She was able to get out of the bathroom at that point, went to her bedroom, got up on her bed and curled up in a fetal type position.
What, if anything, did the defendant do at that point?
She stated that the defendant was standing over the top of her, possibly laying over the top of her and yelling at her that they needed to go back to the bathroom to go over her text messages on her phone.
Okay. What, if anything, did he do? Did he have any kind of a weapon on him or with him at that point?
The victim stated that the defendant pulled out a red box cutter type knife and didn't necessarily threaten her, but threatened to end his life if they couldn't come to a resolution.
Okay, but at least he was armed with a knife.
Yes.
That's a sharp instrument.
Yes.
And if used so, he could be a dangerous weapon.
Yes.
Shortly after that, was she able to get some clothes on and then leave the apartment?
She was.
What did she do next?
She ran to the neighbors and tried to make contact with them. They did not hear her, so she hid around their house.
Ultimately, was she able to contact the police?
Yes.
Did she tell you that they had previously been dating for some time?
Yes, and that the relationship had ended, I believe, around the 15th.
Okay. That'd be Monday, the 15th of July.
I believe so.
Yeah. And this all occurred on the 20th of July?
Correct.
Did she attempt to block communications or texts or phone numbers from him?
She said she did.
And did she say in between the 15th and the 20th that she had received approximately 100 texts and many phone calls through him?
Yes, but she could never identify the number that they were coming in from.
Okay. But she believed that he had tried to contact her that many times?
Yes.
Okay. Did law enforcement subsequently look for the defendant?
We did.
Did law enforcement go out to his residence? Or at least where he was staying?
On First Avenue?
Yes.
Yes.
Okay. And did you contact anybody from from that residence in First Avenue?
When we arrived, we did make contact with the owners.
Okay, and that's specifically First Avenue and Siren?
Correct.
Okay. And was one of the owners, his first name is Ryan?
Correct.
What did Ryan tell you?
He stated that the defendant had left approximately 10 minutes before our arrival and had packed up all his belongings.
Okay. And did he make any phone calls or phone contact with anybody?
Yes, he provided a phone number to a female subject that lived in the Lewis area, and he believes that's who picked him up.
Okay. And did Ryan tell you that one of his 9-year-old children heard Jacob tell somebody over the phone that he beat up the victim?
Objection, that's double hearsay.
Hearsay is allowable at prelims.
Not double hearsay unless you can do something else, so it is sustained.
Okay. Did Ryan ultimately hear the defendant saying something to the effect that he had warned the victim that something like this would happen?
Yes.
Okay. And when Ryan was, or I should say, when the defendant was ultimately arrested as part of his belongings, did he have a red iPhone in his possession?
At the time of the defendant's arrest?
Yes.
Yes.
Okay. All right. And this all took place within Burnett County, Wisconsin?
Not the arrest.
Or I should say the assault or the activities of the defendant via the victim?
Yes, that did occur in Burnett County.
Okay. And do you know what the defendant looks like?
I do.
And do you see him in court here today?
I do.
Could you tell the court where he's seated and what he's wearing?
He's seated at the defense table. He has a full beard, brown eyes, orange jumpsuit.
Let the record reflect that Deputy Henry has identified Mr. Jones.
That the state would rest.
All right. Any questions, Mr. Pollock?
Deputy Henry, I just kind of want to walk it back from the beginning. I think you testified on direct that the assault had allegedly occurred at around 3 that morning, right?
Correct.
What time were you dispatched?
It was around 9 a.m.
So several hours later.
Correct.
Mr. Jones was not at the location when you arrived.
Correct.
There was some discussion of potential assault, and it sounded very violent, but did the alleged victim ever indicate to you that she was able to stop Mr. Jones from assaulting her?
No.
So, okay. There was some discussion of potentially a broken toilet. Did you observe that?
I did.
Did you photograph it?
I did.
Could you describe what the toilet looked like when you arrived?
It was a white toilet with, I believe, a white seat, and the seat was knocked off towards the shower.
There was also some discussion of apparent messages from several numbers. Did you observe those?
I did not see the alleged messages, but she did play a voice recording that was made just before the time of the assault.
Can you describe that, please?
That was what she identified as the defendant calling and leaving the voicemail stating, "You better answer the phone or else."
Did the voice on the message ever identify itself?
The voice itself, no.
Okay. Was that the only message that you are aware of personally?
No.
Could you elaborate, please?
Last week, Monday, I received further communication from victim 1. She provided further voicemails, including the one I just spoke about, and then 2 other ones where she identified it as being the defendant crying. They were very hard to make out, other than they alleged that he screwed up.
Okay, and so was that, do you know, 4 or 5 messages total?
I only received 3 voicemails from her in total.
Okay, I see. Did the person calling use a name or identify themselves in any of those messages?
No.
I think there was some discussion of a knife or a box cutter. Do you remember that?
I do.
Do you know which it was?
The style is with it being recovered later, it was a red Milwaukee slide, but it also looks like a regular pocket knife. It's technically it would be labeled for sale as a box cutter knife.
And you said that was recovered later. How did that come about?
Through a search warrant.
Where was it located?
In the bags that were in the defendant's possession when he was arrested in Polk County.
Just reviewing my notes, there's some discussion that victim 1 described having or Mr. Jones placing his hands around her neck and squeezing. Did you observe red marks on her neck?
She had light red marks. I did not observe any petechia at the time. And then I have received further injury photographs from the victim that were taken several days later where bruising was very apparent.
So I am not familiar with the term petechia. Could you explain that to me, please?
It's broken capillaries. It shows up as red dots. Generally, it can be on the skin or in the eyes, and it's common in strangulation cases.
Did the person identified as victim 1 ever indicate to you whether the apartment doors were locked?
She had thought when she returned home through the front door that it was locked, but her children may have left the other 2 doors unlocked that she was unaware of.
She wasn't sure?
Yes.
Those are the only questions I have for today.
Have no redirect or follow-up, assuming no defense witnesses would ask for a bind over.
All right, thank you. You may step down. Thank you. Any witnesses, Mr. Pollock?
No, Your Honor.
All right, thank you. Based upon the testimony of Deputy Henry, I do find that there is probable cause to believe a felony was probably committed, and it was probably committed by Mr. Jones. So the court does find probable cause and will bind the matter over. Information, Mr. Reneke?
It is electronically being signed and filed as we speak, and it does mirror the complaint.
Proceed with arraignment or set for another date?
One moment to discuss with Mr. Jones, please.
Yes.
We are comfortable proceeding to arraignment, Judge.
He understands charges and maximum penalties.
Assuming information mirrors the criminal complaint, which I have gone through with him, and I have no reason to doubt that, then yes, he does. We are comfortable waiving any reading and entering not guilty pleas.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial, and you would be entitled to a speedy trial should you request one. Are you asking for a status?
I am, Your Honor. I think there is one open matter that I represent Mr. Jones on, and potentially a third matter that I need to be appointed on, if it would be possible to have a joint status.
Let me.
What he's talking about, Your Honor, is 22 CF 69. There's a sentencing after revocation. He was recently placed on probation, which was revoked. And then there's a
Set for September 30th.
And then there's also a OWI third. It's, I believe, 24 CT, and I'm not sure what the final two numbers are. I think 53.
Okay, I can get that up. Or CT33.
Yes, and I anticipate being appointed on the sentencing after. I have not been appointed yet.
All right, Mr. Jones, if you wish to have Mr. Pollock represent you on the sentencing after revocation, you need to reapply, I'm sure.
I think his application is probably still good. They're good for 90 days, and this is July 20th, so we're probably still good.
You just need to go through the process to get yourself.
I
on
think
the
so.
case.
Yep.
And you shouldn't have an issue.
I don't think so.
All right, that is scheduled for September 30th at 1. So what would you like to do with the two other cases?
If we could just have a status conference, I guess I would prefer sometime before the 30th.
Well, that probably won't happen. A status before the 30th?
Well, Your Honor, I don't know if this is going to be a situation where things are handled piecemeal or globally.
Probably piecemeal, since we're dealing with an old case and two new open cases that have to go through a whole lot of things, including getting discovery.
In that case, Your Honor, if you just want to set statuses on the 30th, I think we can take it up then.
All right, we'll do status on September 30th at 1. Statuses with 24 CT33 as well as 24 CF. Wait, which is the other open?
22.
Yeah.
22
CF 69 is currently set for plea and sentencing. Status in 24 CT33 and 24 CF 170 for the same dates and time, September 30th at 1. All right, and it must be Mr. Renicky. Anything else from either side?
No, Your Honor.
All right, then we are adjourned. Thank you.
Court calls the case of People versus Tamara Motley.
The people. Good morning, Your Honor. Eric Perry on behalf of Ms. Motley, P79467.
Your name?
Tamara Motley.
Your Honor, this is the date and time set for a final settlement conference. I do believe the defendant is going to be taking advantage of a plea offer. Plea to added count 2, operating while visibly impaired first offense, contrary to MCL 257-6253A, 93-day misdemeanor, $300 fine, the various license sanctions from the Secretary of State. It is due for dismissal of count 1 operating while intoxicated.
Is that a correct statement?
Yes, it is, Your Honor.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth shall be God?
Yes,
State your name for the record again.
Tamara Motley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to an added count 2 of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days jail, up to a $300 fine plus court costs. Court could order rehabilitative services or community services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yeah.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yeah.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
April 29, 2023, at the location of 477 Washtenaw Avenue, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What do you have and how much?
I just had like a few drinks at a bar. My best friend had graduated from U of M, and it was the day before her graduation.
All right. Were you stopped by the police or was there an accident?
They stopped me
Why'd they stop you?
because I was in the drive-thru at McDonald's waiting for them to open.
Waiting for what?
Waiting for them to open in the drive-thru.
All right. You're not disputing the right of the police to stop you, are you?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital?
No.
Were you taken to the police station?
Yes.
Was there a breath test?
Yes.
And what were the results?
I think it was over 8.89.
Was it a .08?
Yeah.
That's correct, Your Honor.
Yes, so stipulated.
And you're not disputing those breath test results, are you?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
So satisfied.
Defense satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
September 11th at 9 a.m.
September 11, 2024, 9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you.
Your Honor. Thank you.
Court calls the case People versus Jesus Bustamante Cruz.
Raise your right hand. Do you solemnly swear to or affirm that you will interpret it accurately, completely, and impartially using your best skill and judgment and to translate from English into Spanish and from Spanish into English in the matter now before the court? So help you God.
I do.
Lower your hand.
All right, state your name, sir.
Kamal Hanawi.
All right, thank you. All right.
Ashley Lonnie for the people.
Good morning, Rebecca Chiappo on behalf of Mr. Bustamante Cruz.
Assistant Public Defender Natalie Pate with on behalf of Mr. Bustamante Cruz in the case ending in 0708.
All right, and what are we doing on these?
Your Honor, today is the date and time set for final settlement conferences in both matters. At this time, the people are unable to proceed.
We would ask for a dismissal, Your Honor.
That's correct, Your Honor.
People being unable to proceed in both matters, these cases are dismissed. That's without prejudice.
Yeah.
Thank you, Your Honor.
All right, thank you.
Judge.
Court calls the case People versus Linda Donald.
Ashley Lonnie for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, we have executed a jury waiver in this case.
Yes, it is. Ma'am, good morning.
Good morning.
Your name?
Linda Donald.
All right. You signed this waiver of trial by jury form?
I did.
All right. You understand that you have an absolute and constitutional right to have the matter tried before a jury?
I do.
All right. You understand that by signing this form, you're waiving that right and it'd be tried before the court without a jury present?
And that would be before you, sir?
Yes, ma'am.
Okay.
I'm okay with
I don't know, for better or for worse.
that.
All right, people also waive their right.
Yes, Your Honor.
Based upon the statement of counsel and defendant, court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for.
September 25th at 9 a.m.
That is the day I come back from vacation, Your Honor. We could do I can do the 26th, I can do the 27th. Just can't do the 20. Okay, I know the 26th is impossible. It's a Thursday. But I can do that Friday.
We could do, October, or I'm sorry, September 30th at 9 a.m.
That's a Monday.
Yes.
Let me see what I got. That's fine. That would work.
Non-jury trial, October or September 30th. September 30th, 2024, 9 a.m.
Thank you, Your Honor.
Thank you.
Your Honor. Thank you.
Okay.
Court does call the case People versus Antoine Pitts.
Dr. Lonnie for the people.
Sherilyn Foster Tucker on behalf of Antoine Pitts.
Antoine Pitts. Thank you.
Your Honor, today is the date time set for a final settlement conference. At this point, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Martin Wise.
Dr. Lonnie for the people.
David I. Goldstein appearing on behalf of the defendant. Mr. Wise, when you get to the podium, please state your name.
Martin Michael Wise.
Your Honor, may we approach?
Briefly, yes. All right, Rick, go ahead.
Thank you so much for the bench conference. The people have received a warrant request, not for this defendant, but related to the matters at hand in this case, that the people would prefer to review before this case proceeds to trial, and are respectfully requesting an adjournment to the next final settlement conference.
Your Honor, in general, I have no objection, as I indicated at the bench. Ms. Lundy and I did discuss it before we approached the bench. The only thing I'm going to ask, Your Honor, is this is now the second, well, let me back up. This case, not this case, a case with the same charges was originally set for trial. Neither of the victims showed up, so the entire case was dismissed. It's now been reauthorized. One of them is here, so I'm not objecting to that one, but the other one is not. So now this is the second time on a critical date that that individual has not shown up. So I'm asking that that charge be dismissed.
I think under the circumstances of the case, and I recalled the first case when we were going through it, and I'm not sure who can testify as to whether or not that would lead to potential be sufficient evidence as to the other charges of A and B regarding the person that's not here. So it would be the court's practice that if I'm going to adjourn this, I'm going to adjourn the whole thing. So I'll deny that request. I'll adjourn jury final settlement conference October 18th, 2024 at 9 a.m. Jury selection, if necessary, once again, October 21st, 2024, 8:30. All of those are in person.
Thank you, Your Honor.
Thank you.
Your Honor, I can tell you now, the 18th date is not a problem. The 21st date might be. We can deal with it on the 18th.
Very good.
Okay.
All right. Thank you.
Thank you.
Court does call the case of the People versus Eric Mays.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Eric Mays, who is approaching. Please state your name for the record, sir.
Eric Mays. All right. What are we doing?
Thank you, Your Honor. Mr. Mays is going to be waiving his right to a jury trial and respectfully requesting that Your Honor set this for a bench trial.
And people also waive their right, Your Honor.
You signed that form, Mr. Mays? Yes. You understand you have an absolute constitutional right to have the matter tried before a jury? Yes. Okay. And you understand that by signing this form, you're waiving that right to be tried before this court without a jury present?
Yes, I do, Your Honor.
All right. Based on the statement of counsel, and defendant court will consent to have the matter tried before without a jury. Non-jury trial will be set for
September 25th at 9 a.m. Or you find
well, we might have, before we set the date, we might have to deal with his bond violation.
Your Honor, if I may.
Yes.
His bond violation is in a 14B case. It is not in this matter or the other 14A1 matter.
I was wondering about that myself because I did not have him on the tech.
Yes, that was for a 14B matter. His other matter in front of your honor is scheduled for sentencing on August 28th.
Got it.
And we do expect sentencing to resolve this case.
Wonderful. All right. Then I'll set it for the September 25th, 2024. 9 a.m. All right. Thank you.
Thank you, Your Honor.
Bond in this case will continue. Court calls the case of the people versus Kenneth Hoffman.
Special law for the people.
Morning, Your Honor. Spencer Clayton appearing on behalf of Mr. Hoffman, who approaches, will be standing to my right, number 77302. Mr. Hoffman, can you state your name for the record, please, sir?
Kenneth Hoffman.
Thank you. All right. What are we doing?
There is a plea offer available to the defendant that I understand is going to be taking advantage of. Upon a plea of guilty or no contest to counts 1, malicious destruction of property, and counts 3, disturbing the peace, count 2, assault and battery will be dismissed. The people will further agree to sentencing under the prosecutor's preferred protocol.
Is that a correct statement?
It is, Judge.
Has he signed an advice of rights?
I don't believe so, Judge. I thought there was one in the file, but
He needs an advice of rights form.
we did go over them.
Raise your right hand, please. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
State your name for the record, please.
Hoffman.
All right. So it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes, sir. Yes, Your Honor.
All right. The first charge is the charge of attempted malicious destruction of personal property, 200 to 1,000. That is, as indicated, a misdemeanor punishable by up to 6 months incarceration and a $1,000 fine plus court costs. Do you understand that? Actually, that's not right. Is it? Oh, it's the attempt. Got it. 6 months incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. And also to count 3, disturbing the peace. That's a misdemeanor punishable by up to 90 days and $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty
Yes, Your Honor.
to the charge of attempted malicious destruction of property, 200 to 1,000. How do you plead?
Guilty.
To the charge of disturbing the peace. How do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form today. Is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Understand that? I understand. Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir. Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
All right. And because you believe that you're guilty of these charges?
Yes, Your Honor.
February 7th, 2024, at the location of 5808 West Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan. What did you do that makes you think that you're guilty?
If I may assist him, Judge? Sir, on that date and location, did you have contact with an individual that you had just had a minor fender bender with?
Yes.
And did you exit your vehicle and approach his vehicle?
Yes.
And that individual, Aiden Becker, did you attempt to willfully and maliciously destroy his property by banging on his headlights of this vehicle?
Yes.
And at that time, did you excite or create a disturbance to the community?
Yes.
Thank you. I believe that satisfies, Judge.
All right. And there was no damage to the headlights?
No, Judge, it was an attempted, so nothing was actually damaged.
Actually damaged, but you attempted to do so. Is that correct? All right.
Like smearing from like hands, like this, things like that. No actual
Damage. Okay. All right, counsel, have I complied with the court?
You were satisfied.
Satisfied as well, Judge.
Court will accept the defendant's pleas of guilty to counts 1 and 3. Count 2 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be September 11th, 2024.
Your Honor, sorry, I think I have a jury trial that day. I do, Judge. I don't know if there could be another date possible.
It's the 25th at 1 p.m.
September 25th.
Yes.
September 25th, 1 p.m.
That works.
Bond with its conditions will continue. Stop at probation on your way out. Court does call the case of the people versus Stephen Richmond.
Ashley Lonnie for the people.
Good morning again, Your Honor. Spencer Clayton appearing on behalf of Mr. Richmond, who approaches, will be standing to my right, P number 77302.
All right. Your name, sir?
Stephen Richmond.
All right, what are we doing?
Your Honor, there's a plea offer available to the defendant to resolve this matter, and I believe he's going to take advantage of it. Upon plea of guilty or in context to an added count 2 of malicious destruction of property less than $200, 90-day misdemeanor, contrary to 750-377A1D, malicious destruction of property 200 to 1,000, currently charged in count 1 will be dismissed, along with an agreement to pay restitution in the amount of $445.56.
That's correct, Judge.
And that's what he wishes to do.
Yes, Your Honor.
May I have, Rick, will you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
Stephen Richmond.
Put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is destroyed or otherwise injured. If that's greater than $500, that would become the maximum fine. Do you understand that?
I do.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights? Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
I agree.
You understand you're giving up your right to appeal of right?
Correct.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of August 27, 2023, at the location of 7,000 West Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding the property of a Rodney Smith that makes you think that you're guilty?
I scratched the vehicle. I scratched the vehicle.
Okay. You did that intentionally?
Yes.
Okay, you were in a parking lot?
Correct, Judge.
Yeah.
Okay. Why'd you do that? I mean, I'm just asking because you're in a parking lot, vehicles get scratched.
I was walking into the store and he drove his car into me, pinned me up against the car, backed up. I went forward and he did it again. And I went into the store and went on my way, came back and made a mistake and went back to his car because I was looking for some sort of acknowledgement of what happened. And I just shouldn't have done it.
And you scratched the
I scratched the car.
That was willful and malicious.
Yes.
Thank you.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Satisfied as well, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be September 25th, 2024, 1 p.m. We'll continue with its conditions. Stop down at probation. Start the process. Thank you.
Thank you, Your Honor.
Court calls case People versus Anissa Drummer.
Carolyn Foster Tucker on behalf of Vanessa Drummer.
And Mr. Drummer.
Thank you.
Madam please dismiss the final settlement conference at this time. People are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed without prejudice.
Thank you, Your Honor.
Thank you. Courthouse case, People versus Devontae Smith.
People.
Carolyn Foster Tucker on behalf of Devontae Smith.
Your name?
Devontae Smith.
All right, what are we doing?
Your Honor, set for a final settlement conference. There is a plea offer available at 4A, but people at this time are unable to proceed.
Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you. Courthouse case, People versus Richard Giroux.
Good morning, Your Honor. Jeff on behalf of Richard Giroux. Mr. Giroux, please state your name for the record once you reach the podium.
Richard Giroux. Thank you.
Today is the date for the final settlement conference. And I'm just pulling up my notes to see if we're going to be able to proceed on this case or not. Your Honor, it said we are unable to proceed at this time.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you.
Courthouse case, People versus Jason Heron.
Assistant Public Defender Natalie Fate, on behalf of Mr. Heron, who is approaching. Please state your name for the record, sir.
Jason Heron.
Today's date is the final settlement conference. I understand that the defendant is going to be pleading as charged to domestic violence with sentencing under 7694A with the consent of the prosecutor. And I understand this will be a no contest plea also with consent of the prosecutor.
That is correct, Your Honor, and I have discussed that with my client. He would like to accept that offer today.
Basis and no contest, please.
Potential civil liability, Your Honor.
Raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
State your name again for the record, please.
Jason Lamont here.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence. Is that correct?
Correct.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. Two things I need to make sure that you understand is that it first of all means that you're not contesting or no longer wanting to dispute this matter or this case. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you pled guilty to this charge. You understand that?
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest. No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Right.
You signed an advice of rights form today, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
All right. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
Sir.
Doing this voluntarily
Yes, sir.
and of your own free will?
Correct.
Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 245512. Any objection to the court reviewing that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the
People are satisfied.
Yes, Your Honor.
court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 9, 2020. Sorry, 1 p.m. All right. We'll continue with its conditions. Thank you.
Thank you, Your Honor.
Court calls the case People versus Christina Willman.
Assistant Public Defender Natalie Tate with and on behalf of Miss Willman, who is approaching. Please state your name for the record, ma'am.
Christina Willman.
Thank you, Your Honor. I have discussed this matter with Miss Lundy. We are respectfully requesting to adjourn the final settlement conference in this case.
Why? Basis.
Ms. Lundy had we both have some additional investigation to do regarding some paperwork I sent over to Ms. Lundy about a potential resolution of this case.
That's correct, Your Honor. The nature of the intoxicating controlled substances in this case, there's an allegation it may have been a therapeutic amount. So we could do some additional investigation into that.
Adjourn jury final settlement conference, October 18th, 2024 at 9 a.m. Jury selection if necessary, October 21st, 2024, 9 a.m. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Bond will continue with its conditions. Court does call the case, People versus Nicholas Seuss.
Good morning, Your Honor. Robert Hinojosa here on behalf of Mr. Seuss, who's present to my right.
Nicholas Seuss. Thank you.
Your Honor, may myself, counsel, and Mr. Allen approach?
You may. All right, record should reflect we've had a bench conference in this case. I will adjourn the jury final settlement conference and jury selection in this matter. Jury final settlement conference, October 18th, 2024 at 9 a.m. Jury selection, October 21st, 2024 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Heather Berg.
David Shannon, you have Heather Burton.
In your name, ma'am?
Heather Burton.
All right, go ahead, Mr. Chair.
It's the time they set for sentencing, Your Honor. I have no problem with the recommendations at all, and I think they're excellent and apply to this situation. We do have one small request.
Yes. Oh, I like what Mr. Pilar wrote, but no, go ahead. I'm with you.
So, Heather works in the corner. She starts at 6 a.m. in the morning and she gets up at 4 a.m. in the morning. She has been setting her alarm at 9 o'clock at night in order to wake up, in order to test and to go back to sleep, to get up in the morning to go to work. We're asking the court if she could move her testing time, the last testing time, to 8 p.m. from 9 p.m. so she doesn't have to wake herself up to test. That is our.
Have you addressed that with community corrections?
I actually mentioned it to Teresa, and I'm asking you now if we need to address it.
I typically, and Ms. Pilar, you can correct me if I'm wrong, if somebody addresses that issue to community corrections, they'll make an adjustment.
Yes, Your Honor. Typically, if they're on probation too, they'll reach out to me to make sure that I have no objections to the change in time, but they will also adjust other times.
Other times will get adjusted. So I don't need to do anything, but thanks, Mr. Shan, for trying to force me to do something.
Good start to a Wednesday.
I don't know, man. All right.
Other than that.
Wow. You're just Mr. Optimist. Ma'am, is there anything you'd like to tell the court before I do impose sentence?
I just want to say that I am very sorry for what I did. I'm pretty ashamed of it, and I will never be correct. Ever.
Very good. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, probation recommends completion of alcohol highway safety class and continuation of the sober link for 1 month, as the ASA found no substance abuse treatment or no need for substance abuse treatment. Court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with completion of terms. Therefore, it is the sentence of the court. I would place you on 6 months probation. You would pay $855 fines and costs, $100 prosecution recovery cost, $100 police agency recovery cost, $180 probation oversight fees. When can you get that paid?
How much time are you gonna need to pay everything? No, you can work with probation, get on a monthly.
Yeah, can I do that?
Yeah.
Do you have anything today?
Yes.
Okay.
Yes.
How much can you?
Okay, I'll ask. 500? Thank you. 500 today. And then the balance is determined as payment plan as arranged by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an alcohol highway safety education class within the next 60 days. You're to provide proof of the victim's impact panel attendance to probation that has already been completed. I'll continue to sober link for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. Okay, thank you. Good luck to you, man.
Great rest of your day.
Yes, sir. Court does call the case of the people versus Amanda Ray Reese. She's not in, no?
You're right, you have a potential suggestion. She has.
A potential suggestion. Okay, go ahead.
She has a pretrial next Wednesday. She did show up for her last court date with you, which was on the 4th. That was adjourned until 18th. Obviously, I'm trying to work with her to accumulate and get all these cases taken care of. She also has a matter at 14B in front of you.
You said she showed up on the 4th?
Yes, sir. I think she might have showed up on Zoom.
And Teresa Claire on behalf of probation. Your Honor, I do know that she did appear for that pretrial on her pending case.
Oh.
However, Ms. Reese also has bench warrants out on the end in the 14B case that he is referencing has a bench warrant, and they're indicating $50 an hour cashier. And she also has a pending felony out of Detroit. So given it's present today, probation is required.
And counsel, I would note that her initial arraignment was adjourned because she didn't show up, and then they adjourned it, looks like from the magistrate's notes, a second time. And then since the time of her, well, not since the time of her plea, but I've had to issue 1, 2, 3 previous bench warrants against this defendant. She clears them and then doesn't show up.
Okay, she did interview with probation. There was a recommendation for today, so she did follow some of what she was supposed to do. So I think she will at some point. Potentially, I'd ask for a 48-hour bench warrant if we can contact the court at that time.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give it 10% privilege. Given all of the circumstances, that warrant will issue immediately. Court calls case People versus Tamara Motley.
Good morning, Your Honor. Eric Rooney, on behalf of Ms. Motley, P79467.
Motley, can you state your name, please?
Tamara Motley.
Counsel, have you read the alcohol screening and assessment?
I have, Your Honor. I reviewed it with my client. There's no additions, corrections, or deletions, just brief allocution, Your Honor.
All right, go ahead.
Thank you, Your Honor. Your Honor, Miss Motley, this is her first offense for an OWI. She has 0 criminal history. She was cooperative with the authorities as well as with your staff. She's been on bond on or about since April 29th of 2023 with no issues. She's from Saginaw, Michigan, Your Honor. She currently lives in Big Rapids, which is why we're on Zoom now, Your Honor. We appreciate that, you accommodating that for our. I'm sorry, Your Honor, I'm getting a lot of background noise. Sorry about that. She lives in Big Rapids because she's going to school there, Your Honor. She recently received her bachelor's degree. She's pursuing her master's degree in business administration. She hopes someday to become a CEO for a Fortune 500. She also works part-time, Your Honor, at a local bank in Big Rapids. Her money's limited. Again, she has no criminal history, no bond issues. She's been in bond, Your Honor, for about a year and a half now. I think the recommendation is a 6-month probation term with fines and costs and some other factors or other obligations. I'd ask the court to consider adopting that in part, but giving her some time to pay the fines and costs because her money is limited while she's going to school. And I also asked the court if they'd consider a review at the halfway point. Thank you, Your Honor.
Let me just address one thing. A review at the halfway point, she can always petition to do that at the halfway point. Ms. Motley, if you'll unmute, is there anything you'd like to tell the court before I impose sentence?
It was a big mistake. I apologize for my actions, and I'm just trying to focus on my career from this point forward.
Oh, very good. The court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Probation is recommending completion of an alcohol highway safety class as the alcohol screening and assessment does not find a need of substance abuse treatment. Court will follow the recommendation of probation of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of completion of her terms. Therefore, it is the sentence of the court. I will place you on probation for a period of 6 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $180 conviction oversight fees. When can you get that paid?
Over the course of 2 weeks, I can get that paid. I can pay half.
So you can have it all paid in 2 weeks?
Yep.
Your Honor, can we
Okay,
add
why
for 30 days?
why don't I-
Your Honor,
What?
I'm sorry.
I'm gonna give you to the end of the month to get it done. Okay?
All right. Thank you. Really appreciate it.
Thank you, Your Honor.
Okay, by September 30th, 2024. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You're to complete the alcohol highway safety class. You're to do that within the next 60 days. Provide proof of the victim's impact panel attendance to probation. Other than 93 days in jail, that is suspended. Thank you.
Thank you, Your Honor.
Thank
Court calls the case, People versus Gerald Anderson. Yes, thank you.
Mr. Anderson, who is present via Zoom. Sir, can you please unmute and state your full name for the record?
You need to unmute, Mr. Anderson. Got it.
Can you hear me?
Yes, we can hear you. State your name.
Gerald Curtis Anderson.
Thank you, sir.
Thank you, Your Honor. Today is the date and time set for sentencing. I have reviewed the PSIR with Mr. Anderson. We have no material changes, additions, or corrections, and would ask the court to adopt probation's recommendation. As to the finances, Mr. Anderson is respectfully requesting a $200 per month payment plan.
Sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. I appreciate the opportunity to be clean and sober. It's been a while since I drank anything. It'll be a year next month. And I'm very sorry about my bad behavior in the past.
Yeah. Congratulations on your year of sobriety. That's beautiful.
It feels different. It's been so long, you know?
Yep.
I thought I did too.
I'm sorry?
I got so used to living that way. It was just like going to work, you know. I did both. I worked and I drank, you know. That's all I lived for.
Sent to the court, $555 fines and court costs, $250 restitution to Meyer payable through the court. So you said you could do $200 per month?
At least.
Okay, starting when?
Right under 3 weeks, Your Honor.
Pardon?
Right under 3 weeks from now, like maybe 2.5 weeks.
Okay, so you can start it up. Okay, here's what I'll do. You have payment plans starting September 30th. Okay. But that first payment has to be $250 to get that restitution paid.
Sounds good.
Okay, and then the balance at $200 per month on the 30th of each month. Okay?
Awesome.
All right. And then 93 days in jail that is suspended. All right?
God bless.
Yes, and to you, sir. And Good luck. All right. And continued sobriety to you.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. You can log off now.
Court calls the case People versus Chantel Coca.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Coquette.
Oh, coquette.
I think it's Coquette.
You think it's coquette? You don't know, do you?
I would have bet on it.
Hold on a second. We'll find out in a moment. Ma'am, what is your name?
Chantel Coco.
Good job, Kearney. You weren't even in the ballpark. Sorry, ma'am, sorry about butchering your name, but go ahead, Miss Kearney. What do you?
Coco is better.
Yes, it is. That's right, because you told me the last time the T was silent.
Yep.
She did. I now recall. Yep. Okay, go ahead.
Your Honor, today is the date and time separate. Saying, review the pre-sentence report, and we don't have any material changes for completions. We ask that you adopt probation.
All right. And ma'am, is there anything you'd like to say before I impose sentence?
I'm very sorry for what I did, and I will definitely not be doing it again.
To sentence of the court, I will place you on the 4 months prosecutor deferred sentence program. You're to pay $555 fines and court costs, $120 probation oversight fees. When can you pay that?
As soon as I'm able to. I have the money for it. Yep. So I can do it. I can do it today.
Okay, well, why don't we, let's say today's the 11th. Get it paid by September 16th. This Monday coming up, okay?
All right.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. You are not to go to any Walmart store in the state of Michigan. I'll set a review hearing that is to be held January 15, 2025 at 9 a.m. I'll order 365 days in jail. That is suspended. All right. Thank you, ma'am. You have a great day.
Thank you. You too.
Let's call the case. People versus Jermaine Phillips.
Natalie Page with on behalf of Mr. Phillips, who should be present via Zoom.
He is not here.
I did talk to him yesterday. I did expect him to be here. Would Your Honor consider texting that? So I could text him.
Your folks need to be here on time.
I understand, Your Honor.
I'll pass it. We'll get called up in the next block. Here is definitely going to be a benchmark.
Thank you, Your Honor.
Court calls the case People versus Thomas Rastall.
Take your name for the record, sir.
Thank you, sir. All right, go ahead.
Thank you, Your Honor. State the date and time set for sentencing. We have no material change for arresting. Recommendation. Mr. Rassel is respectfully requesting a payment plan for the fines and costs as arranged by probation.
Sir, is there anything you want to say before I impose sentence? All right. Sentence of the court, place you on 6 months prosecuted deferred sentence. You're to pay $480 fines and court costs, $180 probation oversight fees. How are you going to get that paid, sir?
It's typical on SSI. I've been urging. I just couldn't find the bid. Sorry.
Here's what we'll do. Talk to probation. When you find the paperwork, get to probation. And I'll just at this point set it up as a payment plan as arranged by probation. All right, we'll figure it out. No use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the CCOP program. No going to any Walmart store in the state of Michigan. I'll set a review hearing that's to be held March 12th, 2025 at 9 a.m. I'll order 93 days in jail. That is suspended. Thank you, sir.
Thank you, Your Honor.
Court calls the case People versus Ronald Woodward or Woodard.
Good morning. On behalf of Mr. Woodard. Mr. Woodard, can you unmute and state your name for the record, please?
Ronald Woodard.
Need a camera.
I'm trying to get the camera on, Jan. I'm sorry.
Oh, he got it. But now he's muted. All right.
Okay.
Your Honor, today's the date and time set for sentencing. Mr. Woodard has been accepted in the recovery court. Oh,
That's right. I saw him.
okay.
There he is.
So we do ask that you adopt probation and completion and transfer this case to 14.
All right, Mr. Woodard, is there anything you want to say before I impose sentence?
Yes, Jan, I'm sorry for, getting in trouble. I just got out the hospital, Your Honor, for cardiac arrest. But I do apologize for my actions.
Okay. All right. Sent to the court, 24 months probation with supervision through the 14D recovery court. You're to pay $1,055 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs. You're to comply with all terms and conditions as set forth by 14B recovery court. I will order 365 days in jail. Credit 1 balance is suspended. All right. Thank you, sir. Good luck to you.
Thank you, Your Honor.
Court does call the case. People versus Ladante. No.
Teresa Claire on behalf of probation. Your Honor, Mr. Knowles was scheduled before the court for a violation of probation. He did fix all conditions except for the financials. I would leave it up to the court how they would like to proceed given these facts.
Is he's done everything. Is he aware? He's aware of that outstanding balance, is he not?
He should be, Your Honor. And he recently made a payment, well, it was a couple months ago, but on July 24th. So I do know he's aware of what the balance is. I have no explanation why he's not.
He's done everything. Why don't I just do this? Let me just adjourn this to the November 27th date. Let's see if we can just get the payment in and do that.
Your Honor,
Are we out of time?
I'm the probation term is maxed. However, is it possible to discharge him from probation?
Yes. What I'll do is well, let's do it this way then. I'm sorry. Yeah, you are indicating that we're max. So I'll discharge him from probation with some improvement. I'll order the defendant pay the $346 outstanding balance, that he's to pay that by November 26th.
Well, Your Honor, his total balance is $1,046. So he owes a very large.
I see what you're saying.
Yeah, so would the court want to have him sent to collections, or would the court like to bump it out for the November date and I can be in contact with him and tell him?
What I'm looking to do is you'd be in contact with him and do that. So what I'll do is I'll follow what you said, the $346, which is really the portion of his outstanding balance. I'll indicate he's to pay that by September 30th, 2024. The balance by November 15th. However he wants to do that. And then I'll set a review hearing to verify payment for 27, 2024.
Perfect.
I get what you're doing. All right. Court calls the case of the people versus Guadalupe Cervantes.
Probation, Your Honor, this is about a scheduled before the court today. I know hearing prosecution for the sentence. She did complete all terms ordered by the court and did pay for probation recommending that the court dismiss the case for
Hearing no objection, so ordered. Court does call the case of people versus Emily Roush.
Teresa Claire on behalf of probation, Your Honor, second, she did complete all terms ordered by the court and I did waive her appearance. Probation is recommending that the court dismiss the case pursuant to the prosecution.
Hearing no objection, so ordered. That's it till 10?
Yep.
Really? Really?
No, I haven't.
Good job, Ed. All right, court stands in recess. Court calls the case People versus Susan Hall.
Thank you, Your Honor. Today is the date and time set for sentencing. I have reviewed the PSIR with Ms. Hall. We have no changes or corrections. We would ask the court to adopt probation recommendation.
Ms. Hall, is there anything you'd like to say before I impose that?
Thank you.
Statutory fees of $125, 58 days in jail, credit 58 served. You're all set. Thank you.
Thank you, Your Honor.
Court calls the case People versus Jermaine Phillips.
Assistant Public Defender, we take on behalf of both with Mr. Phillips.
He's not here. I don't have him on.
For the record, Your Honor, I did send him a text, he did not respond. I did have a conversation with him yesterday, fully expected him to be attendance today. For the record, I requested adjournment.
Bench warrant will issue for defendant's failure to appear, bond set 5,000, give a 10% privilege on it. That warrant will issue immediately. There haven't been previous warrant.
Thank you, Your Honor.
Court calls case People versus Casey Atkins. That was my name.
Yep.
Pardon?
386.
Heard that. 386? Excuse me, your name? Just wondering how it. They're giving me everything in contribution except that. I don't have an arrow there. Well, no, I got one. Sorry. The last one's over. Okay, Ms. Atkins, you're here on a show cause. You owe $386. Pardon?
Fine.
Right, you had pled back in 2022 to double parking.
Is that for 14A court?
Pardon?
Is that a 14A court? Because I saw a magistrate and was supposed to come and see you on the 21st. I thought it was because I thought I was going to be out. So I said that I could pay it on the 26th. However, you denied my bond. And so I was not able to get out and pay this. I believe that is what this is about.
Your bond was denied. You weren't on the felony cases that you have.
I'm sorry.
Your bond was denied on the felonies that you have.
On the bond violation that I have. I haven't.
Yes.
But I saw the magistrate and told her that I would have been able to pay it. So I was supposed to pay it by the 26th, but I did not get out.
Well, I don't have a note of that. She PR'd you on this case,
Right.
Set it for today.
Right. Can I get out today? And then I can pay it. I'll probably be in front of you.
Okay, Ms. Atkins, doesn't work that way.
I'll probably be in front of you in a couple weeks for the hospital.
Right, but you've got to follow the rules. I mean, you're in
Yeah.
on the probation violation. You've got this.
Yeah.
So the short answer to your question, and I don't have everything in front of me. Can you get out today? No.
Okay.
All right. So what I'll do on this case is I'll just adjourn this out to give me the end of October. Because I don't know what's going to happen with our fellows.
October 23rd at 9 a.m. Okay.
Adjourn this to October 23rd, 2024, 9 a.m. Thank you. Question to ask. Can I get out today? Courthouse case view versus Genevieve Donald.
And on behalf of the Donald, Your Honor, Ms. Polera did tell me that Ms. Donald called the probation officer this morning, and the most recent news was that she stated she was in an Uber on the way here.
I did have a phone conversation with her yesterday, and she did say she would be here.
And Your Honor, that is true. She was just in communication, with Lynn in my office, crying that she was late and even told her to get here, and she said that she was sitting at the perfect time.
Presuming you want me to pass this case to Ms. Pate and have your client not show up again?
Your Honor, I truly believe this client will show up, but yes,
You believe that about the last one too.
I did too.
So your track record isn't good. You realize if this one shows up, you're at 50%. That's it.
That's true. I've been too optimistic today.
Always too optimistic, but the longer you practice, then you'll get reality. Reality will set in. I'll pass it. She's not doing anything.
Almost there.
Are you gonna ask me for a difference too? Yeah, no comment. I don't know what I'm gonna do. Court calls the case, People versus Keith Malone. And I think he's here. Yes, he's in there.
Thank you, on behalf of Mr. Malone. Sir, can you please state your name for the record?
Keith Darrell Malone. Thank you, sir.
Please clear on behalf of probation. Your Honor, Mr. Malone is before the court for review hearing on a prosecutor deferred sentence. Mr. Malone, has a balance of only $90, left. I know that Mr. Malone had some medical, he was in the hospital, with some surgeries. It was having difficulty with getting him paid. He recently made a payment, to the court last week and still has the balance of $90. He indicated to me that he would have that balance paid by next month if the court will. Probation is recommending an extension of that prosecutor deferred sentence for a period of 1 month, so he can pay that balance. He indicated he can pay it on October 3rd when he gets his next check. And probation would also ask that the review be set for October 9th, 2024.
So he's done everything except that.
He's done everything except that.
Ms. Pate.
Thank you, Your Honor. I have reviewed the recommendation with Mr. Malone. He does understand that he still has a financial obligation of $90. He has had some medical issues that makes that difficult. We would leave it to the court's discretion.
Hello, Judge Simpson.
Hello, sir.
Let's go, Tarpons.
Chairman, yeah. Okay. So, and I see you in that Michigan, and we both lost this past weekend.
I know, born and raised in Ann Arbor, but no loss to me because I have 25 months clean and sober. I started a program called Turn Up and Recovery, where I'm at now, that I'm doing. And thanks to the court, thanks to myself to change myself, understanding that what I was doing for 32 years, they get me nowhere and seeing you a million times, maybe more. But I'm just saying, even Mr. Allen, I know him, he used to lock me up, so I know good thing for people. And Miss Polera, she said, just keep in contact like I've been doing. I'm trying my hardest since I've been in this recovery home after my 3rd surgery. I would have never had. It took me 23 years to have my surgeries. So I'm doing better now, not picking up.
Good man.
So I'm saying thanks to the court, but leniency for you. I've been seeing, I watch you every day, listen to all the little Rick Maroy, but you always been famous to me because you always been my judge. So I can say that too. But to let you know this, you know, due to where I'm at, my finances been cut down a whole bunch. Like I only get one part of my check. So I would like to know if you have leniency, let me go with the $90 and keep doing what I'm doing and keep myself clean and sober.
You know, I already wrote in your file because a lot of people that appear before me, they don't think I remember them. I remember you, Mr. Malone. I'm glad to see that you're doing well and that you're finally, you know, that you made a decision to kind of turn things around for yourself. And I know that in the past, there were a lot of challenges, but the blessing in it, maybe the journey was in part the blessing that it had to be so tough. But the blessing in it is that you're here talking to me. Because sometimes I never know when I see that person the last time. All right. So here's what I'm gonna do, Mr. Malone. I'm gonna waive the $90. I don't need that money and don't want it. I want you just to be healthy and have everything work out for you. I don't want you stressing about it. But see, and the thing I know is that you would do everything in your power to make sure to get that 90 to me to show me that you're a good man and a man of your word. I don't need that $90 to believe that about you. And so I don't want it. I'm just going to dismiss your case pursuant to the prosecutor's deferred sentence, and we'll close this matter out.
I'm going to say thank you to the court. And one thing, Mr. Simpson, you are a very lenient judge. You know, you don't know me, but I'm 60 years old now. I'm a river rat, plus I'm a road runner. So we don't talk about this in court. But you are a good judge. Mr. Allen, nice to see you. Ms. Polaire, thank you. And my lawyer, they had a different lawyer before this lawyer, but thank you too. And I'm wishing to do the best, and you probably see me doing some, motivated speaking stuff. That's what I'm into now. Because I got a couple of I sponsored a couple of people, and they're doing the right path. They up in Bear River, like where I started from. But if they fall back off, only one who can pick themselves up is their self to get help. And all the tools
That's it.
I'm saying thank you, sir.
And thank you, Mr. Malone, for being such an inspiration. You take care of yourself, even though you are a river rat. I'll let it go. All right.
Okay,
Take care.
All right, thank you.
Yep. All right, bye-bye. Court does call the case of the People versus Che Massey.
Here, Your Honor. I have not been able to get in touch with her. I don't have any information for her.
Bench warrant will issue for defendant's failure to appear. And it's a bit odd, but we extended. Bench warrant, 5,000, I'll give a 10% privilege. That warrant will not issue until the, I'll issue it the 16th. Case, People versus Marquise Fuller. Oh, no, here she is.
Student attorney seeking permission to practice pursuant to Michigan Court Rule 80.120 under the supervision of Assistant Public Defender Lauren Kearney.
How come under Lauren and not Natalie?
I think the case number ended in on, I believe it is on.
Oh, so it's not that you like her better.
No, not at all. Nope.
Really? So you like Miss Pate better?
I like them both equally. They've both been really great.
Okay. You believe her? No. All right. Permission to practice is great.
I'd like to serve the hearing on behalf of Mr. Fuller. It is my understanding that he did pay off the bailiff that was.
Is this one that?
It is.
All right. Cancel show cause. Defendant paid.
Thank you, Your Honor.
Thank you. She feels like she's like Superwoman. She's like, she did. What did you say? She got the money. She did that. And she sat down in between them and said, see, that's how it's done. Court calls the case, People versus Corey Harris.
I'd like to serve the student attorney on behalf of Mr. Harris, who should be present via Zoom. Can you please state your name for the record?
My name is Corey Edward Harris. Thank you, sir. All right.
Your Honor, I had some discussions with Mr. Harris, and he indicated that he did suffer from a stroke, and that coincided with when he stopped making payments on his payment plan.
Got it. Okay. How much is he owe?
My understanding, I have $130.
Yeah, it's 3:30.
It's 3:30.
As of right now, he's paid about $200. He accumulated some late fees, so that's why the balance is a little higher.
Okay, so what do you wish the court to do?
We would ask for an adjournment just so that Mr. Harris could get a little bit back on track and potentially be able to start making some more payments.
Okay. All right. Mr. Harris, how long is it gonna take you to at least get yourself in shape or to the point where you can start making regular payments?
I just got heart monitor from cardiologist yesterday, spoke with them. They want me to get back started doing like light physical activity, nothing too strenuous. But I got some stuff lined up for this weekend, just like little home repair stuff. Initially I was self-employed doing lawn care maintenance and some building maintenance for like small properties. But I injured myself in May and that cut back. So probably a couple of weeks I can get something to you. I'm trying to take it.
December.
December 11th.
Okay. All right, here's what I'm gonna do. I'm gonna adjourn this out to December 11th, 2024 at 9 a.m. All right, try to get yourself in a position to start making payments and we'll see where you are at that point. How's that sound?
I appreciate that. I'll do
All
my
right.
best by then though.
Okay, I'm sure you will. All right, you take care of yourself, sir.
You too, thank you.
House case of the people versus Michael Johnson.
Mr. Johnson, can you unmute and state your name for the record, please?
Michael Johnson.
Your Honor, it seems to be some issues going on with this one. It looks like it was potentially sent to collections, but Mr. Johnson had not filled out the paperwork. He does reside in Canada now and is currently unemployed seeking employment. So that would explain the failure to make payments. So maybe we just need to get an updated address with the court to.
All right, he needs to provide that address to the court.
Did you
All
hear that, Mr. Johnson? Can you please reach out or provide an updated address?
I can, yes.
All right. And what else, and then he needs to get back on track to get things paid and do whatever. He's on probation, right? Has he finished he did. He would have. All right. And it's just, how much do you have in Mel?
$13.50.
So when is it when we got here today, I adjourned it in June to today's date. And he needed to make a payment. Did you make any payment between now and then?
I did not. I have still been unemployed since then.
Then he needs. So what I'll do is I'll adjourn this out to December 11th, 2024. You need to get yourself employed, figure out how you can make payment or fill out paperwork so we can adjust the fines and costs if necessary, but I don't know. Okay?
Okay.
All right. Thank you.
Thank you.
And any payment needs to be in US dollars. I just saw the exchange rate. No, I'm kidding. All right. Thank you. Court does call the case of people versus Terry Lopez.
Alexis, their student attorney appearing on behalf of Mr. Lopez. If he hasn't hired him.
Mr. Lopez? Do you have a camera? Just show us. Mr. Okay. Oh, there you are. Okay, how much does he owe? 400. All right, right now you owe $400. Counsel, what are we doing?
I spoke with Mr. Lopez. It sounds like he was in a position to pay that, but then something came up, so he was unable to pay off that $400. So he said he should be able to pay within the next month.
Is that correct, sir?
Yes.
Okay, I'm gonna mark the file defendant to pay balance in full. And then I'll adjourn this out to.
For the 23rd.
I'll adjourn it out to October 23rd, 2024, 9 a.m. Okay, you got to get that paid.
Is there gonna be Is there gonna be a Zoom? Because I'm gonna be in Nebraska on that date.
In Nebraska? on purpose?
I'll be working in Nebraska.
Oh, okay, all right. It can be Zoom, but if you get it paid, I'm not gonna worry so much about you being here, but you gotta get this paid.
Okay.
All right, thank you.
Yeah, thanks.
Council case People versus Phoenix Novaman.
On behalf of Mr. Moberman, I've reached out once now, also sent an email, have not been able to contact.
She is doing so well.
I know, I was 4 for 5.
She got her stats too, right? How much is he owe?
32.
It looks like there was a payment made on May 24th of this year.
Yeah, he's come down quite a bit. It's out October 23rd. See if you can get through to him, see if you can get it to paid.
Thank you.
That's only because she had an 80% show rate. Court calls the case People versus Noah Vermalingo Semetanka.
Paid in full.
Paid in full, all right. Cancel share cause dependent paid in full. All right, anything else, or?
Putting this down now over to the next one.
Whose case was that?
That was States.
Miss Pate's second pass? That they're still not here?
Correct.
Sure, we'll just put it into the next block. Apparently, that seems to be a habit today with Miss Pate.
It's taking a real long time.
Yeah. All right, so court stayed in recess. Who are these people?
These are our interns. They will call interns.
Sorry. Where are you? Let's call the case of the People versus Genevieve Donald.
This is called the Federal Adelaide case on behalf of the not witness.
This is a recall.
That
It
is.
is.
Correct.
Just check.
That
So,
is correct. We did hear from the other client, that was here earlier, but I have not heard from Ms. Donnell since the court previously called this case this morning. I haven't actually. What was previously given that I would anticipate she may be in the Uber right now. Outside of that, I have no.
you have no clue.
No, I don't. I haven't had contact with her since,
You know, there's a jail recommendation on this.
I haven't.
Okay, so really, Miss Pate, what do you think the odds are she's in an Uber right now?
Sorry,
What do you think the odds are she's in an Uber right now?
honestly, Your Honor, I don't know.
Yes, you do. Bench warrant will issue for defendant's failure to appear. Bond 10,000. I'll give a 10% privilege on that. Because of previous warrants, this warrant will issue immediately.
Thank you, Your Honor. Thank you. Thank you for passing the matter earlier.
Not a problem. Yeah, sometimes I need to pass it just to make it. Court calls the case, People versus Shannon Howell.
Good morning, this is the public defender warrant.
Good morning.
Say your name.
Shannon Howell.
Thank you, ma'am.
Probation. Your Honor, Ms. Howell is before the court for violation of probation hearing. Ms. Howell is at the max of her probation term. Ms. Howell was reporting in final probation up until her incarceration. She was incarcerated in Ohio, and I did receive verification that she was incarcerated at the Ohio Correctional Treatment Facility from April through July, and is now released to a halfway house. She has completed other programming. It is just a matter of the monies that she does work, which does include. Given all of the time of her incarceration, probation's recommending 93 days in jail with credit for 93 days served, that the court waive remaining terms except the financial obligations to discharge her from probation with some improvement, given that the program part was completed and compliance prior to that incarceration. And that she be referred to collections to set up a payment plan, given that she's in housing.
No objection to any of that, Your Honor. I will say on behalf of Ms. Howell, she did, after she was, incarcerated, she did complete treatment down in Ohio and is now in a residential or halfway house treatment program. So she is working to, get back stabilized.
All right, Ms. Howell, anything you want to say, ma'am?
No, I mean, the only thing is as soon as I just started working, so as soon as I get my first paycheck, I plan on making a payment as soon as possible.
Sentence of the court, 93 days in jail, credit 93 served. I'll waive all remaining terms except the financial obligations, discharge the defendant from probation with some improvement. I'll refer the balance of this, including rest, fines and costs and restitution, to collections for a payment plan. All right, thank you. Courthouse case, People versus Deontay Bonner. You don't have a check in.
Your Honor, I do not have an explanation for Mr. Bonner's failure to appear. For the record, I would respectfully request an adjournment.
Clara, on behalf of probation, Your Honor, Mr. Bonner is another who has passed his probation.
Gotcha.
This also was an issue of money, like with the other case, and discharge him from probation with some improvement, given that it's the money, although he's not here. Probation can reach out to him and indicate that a payment plan of the 475, if the court would like to set a payment date by that and a balance by January 5th, and then having a court review hearing by January 15th to verify that payments made, given that it is just financial.
All right. I will discharge the defendant from probation with some improvement. He's to pay the 475. I'll give him till October 31st, 2024 to pay that. And then the balance is to be paid by January 5th, 2025. I'll set a review hearing in this matter January 15th, 2025, 9 a.m. to verify payment. Court does call the case, People versus Man Davis, 2 matters. They both have
One of the.
warrants. Man Davis.
Just to clarify on the application, Mr. Davis was convicted for violation of probation. He is also in veteran status on another matter before this court. Probation would ask for a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000. I'll give a 10% privilege on that. That warrant will issue immediately. Case, People versus Lexus Kersey.
Mr. Public Defender Natalie, with on behalf of Ms. Kersey, who stands to my right, please state your name for the record, ma'am.
Let's Kersey. Teresa Claire on behalf of probation. Your Honor, the council wants to approach for.
You may.
So Teresa Claire on behalf of probation. Your Honor, Ms. Kersey is before the court for a final review hearing on a prosecutor deferred sentence. Ms. Kersey has completed all programming components that this court ordered her to do. Her criminal history is also clear, and she's been reporting to probation as directed. She does have the outstanding balance of $675. Ms. Kersey and I did have a long conversation. She's had some difficulties recently over the last several months. She did provide an ability to pay, which I did provide to the court's review today, if the court would consider any reduction in the fines. That is level.
Counsel, anything you want to say?
Nothing further, Your Honor. I would just respectfully request that the court consider possibly reducing or waiving any fines, considering that Ms. Kersey has done everything else for by the court while on probation.
Ms. Kersey, anything you want to tell the court? Pardon?
I'm trying to take it.
I know.
Yeah, so I'm going to do my best to get this over done.
Okay, but how are you doing?
That's crazy, I shared it with the judge.
Yeah, I'm here. So, yeah.
Sometimes we just, probably as you're waking up each day, sometimes you're wondering how you're gonna make it, right? And then you get to the end of the day and you probably little by little realize you probably have a little bit more strength than you thought you had at the beginning.
I'm stronger than I thought I was.
So my baby's just keeping me going.
Pardon?
My baby's just keeping me going right now. So I'll tell you that, waking them up every morning to get ready for school is what keeps me going.
All right, so I'll say this to you as you're going on this other part of your journey in life. One of the things you have to make sure of, and my heart goes out to, I can't comprehend. All right, but I can certainly offer my prayers and condolences and everything. The one thing that you have to remember is, especially with the little ones, you're doing everything you can to take care of them, right? But there's a certain person you can't forget about. And you gotta make sure you take care of yourself. Everybody keeps saying that to you. Why do you think everybody keeps saying that to you?
I have to take care of myself. Take care of that.
Said one of the things Miss Valera indicated to me, we were talking about your kids and talking about this, said you're a dedicated mom. And I know usually don't share personal things, but I'll say this to you. I lost my dad when I was 16. All right, there's 4 of us. And one of the things at 16, I'm a 16-year-old boy, so I'm not clear what the heck's going on in the world, right? But I realized that my mother did a lot of things that normally she wouldn't have had to. And that she really did need to take care of herself, but she always made sure to take care of herself. We didn't want to need anything. And I asked her one time how she kind of made it through it. She said, I just had to take care of my babies and I had to take care of me. So I don't know why I felt the necessity to share that, because apparently probably some of the people that are telling you that you're probably not listening to. So I'm telling you, you have to do that. All right. What I'm going to do in this case is I'm going to waive all the fines and costs. I don't want anything. You don't need it. Most important thing is you take care of those little babies. You make sure they're okay. Whatever money you're going to give to the court, you take care of them. You put that toward them. And this will take a little bit of stress off of you. I don't need you reporting to us. I don't need to know that. I almost want to make you report to us just to tell us that you're okay. So what I'm going to do is I'm going to dismiss this case at this point under the prosecutor's deferred sentence. You're done with us. Ms. Kersey, God bless you. Take care of yourself. Take care of those little ones. Take care of your family. And make sure that they get out there and have the opportunity to do great things.
Thank you.
You are more than welcome. And Ms. Kersey, I mean it. Do this old judge a favor. And then at some point, maybe a month or 2 down the road, just call Miss Valera. Let her know that you're okay. She will make sure that message gets to me, and that will mean the world to me.
Thank you.
You're welcome. Here. Court calls case of the people versus Cindy Miller.
Good morning, this is the public hearing on behalf of Ms. Miller, who I believe is on Zoom. Explain to you, state your name for the record, please.
Oh, there's. Okay, you have a camera, please? Ms. Miller? You muted yourself.
Yes, I'm here.
Okay, do you have a camera?
I don't know how to turn the camera on.
Ms. Miller, there should be a little camera with a line through it, you press that, turn your camera on. I will say for the record, Your Honor, I do believe that is my client.
Okay, you recognize her voice.
Yes.
All right, go ahead then with this. Ms. Miller,
Yes, Teresa Claire on behalf of probation. Your Honor, Ms. Miller.
she got it. Okay.
Ms. Miller is before the court for violation of probation hearing. Ms. Miller, was not reporting as she was supposed to. However, I've had conversations with her, I should say not reporting since she was last reported. Had an extension. The issue is that she has a $380 balance. My conversations with Ms. Miller, she indicated that she's having difficulty with getting that paid. As the court knows, the court has extended this 2 times prior to give her a little bit more time. I did have a conversation with Ms. Miller about filling out the proper paperwork for the court to look at that. Given that there is still time on this case and it is a prosecutor deferred, probation is recommending that we extend it once again for a period of 4 months, that Ms. Miller make an $80 payment, and then $100 per month, that she get the ability to pay for along with the supporting documentation to my office within 10 days, that all conditions that were previously ordered would continue. That would include monthly check-ins with probation and setting a new review hearing January 15th, 2025 at 9 a.m.
I did go over all this with Ms. Miller. We have no objection to any of that.
She just dropped. Oh, she's back. Now, okay, there she is. All right, go ahead.
We just have no objection. I did send over the ability to pay form.
I'll extend the prosecutor deferred sentence for a period of 4 months. She's to pay $80 on her before today. Can you get that in, Ms. Miller? I'm assuming she can hear me, but.
Hello?
Yes, can you hear me?
Hello?
I don't think she can hear me.
I
Can you hear? Okay. So I'll just finish this. Pay $80 on her before
Hello?
September 11th. I'll give her till September 30th, 2024. Then $100 per month. She's to submit the ability to pay form along with supporting documentation within the next 10 days. Continue all terms as previously ordered. I'll set a review hearing January 15th, 2025, 9 a.m. Thank you. Do I have it? Court calls the case People versus Michael Holbrook.
Way out to the Zoom.
Evening.
I do not have information from Mr. Howard. I did not have good contact information with him, was unable to speak to the court for his hearing. For the record, I request his priority confirmation. Mr. Holbrook is scheduled before the court for a violation of probation hearing. I'm compliant with all terms ordered by the court. Additionally, he's failed to appear several times before this court for probation.
On the last one, I don't, bench warrant will issue on $25,000. I'll give a 10% privilege on that, like the last one, the last 2, the warrant will issue immediately. Court calls case People versus Sandra Sanchez.
Assistant Public Defender Natalie Hayward on behalf of Ms. Sanchez, who I believe is present via Zoom. She may have dialed in.
No, she's right there. Ms. Sanchez, can you unmute and turn on your camera and state your name?
Big call in.
She called in. Okay, so she called in. I don't have a camera. I need you to unmute. You need to hit *6. There you go.
Hello?
Hello, what's
Hello.
your name?
Sandra Sanchez.
Teresa Claire on behalf of probation, Your Honor, Sanchez before the court for a violation of probation hearing. Since I filed that report, Ms. Sanchez has become compliant with all accepting monies. She does have an outstanding balance of $790. She did make a payment last in July of $50. I did have a conversation with her regarding the monies most recently. I know that the court did one prior extension already. However, probation is asking that the court give her additional time and extend her probation term for a period of 6 months. That she pay $140 today, then $130 per month, and that all other conditions continue as previously ordered.
All right, Ms. Sanchez, can you make the $140 payment today?
I made a online payment of $60 yesterday, and I can make the other half Friday.
Friday?
Yes.
Okay.
And Your Honor, I do confirm that she did make that $60.
So she would need another 80?
Correct.
Got it. Anything, counsel?
For Your Honor, I respect the request that you adopt probation's recommendation.
I will extend your probation term for a period of 6 months. You're to pay an additional $80. The $80, you're to do that by this upcoming Monday, the 16th. Then $130 per month thereafter. I'll continue all of the terms as previously ordered. All right? Thank you, ma'am.
All right, thank you.
Court calls the case People versus Veronica Webster.
Webster, that he is lying, she has city hustler, there's no information on their.
Here's for on behalf of probation, Your Honor, Ms. Webster is scheduled before the court for a violation of probation, and she is not compliant with terms. She's not here as well. Probation is requesting.
Bench warrant will issue for defendant's failure to appear. Bond $25,000. I'll give a 10% privilege. That warrant will issue immediately. Thank you. That it? Till when? What? I don't have anything to do till what? No. All right, then the court's gonna stand in recess till 1. Maybe Ms. Fate can find her clients. All right, give her some time. All right, thank you, court's in recess. All right. Court does call the case of the People versus Rosalind Wallace.
Good afternoon, Assistant Public Defender Lauren Cannon on behalf of Ms. Wallace.
Teresa Claire on behalf of probation, Your Honor, Ms. Wallace was scheduled before the court for a final review hearing on a prosecutor for the sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation.
No objection.
So ordered. Court calls case of the People versus Brittany Zemeckis.
Good afternoon, Assistant Public Defender Lauren Cannon on behalf of Ms. Zemeckis.
Teresa Claire on behalf of probation, Your Honor, was scheduled before the court for a final review hearing. The prosecutor deferred. She did complete all terms ordered by the court. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred discharge from probation.
No objection.
So ordered.
14A District Court for County of Washington, State of Michigan, session, the honorable David Chip.
You may be seated. Court does call the case, People versus Zachary Burlett. Zachary Burlett, you'll need to unmute and turn on your camera. Oh, camera, looks like it's coming on.
Hello?
There. Hello. State your name.
I am so sorry about that. Zachary Burlett.
Not a problem.
Teresa Claire on behalf of probation, Your Honor, Mr. Burlett is before the court for a review hearing. Mr. Burlett, did have an accident where he was hit by a car. He's been hospitalized. He did provide me proof of his hospitalization. He had, as far as I know, he's been discharged from there. He is in a outpatient plan. I think it's set up through the Delana's house, where he is staying at the hotel. And is under medical care still there. And he has a nurse that comes in and works with him with that. given the circumstances of Mr. Burlett, and being hospitalized, he now has to restart his domestic violence program and his mental health therapy that he was attending, and even getting back into the transitional housing. I believe he lost that temporarily because he's out so long. Have to get reset up. Given all of the circumstances with him, Mr. Burlett did stay in communication with my office. I was in contact with his medical staff. Probation's asking that all conditions continue and that the next review hearing be set November 4th, 2024 at 1 p.m.
All right. Mr. Burlett, anything you want to say regarding that?
Oh, yes. First and most, I just want to apologize. I was actually talking to Sparrow, which is the Down Farm program, and I talked to David LaFar, which was my house manager earlier today, and he said they were recommending me to other places. However, though, they said he wants me to come back, but the recommendation he had made was for me to do 30 days in a Sparrow. Once I'm done completing my 45 days with Washtenaw in nursing home. I think that's what it's called. I'm trying to get it for work. So I do have physical therapy that comes twice a week. I do have nursing that comes once a week to do checks on my stitches that I had in incision, plus the plates, screws, pins, etc. But it's a pretty hard time right now. But I'm maintaining and doing what I can. And they said that they will accept me back in the housing. They just would like for me to go to Sparrow for like a 30-day. They are aware of some medication to take, which had to be taken, but it gives me another 30 days to just kind of relax. You know what I mean? Just to
I got you.
Not be doing so much.
All right. So, but you're doing as well as can be expected right now.
Yes, and so for Miss Clara is aware of my therapy that I had. My therapist got fired, unfortunately, due to everything that happened. I was in no communication. So what I was suggested to do is once I'm up to go, just to make another call to them, and they will reschedule everything. Everything will basically be back on track with that.
Okay. All right. Sounds good. Then what I will do is I'll continue all conditions as previously ordered, let you get back on track. And I'll set a next review hearing November 4th, 2024 at 1 p.m. Okay, sir?
Thank you, Your Honor. Thank you, Your Honor.
Thank you. Good luck to you.
Thank you.
Let's call the case of the People versus Nathaniel Laurent.
Turn left.
This is a show cause, the time we call.
Show cause. Nathaniel Laurent. How much you have?
$825.
You're supposed to come back with a plan for payments. It's not here. I turned it out the last time, so we could do that. Got here, bench warrant will issue for defendant's failure to appear. You said $825?
Yeah.
Bond is set in the amount of $825 cash. Warrant will issue immediately, there having been previous warrants. Let's call the case of the People versus Brian Cox. Thank you.
Yeah, it's a date and time set for a violation, I believe. I have had a chance to.
I think we're set for a review.
Review, okay.
You want me to violate him? Yeah.
No, you're
All right.
I did just have a chance to speak with Mr. Cox. I was unable to contact him prior to today due to just bad contact information that he is here. Part of the, I guess the recommendation from Ms. Pilar reflects a new conviction. Mr. Cox, his understanding of that conviction is not super clear. He believed that he hadn't pled on the case yet. and that nothing was finalized. I obviously have not had the chance to speak to his attorney on that case or anything because of we just discussed about it now. So So I'm actually asking for an adjournment so I can look into that. He thought that his next court date was kind of another conference with the judge to discuss the plea. And I just want to look into it to make sure he's fully aware
And then
of
I
how
just
that case
like
impacts this case
quickly
and
popped
vice
on,
versa.
and it's been like 6
Ms.
minutes.
Polero?
So if you
Yes,
stayed,
Ms. Polero,
thank
on
you.
behalf
I'm
of
sorry.
probation. Your Honor, Mr. Cox is set before the court for a review hearing. He did fail to appear at the last review hearing, and the court did issue a bench warrant. When he did the bench warrant recall, I believe the clerk's office reset it for a review. So
That's why it's on. Gotcha. Okay.
correct. So they reset it for the review hearing. Mr. Cox did not appear at that review hearing because he was incarcerated in Oakland County, is my understanding, correct, Mr. Cox?
Yes.
Okay, so that incident in Oakland County happened at that time, that's why he wasn't here. From his criminal history, Your Honor, it is showing that there is the conviction of the RNC stolen property, a motor vehicle, with the date of offense of July 2nd. The sentence date, I looked online and it shows October 17th for that. Now.
That shows it's a sentence?
Correct.
Okay.
And so, like I explained to Mr. Cox today, my issue with Mr. Cox is that I hadn't heard from him since June. And he indicated to me that he did contact my office because he missed his court date and was advised to complete the bench warrant recall request. So I do believe that there was some form of communication from him to learn to do that. However, I didn't hear from him to speak about any of the incarceration that happened or the new case that is there. It's my understanding that it is a conviction. However, he indicates today that he believes that once he goes back for sentencing on that date, that it may go away. I've never heard of anything like that being as such. However, I would not be opposed to a short adjournment so I can reach out to that county to verify what is happening in that case.
All right. And that seems to me to make some sense and allow you, Ms. Perry, to figure out what may be going on.
Yeah, and just make sure Mr. Cox and his attorney know what's happening here as well. I don't know, Connor, but I would like some time to figure all this out.
Because they may not have known that if it was a plea, there might be an issue with them not knowing that this was here.
That's my worry, yeah.
Okay. September 30th, 2024, 1 p.m.
Thank you.
You're welcome, sir. I'll continue.
Good morning, I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the criminal jury trial calendar call for September 16th of 2024. This is the 10 a.m. calendar. I'm going to call the calendar. If you're represented by an attorney, the attorney will respond on your behalf, and the attorney from the state will respond on behalf of the state. If you're not represented, then we'll speak directly with you to see what you wish to do with your case. You have the option of having an attorney represent you if you cannot afford one or you need one today. We have attorneys in the courtroom that I could assign to you, or you can represent yourself and meet with the state's attorney and determine what you all agree to with respect to your case. Okay, Marquise James Arnold.
It's not Judge.
Yes, ma'am.
Judge, if you can hear me, I did speak to Mr. Arnold, and I believe we'll have a plea today. I just need to make sure that the state confirm the offer and confirm his eligibility for first offender, I believe. So if we could hold on that, but I think we have a resolution.
All right, Mr. Arnold, as soon as they come back with that, then if it's a plea, we'll go ahead and take that plea at the appropriate time, okay?
Yes, ma'am.
Joseph Ashton.
Step up, sir.
Roger, I'm Michael DuPont. That's my case. I'm here on behalf of Scott Fortis.
All right.
This is a case where Mr. Ashton is out of state. And I would like to speak with one of the assistant solicitors because we'll probably be entering a plea on a plea in absentia. And, but I need a pretrial with one of the assistant solicitors. Be happy to walk down to the office and talk to one.
All right, she usually comes down to the courtroom. Is Mr. Ashton not present?
No, ma'am.
Why is he not present?
Lives out of state, Your Honor.
The what?
He lives out of state.
And generally, if we're gonna ask for a plea in absentia, we do that ahead of time, because if he doesn't show up on the date of trial or the date of the calendar call, then that's a bench warrant bond forfeiture.
I'm here for Mr. Fortas. I'm not familiar with the procedure on that, but I was told that that there was a failure to appear at one time, but that was set aside.
Yeah, it'll be set aside once, but I don't have an ongoing, you don't get to come to court thing. Yeah, that wasn't worked out with anybody. So you can speak with Ms. Hagler and see if y'all can work something out, but to the extent that Mr. Ashton isn't here, it's a bench warrant bond forfeiture.
And Your Honor, Attorney Payne is also on today, so.
I'm sorry, thank you, Solicitor Payne.
He was speaking with her.
I'm used to only having one.
Yes, ma'am, that's fine. We just worked it out where I was covering the first half and Ms. Hagler's covering the second half.
Okay, that works. All right, so sir, you'll speak with Ms. Payne. If you want a breakout room, I can put you in one in a moment.
I'll just walk down the hall, Your Honor.
Okay, that works.
Thank you.
Lazarus Marquise Black, Jordan Van Mater. Oh, Miss Val excused the parties on this case. I think I remember this email coming in. Benjamin Scott Bullock.
Judge, he appears to be on the Zoom call. I didn't speak with him, but I did make contact with Mr. Bullock. Could you turn your camera on and unmute your mic?
Yes, it's unmuted.
There you are, sir.
So, Your Honor, I believe what we're going to do is Mr. Bullock is actually in the process of getting his license. So we may go forward just to make sure he can get his license before he resolves his case. But we would just, I guess, ask for a pretrial to briefly see where we're at with the state with his case, and so I can make sure I get all his contact information.
All righty. Jahai Hamilton Cruz. Mr. Cruz has 2 cases. Mr. Cruz.
I'm here. I'm on.
I see you.
Okay. Here I go.
Right.
Hey,
So
how you doing? Hayward.
Hold on, Mr. Cruz. So, Mr. Cruz, are you re-representing yourself, or have you hired an attorney to assist you?
No, ma'am. I'm currently paying my attorney now. I didn't finish completing my payments. I was asking, could I have more time? Because I'm kind of going through a lot of family issues. And
I got you, Mr. Cruz, but you've been here a while.
I know you told me a month ago to get that situated, and my attorney asked for $20,000. And
I don't negotiate fees. All I know is if you don't pay them, they're not showing up. But you've had this case is a 2021 case, the first one, and then a 2023 case, and so you've had plenty of time to get an attorney, sir. And I told you when you came the last time that I was only giving you 30 days to get that done. Now I don't know what they charge out on these Clayton County courthouse streets because I'm not out there anymore. But you chose to hire an attorney. That's on you.
Oh, but you remember last time we spoke, Miss Hayward, you someone in your office seen that my case came up on your desk around 4 or 5 times. So I thought I dealt with this case in 2021, but it shows that it didn't, because you were telling me that you can also pick it back up. So
No,
I'm trying to get all that.
Okay, let's be clear. I don't pick anything back up. If it comes back up, it's because the state has accused it, and it's currently an active case. I don't recall the state no processing this case. There's nothing in my file or on my calendar that says this case was resolved. You just got another case in 2023. That's all I know. So you have two cases. And I do know that we had this discussion about you going ahead if you were going to hire an attorney and getting an attorney. Now, if you want to have the assistance of Lister, Holton, Dennis, and they are not conflicted out of your case, we may be able to do that. Otherwise,
What does that mean?
In the courtroom might be able to speak with you.
Conflicted out of the case. What does that mean, ma'am?
I said if they're not conflicted, which would mean they either represented somebody else against you, or they represented you in the past, or one of the attorneys who was on the state side may have been involved in accusing your case. So they always do a conflict check.
See, that's why I was asking, could I have more time? Because in 2021, I hired a lawyer to resolve this case, but
well, sir, if you hired a lawyer, that they didn't file any paperwork telling us that you hired them. Ms. Wright, Ms. Val, does anybody see that? Who was the lawyer you hired in 2021?
I would have to, I can't think of his name.
Yeah, Mr. Cruz.
Flynn, something Flynn. I have to look into it. I have to have
I've
my
been here
mom.
the whole time. And so when you hire an attorney, they're required to do what's called an entry of appearance, which means they have to file paperwork with our office. Once they file the paperwork with the clerk's office, then they become the attorney of record. And every case comes up, they're going to be on your case. It's going to show up on my calendar because it's going to be attached in the computer. I don't have that for you for either case.
See, I don't understand that. I'm sorry, but I don't understand that part because from 2021.
Well, sir, you can't even remember what attorney you hired. So how we
No,
supposed
it's my mom. My mom that hired him for me. His name was something Flynn. It's Flinn. Because we hired him back in 2021, and he helped get my probation reinstated, and he took care of this case right here. But I don't know if it never went through because last time I was in court that one of your assistants or something say that they seen that my name came across your office 4 or 5 times that you signed off of my bond. And with that being said, I know my paperwork is messed up in like the Clayton County Court office because I've been locked up like 5 or 6 times for the same thing. And you was asking me last time about did you move from your residence? Did they ever send you this or that?
But sir, that has to do with whether you got notice. It has nothing to do with whether there's an attorney on your case.
So I thought I had an attorney on my case for my first case.
What? I've not seen an attorney on your case since this started. I'm not aware of one. We're not able to find one. We don't have any record of one. And you asked for you asked for time to hire an attorney for the other case. We had this long conversation. And so, sir, like I said, I probably told you, yeah, well, we got Lister and Holt available, but if you want to go out and hire your attorney, understand 30 days. No.
Yes, ma'am. I was under the impression that I had 2 cases, right?
You
I was
do.
asking, may I have more time, please? That's all I'm asking.
Mr. Cruz, this is a 2021 case. Then you got a 2023. Mr. Cruz.
Yes, ma'am. Yes, ma'am.
Mr. Cruz, sometimes we have to make sound financial decisions. If you're not able to hire a $20,000 attorney, then you're not able to hire a $20,000 attorney. Doesn't matter how long I give you. Sometimes you just have to come to the conclusion that you can't hire a $20,000 worth of attorney.
That's all I was saying. Could I have more time if I can find one that can fit my budget? Because I just got a job. I'm paying rent by myself and I'm paying a car note, ma'am. So I'm really struggling at this current time. My mom.
Okay, no, sir, that's not struggling. That's what everybody does. Everybody pays their car notes. Everybody pays their insurance. Everybody pays their rent. That's grown-up stuff. So you're not struggling. You just live.
On my end, I'm really struggling, like, because I can barely afford my car note. I'm getting my hours cut on my job, and I'm trying to make sure I can keep paying my bills. So hiring an attorney is kind of hard, but I'm still like saving up so I can hire that.
Sir,
but I'm close.
What I'm telling you is, I'm giving you the option. I can appoint Lister, Holt, and Dennis if you wish, but what I'm not going to do is give you more time for an attorney that you obviously can't afford. We've had this discussion. You've had the first case since 2021, the second case since 2023. If you wanted to hire an attorney, you could have paid off that $20,000 by now on time, a little bit at a time since 2023.
Yes, ma'am, but I was under the impression for
Mr. Cruz, you're charged on the first case with fleeing from police, leaving the scene of an accident, speeding 25 to 30 miles per hour over the limit, and no proof of insurance. You're charged on the second case with driving on a suspended or revoked license, marijuana 1 ounce or less, and tampering with evidence. So I gave you on July 29, 2024, an opportunity to get an attorney. I told you at that time you had 2 cases because I continued them both. The notes are on my calendar. You didn't get an attorney. If you want to hire, if you want to have Lister and Holt and Dennis appointed to you, I can do that. Otherwise, you're talking to the state about what they're willing to offer, and you can represent yourself. And all those things that you listed that you call a hardship, that's just living, sir. That's what everybody's going through. Everybody on this this hearing today has rent or mortgage they paying, has car insurance, car note. Those are bills. That's what grown-ups do.
Yes, ma'am. I understand it. So this is my first time, and I'm actually trying. Like, I'm changing my life around now. I'm going back into the same loophole that I was once in when I was younger. See, I'm older now, so I learned from a lot of my mistakes. So I was asking, could I actually have a little additional time, ma'am? Because I understand that I've been dealing with this since 2021 and 2023. But during the 2021,
I've given you the opportunity to have Lister, Holt, and Dennis or to represent yourself. I'm not giving you any more time to hire an attorney that you obviously can't afford. And I'm not dissing you. I'm just saying sometimes you got to recognize where you are in life.
Yes, ma'am. That's what I'm doing now. See, at this point, I'm trying to change
Mr.
my life
Cruz.
around.
So if you don't want to hire Lister, Holt, and Dennis, I can set up a breakout room for you to talk to the state about your cases. Otherwise, I need to move on because I got other people on the calendar. I can't keep going around this circle with you since 2021.
Ma'am, this is my.
All right, next on the calendar is Eric Devon Dixon.
Judge, it appears Mr. Dixon is on the Zoom call, I believe. Yes, I see him. I did reach out. I didn't have a chance to talk. So myself or Mr. Taylor will need to have a quick breakout room or a conference with him via phone. If he could send us his phone number, we may be able to.
Mr. Dixon, if you know how to use chat, raise your hand for me. Where's Mr. Dixon? Eric Devon Dixon.
Mr. Dixon, please turn on your camera and unmute your microphone if you can. It should be at the bottom of your screen, a microphone symbol and a camera symbol for turning on the camera.
Mr. Dixon has 2 cases. The first case is theft by taking, battery, family violence, battery, simple battery, family violence, and simple battery. The second case is abandonment.
Abandonment to who?
Is this Mr. Dixon?
Yes, ma'am.
All right, hold on, Mr. Dixon. Somehow you came back in and your name's not up. Abandonment means that you failed to support your minor children.
How is that possible? When I showed the last time I was in the courtroom, I sent the text message where I was showing them where I was taking care of my kids anyway through the cash app. So how I abandoned them?
Hey, Mr. Dixon, I don't want to interrupt.
Dixon, I don't know. Not my choice. That's not my call until y'all come before me for a trial. I don't know. What you can do is speak with your attorney about the case, though.
Okay, so what's the first charge?
Your first charges are theft by taking, battery, family violence, battery, simple battery, family violence, and simple battery. And you're represented by the law firm of Lister, Holt, and Dennis, and they're here and prepared to speak with you, but they need your phone number. Do you know how to chat to them? Mr. Lynch, can you send him a test chat so he can respond?
I can. It may take me just 1 moment.
Okay, you'll have a red number or a letter pop up on your screen. Click on that and you should be able to send your phone number back to your attorneys in the courtroom. If you all aren't appointed on the abandonment case, send me an appointment order. I'll appoint.
Yes, Your Honor. How do I make this screen?
So what you say the first case is?
Well, I still.
Your attorney will tell you when they get a chance to talk to you.
So what I steal?
What do you what?
You say theft by taking, so what I take?
Mr. Dixon,
Jason,
what did I just tell you? Your attorney will talk to you about your case. We're not having this discussion. I don't get involved until it's a plea or a trial. I'm not going to go back and forth with you about what you took or what you didn't take, because that's not proper. Your attorney knows all that information. That's who you need to speak with.
So what, y'all switched the attorney or something? Cause I thought I had resolved the case last time.
Mr. Dixon, if the case is still open, you didn't resolve it.
So who was my attorney last time I was in court then?
Mr. Dixon, your attorney's gonna give you a call. He can explain all that, okay? Did you put your number in the chat?
What chat? They ain't sent me nothing.
Mr. Taylor is in the process of sending a chat. He sent the chat, so you should be able to see it at the bottom. Check the chat, Mr. Dixon.
Touch your screen.
Okay. Test.
You see something in red pop up on your screen?
Yeah, I see. Chat.
Oh.
Yeah.
Okay,
Hold
click
on.
on that and respond directly back. Okay,
It say, please, this right here, Mr. Dix, please enter your number.
I'm sorry.
That's him, Mr. Dixon, please enter your phone number.
Yes.
That's the chat.
Okay. I think I did.
Okay, thank you. All right. Next is Juan Fuenzalida Alvarez. Juan Fuenzalida Alvarez.
Your Honor, I believe we skipped, Mr.
I
Drake.
did, I'm sorry. DeMarco Antron Drake. DeMarco Drake.
Judge, he's here sitting next to me.
Okay, Mr. Drake, you're charged with no insurance, improper U-turn, no tag or expired or invalid tag, and theft by taking. Did you wish to represent yourself, or did you wish to speak with Lister Holton Dennis about your case?
Dennis. So you want us to appoint to represent you? Okay, sure.
All right. They're going to speak to you about your case, and they'll speak with the state and see if they can get it resolved, okay? Juan Fuenzalida Alvarez.
His case was reset to September 23rd for a bench trial.
Thank you. All right, Shortavius Laney. Shortavius Laney.
Yes. Yeah, ma'am.
All right, Mr. Laney, you're before the court for speeding, fleeing from the police, improper lane change, and no license.
Yeah, ma'am.
All right, sir, did you wish to represent yourself, or did you wish to have an attorney represent you?
I think I talked to him.
Your Honor, I had filed an appointment order previously.
Oh, okay, thank you.
However, I spoke with Mr. Laney and he's requesting a 60-day continuance because he wishes to hire a private attorney.
Mr. Laney, did you hear the conversation I just had with Mr. Cruz?
Yes, man. I just had this conversation with my lawyer. I mean, with that lawyer a couple days earlier, but that's what the lawyer told me to ask for, since I only have half the money for her.
Who you hired, Mr. Laney?
Her name Kamisha Ben. She worked my cases for Fulton County.
Not a 60 days. No, Mr. Laney. This is a 2021 case. No, sir. I give you 30 days.
Yes, ma'am.
Now that's whatever y'all work out is between you and Ms. Benz, but I give you 30 days. Submit a withdrawal, Mr. Taylor.
Yes, Your Honor. Thank you.
All right, Mr. Laney, I'll see you in 30 days with or without your lawyer.
Yes,
Kiara Quinn Love.
Judge, Ms. Love is an active inmate. I will speak to her momentarily. If I could request that the state send us the current offer on the table.
All right.
Oh, I'm sorry. That's not a female. That is a male, but same.
Okay. All right. Is the state ready on any of these cases?
Your Honor, the state is already on Love, and a commit should have the recommendations by now. If not, we can always resend it, but yes, the state is.
I would just ask if you resend it because there's no way to know if we have it or not, or if it's current. That would just be very helpful to expedite this process.
Chad Tiant Madison.
I'm here, Your Honor.
All right, Mr. Madison, you're charged with, may I see you, please?
Yes,
All
Your
right, you're charged with DUI, less safe, driving under the influence per se, and no insurance. Sir, did you wish to hire an attorney to represent you? Did you wish to have the services of Lister Holton Dennis, or did you wish to represent yourself?
I think I spoke to the public defender when I came to court. At that point in time, and I think we discussed something, but we didn't go any further. I didn't get any contact from then. Also as well, Your Honor,
Hold on. Mr. Taylor or Mr. Lynch, do you have a record of representing Mr. Madison?
Judge, we don't have, I do not believe so.
All right, so Mr. Madison, are you sure you spoke with them?
Yes, ma'am. I spoke with, it was a young lady that was in the court at that point in time and told me to write down my information, that they will reach out to me. But nobody reached out to me. And I've been waiting on that call.
All right, so I'll appoint Lister Holton Dennis to assist you.
Okay. And could I also ask one more question before you let you go? What was the statute of limitation for this actual case? Because this whole case has been over my head. I haven't been able to get jobs, housing, different things like that because of this current case.
I got you, sir. It's a 2021 case and it was downstairs and it's been accused by the solicitor's office. So that's part of what you can discuss with because I don't have the file to see what happened when. But that's part of what you can discuss with your attorneys at Lister Holton Dennis.
Okay, thank you.
Sure. All right, Raymond Van Mosley. Raymond.
Yes, Your Honor.
Van
Good morning.
Mosley.
Good morning.
Good morning, Mr. Mosley. You're before the court on no license. Sir, did you wish to have an attorney represent you or did you wish to represent yourself?
Your Honor, the state is on non-process case.
Oh, okay. Mr. Mosley, your case has been no problem. It's free to go at this time. Thank you, sir.
Thank you. God bless.
All right. All right, next is Anthony James Pennington.
Mr. Pennington is in the active inmate. Same announcement. I would ask the state send us a current recommendation so we can discuss that with Mr. Pennington.
All right, so if Mr. Pennington goes forward to trial and still an active inmate, he'll be one of the first out. Is state ready?
And Your Honor, the state will offer non-process case as well.
All right, Pennington, Anthony James, the case will be no process. Thank you.
Mr. Anthony Pennington, inmate. We're dropping his case.
Okay. All right, Joshua Antoine Pratt. Mr. Pratt has 2 cases. He's represented by Lister Holton Dennis on one of them. I can extend that to both.
Absolutely, and I think I spoke with Mr. Pratt. I would need just to confirm. Mr. Pratt, we spoke on the phone on Friday, correct?
No, sir.
Okay, I apologize. If you could chat your number, well, if you'll send him a message.
Yes, Mr. Pratt, a red number is going to pop up on your screen. If you don't see it in a few minutes, just make sure you touch your screen to activate the screen. But a red number should pop up, and that'll be the chat function. And
Yes, ma'am, I got it.
okay, so when you type your phone number and email address into that chat function.
Yes, ma'am.
All right, thank you.
And just for a point, I believe there is a motion to revoke bond filed in one of Mr. Pratt's cases scheduled for September 18th.
Okay.
You said revoke bond. What's going on?
So, your attorney's going to explain it to you, but just for everybody on the calendar, when you have one case and you're given a bond in that case, most people don't read their bond paperwork, but on your bond paperwork, it says that if you pick up another case, then it violates your bond and the state can seek to have your bond revoked so that you spend the remainder of the time in jail because you were out on bond on one case and you got another case. So you have a 2021 and a 2022, Mr. Pratt.
2021, 2022.
Yeah, you got a 2021 license, driving on a suspended or revoked license, no license, decal violation, and speeding 21 to 25 over. And then on 2022, in the year 2022, you got a simple battery, family violence charge, and a simple battery.
Okay.
All right. So
where are we going with this? These cases?
well, that's for you to discuss with your attorney. So let's give them an opportunity to speak with you. Okay.
Okay.
All right. Tamisha Ward.
Judge, Ms. Ward, she should be online. I've spoken to her. Ms. Ward, please turn on your camera.
And Your Honor, this is on our process case.
All right. Tamisha Ward's case will be held cross.
Thank you.
Ms. Ward, you're free to go at this time.
Thank you.
Thank you. All right. Antoine Javoris Williams. And Antoine Javoris Williams.
Yes, I'm here. Good morning.
All right. Good morning, Mr. Williams. Mr. Williams, you're charged with leaving the scene. That's a 2022 case. Did you wish to represent yourself or did you wish to have an attorney represent you?
Your Honor, this is our process case.
Okay. The state's going to no cross the case, Mr. Williams. You're free to go at this time. Thank you. And please, Mr. Williams. Mr. Williams.
Hold up.
You listening?
Yes.
All right. So, Mr. Williams, I would presume that you at your good job. If
Yes,
you're
ma'am.
ever in an accident, just go ahead and exchange information, sir. Leaving the scene is not a good idea because it can suspend your license if I'm not mistaken.
Yes, ma'am.
All right. Thank you.
All right.
All right. Brittany Ann Wilson. Brittany Ann Wilson.
Oh, shit. Oh.
Your Honor, say we move for a bench warrant and bond forfeiture.
Last call for Brittany Ann Wilson. Is Ms. Wilson in the courtroom?
No.
Bench warrant. Bench warrant, bond forfeiture. All right, so we're anticipating a plea for Arnold. Ashton is a bench warrant, bond forfeiture. Black was excused and continued. Bullock is on the is a pretrial with Lister Holton Dennis. Cruz is continued. No, Cruz is, where's Cruz? What do I do with Cruz? Cruz is still here, so he's got to make a decision about whether he's going forward with Lister Holton Dennis or whether he's going to represent himself. Dixon is pretrial, Lister Holton Dennis. Drake is Lister Holton Dennis. Quinzaletha is continued to the 9/23 calendar. Laney is given 30 days continued. Love is an inmate and is pretrial with the attorney and the state. Madison is Lister Holton Dennis and Pratt, Lister Holton Dennis.
Your Honor, can I make an announcement about Mr. Ashton?
Yes.
He is apparently on Zoom. I went to the solicitor's office and somebody in the office called my office. We arranged to have him on Zoom, so if he would turn his.
Yes, I'm here.
Okay, Mr. Ashton. All right, did you have an announcement for Mr. Ashton?
Sorry, Your Honor. So,
I'm sorry?
I didn't hear the court. Could you repeat?
Oh, I said, did you have an announcement for Mr. Ashton?
We haven't been able to pre-try the case yet, but
Okay.
and
you said you were gonna walk down or
walked down to the solicitor's office, but I don't have a telephone with me, so I'm not sure the procedure is. So I merely just want to find out what the state's offer is, and we'll be happy to to proceed, but
Judge, if he wants to walk back down, he can. I just couldn't step out of court for the calendar call to talk with him.
All right, so I'm done calling the calendar. If you want to walk back down there, she's going to be free to speak with you.
Okay.
And just ask for Miss Payne.
I'll be happy to do that. Thank you, Your Honor.
All right, thank you. All right, Mr. Lynch, Mr. Taylor, what do we need to allow you to pre-trial your cases?
Thank you, Your Honor. Mr. Lynch is currently in the attorney booth meeting with one of the active inmates. Two other gentlemen, Mr. Madison and Mr. Dixon, have given me their phone number, so I'm going to step outside and call them by phone.
Okay.
Status and decide how we're going to proceed.
All right, so I'll be back as soon as we have announcements.
And I have a point for everyone. Are you physically in the building today and send them back, or should I send those by email?
You can send them by email. That's just easier because I'm sitting here looking at my iPad. I can sign.
Thank you, Your Honor.
All right, Mr. Arnold, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Mr. Arnold, you're before the court on State of Georgia versus Marquis James Arnold, 2021 CR 06120 for battery, family violence, simple battery, family violence, simple battery, and cruelty to children. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, he's pleading to count 1 and count 5. We're asking the court to accept this plea under first offender, and the state informs me that he is eligible.
All right. By entering a guilty plea to counts 1 and 5 under the first offender, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. Arnold, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Correct.
All right, and sir, your attorney has explained to you the pros and cons of taking this plea under the first offender statute?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. On or about May 22nd, 2021, officers responded to 1710 Old Rex Morrow Road in Morrow, Clayton County, Georgia, and made contact with the victim, Ms. Viviana Garcia, who stated that the defendant, who is her, the father of her daughter, slapped her in the face and grabbed her by the throat with his hand to choke her. The officer did observe bruising and scratching around her neck. And all this occurred in Clayton County. The recommendation is for count 1 is 12 months of probation, and while on probation, pay a $200 fine, complete a family violence intervention program, do 40 hours of community service, and have no violent or harassing contact with Ms. Viviana Garcia. Counts 2 through 4, the state's moving to null pros. And count 5 is just 12 months probation to run concurrent with count 1 for the defendant to pay a $200 fine.
An additional $200 fine?
Yes, Your Honor.
All right, Mr. Lynch.
Judge, that was our understanding. We would just ask that the court accept the plea as negotiated.
All right, Mr. Arnold, I'm going to accept your plea of guilty to counts 1 and 5 under the first offender statute. On count 1, I'll send you to 12 months probation, a fine in the amount of $200. It'll be $298 with the surcharges, 40 hours of community service, and you're to have no violent or harassing contact with Viviana Garcia. On count 5, I'll accept your plea of guilty to run concurrent with, count one, 12 months probation, a fine in the amount of $200 in addition to the original one. That is an additional $298 total. That, like I said, that will run concurrent with count one. Did you have any questions, sir?
So I will get all this information sent by my lawyer or by the, how would I get all this information about the probation and all that?
You're gonna go into the breakout room with a probation expert, Ms. James. I'm gonna put you in there with her in a moment.
And Your Honor, before he does, the victim is on the platform and would like to make a statement.
Don't speak. They're gonna have a whole another case against us. I'm trying to tell you. They're not gonna stop until I speak. Cause they
Miss
feel
Kent.
like, oh,
Miss
be afraid.
Kent. Miss.
She like reality.
Oh boy, it's too early. All right, where's Miss Garcia?
I'm
Miss
right
Garcia?
here. Can y'all see me or no?
No.
Okay, I'm right here.
All right, Miss Garcia, raise your right hand for me. Just the other hand.
Oh, hold on. This is my straight here.
Solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. All right, Miss Garcia, tell me what you want me to know about this case.
I'm not really sure why they said I had to say anything. I only got.
You don't have to say anything. I thought you indicated to the solicitor's office that you wanted to make a statement, but you're not required to.
Okay, no, ma'am.
All right. Thank you.
Okay.
All right. All right. So, okay. I'm confused. There's no family violence intervention program on here. Can somebody explain for the record why there isn't?
Judge, I think she asked for that. I explained to my client he would have to complete it.
Did ask
Okay.
for.
I'm sorry.
I did ask for a family violence intervention program.
I am low as hell.
Oh, all right. I didn't hear it on the recommendation. All right. And a family violence intervention program on count one. All right. So, Mr. Arnold, I'm going to put you in a breakout room with Ms. James, who is our probation expert. She's going to explain everything that you need to know. But the quickest way to get rearrested is to not attend your probation reports. You have to report for probation as directed, or I will get a warrant and it will be signed and you'll have to appear before the court and you'll be arrested and have to appear before the court. So please make sure that you always attend your probation meetings. I'm going to put you in a breakout room. Is Ms. James doing probation this morning, or is it? Oh, maybe I'm just missing her. Hold on. There's a lot of people on the calendar.
I'm here, Your Honor.
Yes, here she is. There she is. Thank you, Ms. James. All right. So, Ms. James, I'm going to put you in a breakout room with Mr. Arnold. Mr. Arnold, once you have had the opportunity to speak with Ms. James and she completes the intake, you don't have to come back here. Just make sure you do what's required for your probation, okay?
Yes, ma'am.
All right, thank you. All right, any other announcements?
I can't hear. Yes, Judge, I'd like to make an announcement. On behalf of Joseph Ashton, and I'm not sure if he's still on the Zoom. But I spoke with Ms. Payne, we have a negotiated plea.
All right, I see Mr. Ashton. I see you here, please. All right, ladies and gentlemen, everybody that I'm not talking to, you need to mute your device. Everyone who is not being spoken to me to directly right now needs to have your device muted. Right now, I'm talking to Mr. Ashton and the attorney in the courtroom. So everybody else needs to mute. All right. All right, Mr. Ashton, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. You're before the court. Your attorney, has someone else representing you this morning? All right, counsel, for the record, what's your name again? I'm sorry.
Michael DuPont, and I'll And I'd be happy to tell the court exactly what the negotiated plea was.
Hold on just a second. So, Mr. What's he gonna plead to? No license, driving on a suspended or revoked license, or stop or yield sign violation?
To count one, which is no license, I plead a nolo. To count two has been no prost.
Okay.
Count three, stop sign, plead to that. And
No laws?
that's it. Yes, Your Honor.
Okay. All right. So, Mr. Ashton, you're before the court on case 2021 CR 05619. You're entering a plea of nolo to counts 1 and 3. Count 2 will be no prost. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yeah.
All right. Factual basis and recommendation, please.
Yes,
Yes, Your Honor. On February 3rd, 2021, an officer was parked on Lake Ridge Parkway, intersecting with Lake Ridge Circle, and observed a gray Nissan Altima failed to come to a complete stop at that stop sign. He did then initiate a traffic stop and made contact with the driver, who was the defendant. And when he ran his information through GCIC and NCIC, he found that he did not have a valid license on him. And all this occurred in Clayton County. For count 1, the recommendation is just 12 months of probation, and while on probation, pay a $500 fine. Count 2, the state's moving to dismiss. And for count 3, it is 12 months of probation, and while on probation, pay a $100 fine and take a defensive driving class, and probation can terminate upon completion. And it would be running concurrent with count 1.
All right. Counsel, anything on behalf of Mr. Ashton?
Your Honor, that's how I understood the conversation I had with Ms. Payne, and I would urge Mr. Ashton to accept that. I think it's fair. It's a fair offer.
All right. Mr. Ashton, I'm going to accept your plea of nolo to counts 1 and 3. Count 2 will be no prost. I'll sentence you on count 1 to 12 months probation, pay a fine in the amount of $500. It's going to be $737.50 with the surcharges added to it. So that'll be the total. That'll run concurrent with count 3, which is 12 months probation to pay a fine in the amount of $100. That'll be an additional $151.50 total. And you're to take a driver improvement course. Now, are you in the state of Georgia?
No, I live in Maryland.
Okay, so what I need you to do is go to the Maryland Department of Driver Services or Motor Vehicles, whatever they call the licensing bureau, the agency where you go to get your driver's license. Go to their website and find a driver improvement course or a defensive driver course, whatever is approved by the state of Maryland. Take that course and submit that paperwork to probation. Okay, it has to be a state approved course.
Okay.
I don't want you just Googling and getting something online that won't work. Go to Department of Driver Services or whatever bureau in Maryland issues your driver's license, and then find out from them what defensive driver courses or driver improvement courses are approved.
Okay. And I just take that to a probation office?
Yeah, they'll give you a certificate. Your probation officer will allow you to do that. So are you living in Maryland?
Yeah, I live in Maryland.
Okay, so Mr. Ashton, I'm gonna allow you to do phone and mail report, which means that you can report by phone or mail. Let me just say, essentially it is mail. You wanna get your envelopes. You're gonna come back, Mr. Ashton, something happened. You wanna get enough envelopes with the form and mail those in when you're supposed to mail them in, because the quickest way to get rearrested is to fail to report, okay? And the easiest way to report is by mail.
Okay.
All right. So when you have the opportunity to speak with our probation expert, Mr. James, then you're going to talk to her, ask for any questions that might be specific to your situation about living in Maryland and maybe, you know, trying to figure out how best to get all of these things done. Upon completion of all of the requirements, then your probation can terminate. So the quicker that you get these things done, the quicker you'll be off probation. Do you understand?
Yes, ma'am.
All right. So, Mr. Ashton, I'm going to put you in a breakout room with Miss James. You'll hold on just 1 second. All right. You'll be in breakout room. You do not, breakout room number 6, you do not have to come back to the main room once you have done your intake. Okay. All right. All right. Thank you, counsel. You're free to go at this time. All right. Next, do we have another announcement at this time?
Yes, Your Honor. I've spoken to Mr. Dixon about both of his cases, and the victim in the case, Miss Tammy Jones, is present on the Zoom courtroom, and she'd like to make a statement to the court before we make our announcement.
Judge, I would object to that since that he is not pleading to it. So there's no reason for her to be able to make a statement right now.
Yeah, that's kind of interesting.
Then we'll stand by our not guilty on both cases, Your Honor. And Ms. Jones, I appreciate your willingness to speak to the court and to the victim advocate in the matter. I'm sure both of us will be reaching out to you soon in the future.
All right, is the state ready on Dixon?
Yes, Your Honor, the state's ready.
Okay, on both cases?
Yes, Your Honor.
All right, so Mr. Dixon is not guilty and will be going on to the trial calendar. It's a ready announcement.
Hello, you say what now?
It's a ready announcement. You'll be on the trial calendar.
Judge.
What I'm going to trial for, I ain't did that.
Mr. Dixon, you talk too much. You're gonna mess up your whole case.
Mr. Dixon, I'll call you after court. The state has decided they wish to proceed with the prosecution of your case. So I'll explain the details after court's finished. Thank you.
All right. Do we have any other announcements? Yes.
I do apologize to interrupt. So I do have an individual here from the 2 p.m. bond forfeiture calendar, and he does want to resolve his plea. The issue is, and I actually have a letter from his bonding company saying that they didn't get notice of the court. The issue is that he's wanted, and I was hoping we could get his plea taken now before there's a break in court, so the deputy wouldn't have to take him into custody. Is there any, and I have the case number, is there any possibility we could get his plea done before on one of these 10 or 11 o'clock calendars?
Sure.
Okay. So that
Is he ready now?
He's pretty much ready, yes. I don't know if the state's ready though. They told me they may need to wait until 2, but I just wanted to make sure he didn't have.
No, we're not waiting till 2. What's his name?
Your Honor, we have to pull the file.
Go pull it.
To you, Attorney Lynch. So I will
Go
have
pull it.
Arnold pull the file for you.
Yeah, go pull it. When you have it, we'll be ready.
Thank you for that.
Thank you, Judge.
All right, so while we're waiting on announcements, I'm gonna go ahead and call the 11 o'clock calendar. All right, so September 16th, 2024, the 11 a.m. calendar for a calendar call. Crystal Alfaro, Mr. Holt Dennis.
She's present in the courtroom.
Okay, you preach trial?
The state's gonna move to no pros that case.
All right, Alfaro is a no pros. Ms. Alfaro, anyone related to that case, you're free to go at this time. All right, Jamal Leonard Chapital. Jamal Leonard Chapital.
She should be on the online calendar. He had contacted, said there was an issue with his log on, and
Hey, I'm here.
Here.
Okay.
All right. Yeah, it's very important when people you gotta put your name on the screen or else we're looking at just another Samsung. All right. Do you have an announcement for Mr. Chapel?
The state's ready.
Mr. Lynch?
Judge, we just asked for a brief pre-trial.
All right, Hires D. Crawford, Hires Crawford.
I'm here. You can hear me?
Yes, I hear you. Crawford, this is Lester Holton Dennis.
The state's ready, Your Honor.
Judge, we just asked for a pre-trial.
All right. Jaden Ellis Dorsey. Mr. Holton Dennis.
The state's
Jaden.
going to move to null pros that case, Your Honor.
All right, no pros granted.
And if it makes it easier, all the cases in that co-defendant case, the state's moving to null pros.
All right, so that would be Jaden Dorsey, Hobie Dorsey, and I believe Johnson, let's see, Caleb Johnson. Those cases will be no pros. Both Dorseys and Caleb Johnson. You're free to go at this time. All right, the attorney in with the Galaxy S22, I keep muting you because I hear a lot of road noise, but you keep unmuting. I know that you're here, so you can stay muted until you hear your case call.
I'm sorry, Your Honor, I wasn't aware. I thought it was my device doing something.
No, it was me. Thank you.
Okay.
All right, Dontravius Devon Duffy.
In the courtroom, Your Honor.
Ready, Your Honor?
We would just ask for a quick pre-trial. We'll have an announcement shortly.
Okay, Kalia Marcinet Gay.
Ms. Gay, are you on the online calendar? Judge, so for Ms. Gay, I did.
State's actually going to move to null pros that, Mr. Lynch.
All right, Mr. Lynch, that's going to be no pros.
Beautiful.
All right. It's his name, Herschel Van Hall.
Mr. Hall is present in the courtroom, Judge. I did speak with him. We would hope for the state's announcement, but I think, if I'm not mistaken, he wants to resolve the first case. And then the second case, I may need to pre-try with the state.
All right, Hall, state's ready.
The state is ready. I was just going to let Mr. Lynch know my offer was actually going to be to dismiss the first case and plead to the failure to yield row and leaving the scene. The state's ready on both.
So I guess maybe I would just ask for a conference with the state. I think we probably can find a resolution based on what she's telling me. I just want to.
All right, state. I'll give you a breakout room in a moment. Allred Jamar Jackson. Allred.
He is present in the courtroom, Judge. And I know he's on the motion calendar. I would just ask for a conference with the state.
Okay.
I'm not sure what the state's announcement is.
All right.
State's ready, I'm sorry.
Rodney Edward Jarrell.
Good morning, Your Honor. That is my case. I'm
morning.
Attorney Ghazi. I represent Mr. Jarrell, and we have reached a resolution with the state and are ready to proceed at Your Honor's convenience.
All right, as soon as I finish the call of the calendar, we'll take the plea.
Thank you, Your Honor.
All right, Caleb Johnson, that case has been no prossed. All right, next case is Nicholas Antoine Johnson.
Here.
Your Honor, the state's going to non-cross that case.
All right, Mr. Nicholas Antoine Johnson, your case has been no prossed. You're free to go at this time, sir.
Okay, thank you.
You're welcome. Jonathan Leroy Kane. Jonathan Leroy Kane.
Mr. Kane?
Yes, how you doing?
Yes, I did speak to Mr. Kane, prior to court. If I could just have a brief pretrial conference after the state's announcement, I think we might, so I can just remember what our announcement is gonna be.
Okay.
No, the site is ready on this case.
Okay, LaTresa Osa Kirkland. Ms. Gatson.
Good morning, Judge.
Good morning, Ms. Gatson.
What say the state? It's, the state's gonna knock off this case.
All right.
On, you're not gonna start on, but nevertheless. Kirkland is here. Okay, thank you. And we have no objection to non-cross, Judge.
All right, Ms. Gatson, thank you. Kirkland will be no pros. Ms. Gatson, did you have any other cases on the calendar?
No, Judge, may I be excused?
Yes, ma'am. How's your son doing?
He's doing great, thank you.
Good. Tell him his old teacher's wife asked about him.
I will, thank you so much. Have a great day.
Yes, sir.
If we could go back to Mr. Kane, I do apologize. I had to pull up my notes. We were gonna announce ready on Mr. Kane's case as well.
Okay, you ready for trial? State's ready on Kane?
Yes, Your Honor.
All right, so that'll go on to the trial calendar. All right, Christy Latrice Mitchell. 2 cases, Christy Latrice Mitchell. Last call for Christy Latrice Mitchell.
The state removed for bench warrant and bond for case. She actually has 5 cases on the calendar, Judge.
She got what?
5 cases on the calendar.
Oh, and she got the nerve to not be here. Lester Holt Dennis has the last one. Have y'all talked to her, heard from her?
Judge, I've reached out, but we don't have a big phone.
Okay, well, when these 5 bench warrants go out, y'all will hear from her. Bench warrant bond forfeiture on all 5 cases.
Thank you, Judge.
All right. Jade Wondrell Moore.
Ms. Moore should be online. I did speak to her. Ms. Moore? Jade Moore? Ms. Jade Moore?
Jade Wondrell Moore.
Excuse me, Your Honor.
Yes, sir.
Are you guys done with me?
Yes, sir, Mr. Kane. You've announced ready, so Mr. Kane.
My phone, I'm sorry.
Keep in touch. Hey, Ms. Moore, hold on just a second for me. Keep in touch with your attorney. Mr. Kane, see, if you have bond conditions that require you to stay away from a particular person and possibly a location, please do not violate your bond conditions. If you were to do so, you could be arrested and remain in jail until your case is resolved. You could be charged with additional misdemeanors or felonies, okay?
Yes, ma'am.
If you don't have a copy of your bond conditions and you need one, you can get one at the clerk's office on the 1st floor at 9151 Terra Boulevard.
Yes, I don't even live on that side of town. Well, that's fine.
All right, then.
Yes,
Thank you, sir. Take care.
Okay,
And
thank
keep
you.
in touch with your attorney, Mr. Kane.
All right.
All right, Ms. Moore is here.
Your Honor, it's on a non-process case.
All right, Ms. Moore, your case will be no prost.
Thank you. No objection.
Can
All
I
right.
ask, what does that mean? I'm sorry.
Ms. Moore, you had a question?
Yes, what does the non-prosecute case mean?
No problem. So the case is, the state has decided not to pursue prosecution of the case. They do have 6 months to bring it back if they should change their mind. But at this time, the case is not being pursued and it will, in effect, dismissed after 6 months.
Thank you so much.
You're welcome, ma'am.
You have a good one.
You too. Thank you.
Hello, Judge.
Yes, ma'am.
My name is Angela Jarrell. For Rodney Jarrell, I was told I was subpoenaed on here, but do I continue to have to be on here?
Just for a few moments, ma'am. He's going to take a plea, but I don't like to release everybody until that is complete. And when I finish the calendar, we're going to take that plea.
Yes, ma'am. Thank you.
All right. Thank you for your patience. All right. Quantavine Andre Page. Quantavine Page.
He's in the courtroom, Your Honor.
All right, Mr.
On the
Page.
state's on a non-process case.
Mr. Page, your case is being no process. You're free to go at this time. Please be careful. All right, so after the call of the calendar, the cases that I have that need pretrial are Chapel, Crawford, Duffy, Hall, Jackson, Mitchell. No, Mitchell, I'm sorry, was a bench warrant for Hall and Jackson, and Jarrell is a plea. Kane is an already announcement, so that's going on to the trial calendar. All right, we're ready on Jarrell?
Yes, Your Honor.
All right, Mr. Rodney Edward Jarrell. Mr. Jarrell? Mr. Jarrell, you gotta speak up.
Are you referring to me or Mr. Jarrell?
Mr. Jarrell, I have two Angela Jarrells. Is your phone not, I see you on one and I hear you on the other.
Yes, I'm having issues. I just got a new phone, so I'm having issues trying to stay on. So I have you on my laptop and my phone, but I can't hear you on my laptop.
Okay, no problem. All right, counsel, do you know where your client is? Is he in court or is he supposed to be on the calendar? Because I'm looking.
He's muted. The attorney is muted.
Sir, you're gonna have to unmute, Mr. Ghazi.
Can you hear me, Your Honor?
I hear you now.
Okay, thank you. My client. My client is supposed to be online, Your Honor.
Rodney Jarrell. All right, there you are. All right, so Mr. Jarrell, I need to see you.
You see me?
No.
You don't?
No.
What I need to do?
Hold on, Mr. Jarrell. Hold on. I'm gonna send something to you. If you see it, click on it, okay? All right, so hold on. Let me see, start video. Let's see if that works. There you go. Not sure why that works, but it usually does. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right. Mr. Jarrell, you're before the court on State of Georgia versus Rodney Edward Jarrell, 2021 CR 06180. You're charged with simple battery, family violence, simple battery, and criminal trespass. You're represented by Attorney David Ghazi, who's here with you on video. Mr. Ghazi, there you are. All right. Mr. Ghazi, what is your client plea to the offenses before the court?
Your Honor, it's our understanding the state has amended the accusation to a disorderly conduct, and Mr. Jarrell is pleading to disorderly conduct with a $300 fine and a domestic violence. I'm not sure. I don't think he has to take a domestic violence course. I think it is just the $300 fine, Your Honor.
Okay, hold on. Ms. Hagler, are you adding it and then no processing counts 1, 2, 3, or are you changing one of the counts that is existing?
Yes, Your Honor. I am not processing counts 1 through 3.
Okay, and then adding a 4, which is the state domestic disorderly conduct.
Yes, it should already be. I did it this morning, so
That's okay. I'm looking at my calendar, which was printed a while ago. So it's done in the system. I just don't see it.
Okay, yes, ma'am.
So by entering a plea of guilty to to disorderly conduct on count 4, counts 1, 2, and 3 will be no pros. Mr. Jarrell, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right.
But
Mr. Jarrell, please address the court as Your Honor. Your Honor.
Yes, ma'am, it's fine. That works. I'm fine. I'm just keen to get this plea done.
Your Honor, can I say one thing?
No, Mr. Jarrell, now that I won't countenance because you're represented by counsel and your attorney knows what words work with the court and don't work with the court. It's probably best that you don't say anything right now. Okay, let me hear from the state first. All right. All right, Ms. Hayward.
Thank you, Judge. On or about June 2nd of 2019, Sergeant M. Carver was dispatched to 115 Nina, N-I-N-A Court, Jonesboro, Clayton County, Georgia. Pursuant to the warrant, the defendant did intentionally batter his ex-wife, also the victim in this case, Angela C. Jarrell, by slamming the victim's driver's side vehicle door on the victim and by grabbing the victim by the neck. Your Honor, at this time, count 4 is going to be a fine of $300 and to have no violent or harassing contact with the victim, Angela Jarrell.
All right. Mr. Ghazi, anything on behalf of your client?
No, Your Honor. We would just ask the court to accept the negotiated deal. I can say that this is a case that I think that was brought around the time of COVID. So Rodney has been waiting a long time to get this behind him. He's had no further issues in this regard at all. It's done what he's supposed to do, and I don't think he will violate the laws any further. And we just ask the court to accept the negotiated deal that's been presented.
All right, Ms. Jarrell, you've been waiting. Did you have anything at this time? I know you were subpoenaed to be here. You may not have a statement, but if you wish to be heard, the court will hear you.
No, I don't have anything.
All right. All right. I recognize that this was back in the dark days of the pandemic, and a lot of people got on each other's nerves and things went left. And so I understand that. Doesn't make it any less of a serious situation for the court, but I do understand that we had an elevation in these types of incidents during that period of time. And it's been a long time. So Mr. Jarrell, the court takes all of that into consideration, as did your attorney and the state, obviously with the recommendation that they have. So I'm going to accept your plea of guilty to disorderly conduct. I'll sentence you to pay a fine in the amount of $300 with the surcharges. It's going to be $444 total. And you're to have no violent or harassing contact with Miss Angela Jarrell. With respect to paying the fines and fees, did you need more than 60 days to pay the fines and fees? I would have given you 30 anyway, because you're not at the courthouse. But if you need more than 60 days to pay, we have a probation option that may work for you, which is paid only probation.
I'm good with the 30.
Okay. Well, I'm gonna give you 60 days, Mr. Jarrell, because you might be able to get it here within the 30, but I'll go ahead and give you the 60 days. Just make sure that you pay it on or before the 60th day. Now, this is what I'm going to ask you to do. Do you know how to use the chat function, sir?
No, ma'am.
Okay. So what Miss Wright, can you chat Mr. Jarrell, Rodney Rock Jarrell, a test chat? So when you see the red number pop up on your screen, you're going to click on that. You're going to send your email address directly back to Miss Wright, not to everybody, but just to Miss Wright. When you send it, make sure you check to make sure you have all the letters and numbers and everything in the right place. And then she's going to send you your sentencing sheet by email. So check either tomorrow or the next day. Look in your spam folder if you don't see it, and it'll have instructions about how to pay in person, how to pay online, or how to pay by phone. Okay.
Yes, ma'am.
All right. Did you have any other questions, sir?
No, I don't.
Okay. Let me know when you've sent that. It should come from Amanda Wright, R-Y-T.
Yeah, I seen it, and then it jumped off.
Just touch your screen. It should still be there. If you're looking for chat, you're looking for whatever's sitting there with a red number on it. You see it?
No, ma'am. Let me see, huh?
Touch right next to, do you see something that says participants?
No, ma'am. My screen just got all y'all blocks and my picture. That's it.
Okay, when you touch your picture, what does it show?
It shows none and blur on the backgrounds, and it's got video filters.
No, look at the bottom of your screen.
Okay, hold on. My screen. I don't have any of the functions on my phone. The only thing I can do is make my my box go big and large. That's the only function I have. She sent me that link. She sent me that link. When I got ready to click on it, it was in the message. And I got ready to click on it, I seen it said direct. And when I matched on it, matched on that red, it didn't it went away.
Okay. I'm not sure.
Can she do it one more time? I tried again.
Miss Wright, can you send it again, please? I'm sorry.
Okay, there it is. There it is. Okay, I hit it.
Okay.
Okay.
Did it open?
Yes, man, I see it. Let's try it again. Okay, so. Okay, I got you. All right.
All right. Now, in that box, type your email address and then send it back to Miss Wright.
Okay.
All right. When you're done sending that, you are free to go. Miss Jarrell, you're free to go. And Mr. Ghazi, you'll be free to go.
Okay.
All right. Thank you all.
Thank you, Your Honor.
All right. Take care, sir.
Thank you.
All right. Thank you, sir. All right. So the remaining cases are Chapel, Crawford, Duffy, Hall, Jackson. All right. And Mr. Lynch or Mr. Taylor, let me know if you need to have a breakout room with either of the solicitors. And remember, we also have cases still on the 10 o'clock that we were waiting on announcements. I think we have Black. Well, no, I'm sorry. We have Bullock, Cruz, Drake, Love, the inmate case, and Pratt. And Madison, I'm sorry. So we got quite a few from the 10 a.m. still. So I'm going to, ladies and gentlemen, Mr. Jarrell, you're free to go at this time, sir.
Okay.
Ladies and gentlemen, the lawyers are addressing each of your cases. They're going to get to you as quickly as they can. Please have patience. If I have already announced one of the cases, then if you're here for one of those cases, you're free to go. So these are the cases that the court has already resolved or that are going on to the trial calendar. So that would be from the 10 a.m. calendar: Arnold, Ashton, Black, Fuenzalida, Laney, Mosley, Pennington, Ward, Williams, and Wilson. If you're here on any of those cases, you're free to go at this time. On the 11 o'clock calendar, Alfaro, Dorsey, there are two Dorseys, Gay, Jarrell, Johnson, two Johnsons, Johnson, Kirkland, Mitchell, Moore, Page. If you're here on any of those cases, you're free to go at this time. Everyone else, just hold on for me. The attorneys are going to meet with the state and with their clients. All right. And I'll accept the announcements as they come in.
Yes.
I'm trying to reach out. I'm trying to get an offer for Mr. Pratt. Find out what the offer is on the traffic cases and to confirm. I mean, I have what's on the discovery for the other case. I just need to verify that that's the case.
Okay, please stand by.
Mr. Lynch, is Hall going to accept the plea deal to dismiss the criminal trespass and plea to the failure to yield and leaving the scene of the accident?
Haven't had a chance to talk to him. But so the leaving the scene of the accident is going to be the issue.
In what way? No.
I mean, I don't know if we need to be in a breakout room for this, but there's some funny business going on because he waited on the, well, I can get into the facts with you in a breakout room if you want.
That's fine. I don't mind doing that.
I don't know how to create a breakout room though.
I don't believe we have the permission to do it. The host has to do it.
If you want to just.
Hold on. Got you. Ms. Payne, courtroom. Courtroom 3, breakout room number 3 for Ms. Payne in the courtroom.
Is that better, Your Honor?
Yes, much.
Thank you. For Jamal Chapito, we are standing with our ready announcement.
All right, state ready on Chapel. Is that Ms. Payne?
Your Honor, the state's ready. Sorry, I was locating my calendar for it.
No problem. So Chapel is ready and it will go on the trial calendar. On the trial calendar.
In Your
All
Honor,
right. Yes.
Crawford, same announcement. We're standing on our not guilty and we are ready to proceed.
And I'm sorry, that's Duffy, you said?
Crawford, Mr. Crawford on the 11th.
All righty.
Okay.
For Crawford, is the state ready?
Yes, Your Honor.
Okay, that goes on the trial calendar.
Thank you, Your Honor.
All right. Still waiting on an from 10 o'clock on Bullock and Cruz, Drake and Madison and Love. And Pratt, I'm sorry. I'm sorry, Mr. Pratt. I'm not intentionally skipping you. It's just the way I made my notes. I messed up.
It's okay, Judge.
All right. Thank you all for your patience. I know that this can seem kind of like nerve-wracking. You're waiting to hear something, but the attorneys are working on this. I'm happy to have 2 solicitors today, so it actually is going a little quicker than usual because we have 2 people to share the load. So I'm appreciative of that. And we'll get right back to you.
Your Honor, I have an announcement for the 10 o'clock calendar.
Yes, sir.
Mr. Benjamin Bullock, we are standing on our not guilty. We are ready to proceed.
What say ye the state?
State's ready, Your Honor.
Okay, Bullock will go on to the trial calendar. That's from the 10 a.m. calendar. Mr. Bullock. It's a ready announcement. All right, everyone associated with that case, we'll see you at the next trial calendar. Anything else, Mr. Taylor? Mr. Lynch? All right, I'll wait for the next announcement.
Judge, I have a couple announcements.
Yes, sir.
So Mr. Hall, I think he's on the 11 o'clock calendar. He's ready for a negotiated plea.
All right, Mr. Hall, come on up.
And I know that the state has offered to reduce the leaving the scene of an accident to a failure to report an accident.
That is correct. I would need a chance to do that. I was waiting on confirmation from Mr. Lynch to reduce that. So I haven't amended it yet, but I can amend it now.
All right, let me know when you're ready. Did you have another announcement, Mr. Lynch?
Yes, Judge. So for Mr. Pratt, we are going to resolve the simple battery case.
Okay.
And I'm waiting because I don't have an offer on the license case. The state.
I sent Attorney Taylor a question for you in the chat.
Yeah, and I answered it. He doesn't.
Did you? Let me see. Okay. Okay, stand by. Thank you.
Also, if I could just ask which solicitor is handling DeMarco Drake, because I would like a very brief conference on that matter.
I am handling it, Mr. Lynch. I do believe I sent the offer to Mr. Taylor in the chat.
Yeah, we have it. Can you just look at your chat so I can see if we can get a resolution?
Yeah, look at my chat. I don't have a response from him. Your Honor, whenever Mr. Lynch in the court is ready, I have amended Mr. Hall's accusation.
And we are ready to go forward on Mr. Hall.
Mr. Hall, raise your right hand for me. Where's Mr. Hall? You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down, sir. You're before the court on State of Georgia. State of Georgia versus Herschel Van Hall. Case 2021 CR 06160 is criminal trespass. Mr. Lynch, how does your client plead to the offense before the court?
Your Honor, the criminal trespass case is going to be a null pros pursuant to the plea. for the two traffic offenses, the now amended.
That is correct, Judge.
All right. Sir, you're before the court on case 2022 CR 04994 for failure to yield the right of way when leaving the scene.
He's going to enter a no contest plea to the failure to yield and a no contest plea to failure to report. The leaving the scene would be null pros pursuant to my understanding.
I did amend it to leaving the scene shouldn't even be on there. It should just be failure to yield and failure to report.
All right, and we'll do a NOLOs to both.
Yes, Judge.
All right, by entering a NOLO to counts 1 and 2, the amended complaint, the amended accusation of failure to yield the right of way and failure to make a report, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right, factual basis and recommendation, please.
Yes, Your Honor. On about 1st, 2022, officers responded to Terra Boulevard where it intersects with Sherwood Drive in reference to a vehicle accident and made contact with the driver vehicle number 2, Larita Davis. And Ms. Davis stated that she was in the far right lane traveling southbound on Terra Boulevard when she was passing the intersection of Terra Boulevard and Sherwood Drive. And the defendant then made a left turn into her apartment complex and hit her vehicle. And the defendant then proceeded to go into the apartment complex to his home and didn't report the accident that had an apparent damage of $500 or more. And all this occurred in Clayton County. The negotiated plea is that 2021 CR 06160 would be dismissed and plea to this case 2022 CR 04994, with count 1 being a $100 fine suspended and count 2 being 12 months of probation to pay a $300 fine, take a defensive driving class, and probation can terminate upon completion of the special conditions.
All right. Mr. Lynch, anything on behalf of Mr. Hall?
Yeah, just a few things on behalf of him with regards to this case. Well, we do appreciate the state reducing the charge to failure to report, and he has decided he wants to get this matter behind him and enter a no contest plea to that charge. Just a couple of things. This accident happened. There was a funeral procession. The accident happened around noon. The other driver, the other vehicle did not remain at the scene. My client remained at his house, which is in pulled into his house, with not an apartment complex, which is in sight distance from the scene. The other vehicle was gone. Then later at around 5 p.m., so some 5 hours later, which I believe is reflected on the police report, police knocked on his door and ended up taking him into custody for leaving the scene of an accident. He certainly didn't intend to leave the scene of any accident. And I'm not sure what the discrepancy is with the time. I won't stipulate, but Judge, my client's 72 years old. He's currently retired, although he's trying to get some more employment. We just asked the court waive the probation fees and allow his probation to terminate once he pays that fine and takes that defensive driving course.
All right, that sounds good. All right, so, sir, I'm going to accept your plea of no load to counts 1 and 2. I'll send you on count 1 to a $100 fine suspended. That will run concurrent with count 2, 12 months probation to pay a fine in the amount of $300. Your supervision fees will be suspended. The fine itself will be $300 with the surcharges. The total will be $444. And the driver improvement course, I want you to go to the Department of Driver Services website or go to the actual Department of Driver Services and get the driver improvement courses that are recommended by the Department of Driver Services. And once you get those recommendations, take one of the courses that's on the list. You'll bring in your proof to probation. Once you've paid the $444 and brought in your proof of having taken a driver improvement course, then your probation will terminate. So as quickly as you do those things, it will terminate. Before you leave the courthouse, I'm going to ask you to exit the courtroom, go out, turn to your right, go to courtroom 305, go in through the double doors and speak with Ms. James to get signed up. Ask her any questions that you might have regarding any of the sentence that I've given you today, okay?
Okay.
All right, thank you, sir. Be safe. All right, any other announcements?
Judge, let me make a quick phone call. I think we'll have something on Pratt.
Okay, thank you.
Ms. Mitchell is present in the courtroom.
Judge, Ms.
Mr. Mitchell,
Courtroom, is that Latrice?
I'm sorry, what now?
Latrice Mitchell is present in the courtroom, Judge.
Okay, so she had a bench warrant bond forfeiture. Why is she late?
She had a school meeting with her son, and she called our office to let us know that she was going to be late. I just found out from
Judge, she had reached out to our office to let us know that she had to go to a school meeting with her son. So that's why she's late. She had to attend a meeting with her son.
Okay. Okay, what's going to happen with all 5 of her cases?
We're waiting for the state's recommendation.
Waiting for recommendations from the state, Your Honor.
All right, y'all work on that.
Your Honor.
Yes.
Hi, my name is Mary Kent. I was coming on behalf of Jamal Chapatel. Could I leave now?
Yes, Mr. Chapatel has announced ready, so you may be called upon for the trial. Be mindful that someone may reach out to you for that and you may be under subpoena, but other than that, you're free to go at this time. Thank you.
Okay, so do I come back? Oh, you said somebody called me and then I come back on here?
No, you're finished today, but he may be going to trial with his case, so you may be called for a trial.
Okay.
All right, but the state victim witness advocate will reach out to you if that is the case, okay?
Okay, thank you.
All right, thank you. You free to go at this time.
Yes, ma'am.
Yes, Your Honor. My battery went out on my phone. I just logged back on. I was trying to see if I missed anything. This is Jamal Chapatel.
Mr. Chapatel, you're free to go at this time. Your attorney announced ready, which means that he'll continue to speak with the state regarding your case, but you all will appear for trial on the next trial calendar and you'll receive notice.
Okay, you know what date is that?
Ms. Val, do we have a date for these cases or are we just sending notice?
October 21st, but notice still will be sent.
We're sending notice, but it'll be October 21st and it's in court, so you can't appear by video for the trial.
Okay.
All right. Thank you, sir. But please keep in touch with your attorney. Things may change on your, on your end if something else comes through.
Okay.
All right. Thank you.
Thank you. Have a good day.
You too.
Your Honor, I have an announcement.
Yes, sir.
Off the 10 o'clock calendar, Joshua Pratt is going to enter a plea on 2022 CR 06719, the simple battery family violence.
All right.
And we were just appointed on the license case.
Okay.
We're hoping to get that resolved. I think he's in the process of getting his license. So we're just going to announce ready and have that go on the trial calendar and hopefully have a resolution. We also need to make sure we do our due diligence as far as, the number of charges he's had. But I think we can get a resolution on the trial calendar for that. But we wanted to go ahead and resolve the simple battery case today pursuant to the state's offer.
All right. So on the case 2021 CR 08693, you all are announcing ready.
Yes, Judge.
What's the state's announcement?
I'm sorry, what case is this? Your
Mr.
Honor?
Pratt, driving on a suspended or revoked license and no license case, 2021 CR 08693.
Okay, yes, I need to send an amendment, but nevertheless, we're ready.
Okay, so that'll go on the trial calendar. Y'all can resolve it in the interim or resolve it on trial day. But that one will go on the trial calendar. Then the simple battery case, Mr. Pratt, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. You gotta unmute for me.
Yes, ma'am.
All right, you can put your hand down. You're before the court on 2022 CR 06719 for simple battery, family violence, and simple battery. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Lynch, what did your client plead to the offenses before the court?
Guilty to count one.
All right. By entering a plea of guilty to count one, count two will merge. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about May 27th of 2021, Officer C. Reynolds responded to 9224 Raven RABS Victor EN Drive, Jonesboro 30238, Clayton County, Georgia. In regards to a domestic dispute, according to the probable cause affidavit, the defendant was charged with simple battery, family violence, because he pushed the victim's head, Ms. Dionca Freeman, into the couch and restrained her arms, keeping her from moving or defending herself. Your Honor, at this time, the for count one is going to be 12 months to serve, 5 days, community time served. The probable cause affidavit, the defendant was charged with simple battery, family violence, because he pushed the victim's head, Ms. Dionca Freeman, into the couch and restrained her arms, keeping her from moving or defending herself. Your Honor, at this time, the for count one is going to be 12 months to serve, 5 days, community time served, balance probated, a fine of $200, 20 hours of community service to complete the family violence intervention program, and to have no violent or harassing contact with the victim, Ms. Dionca Freeman, and count two will merge into count one.
All right. Anything on behalf of your client, Mr. Lynch?
No, Judge, not at this time. We ask the court accept as negotiated.
All right. So, Mr. Pratt, I'm going to accept your plea of guilty on case 2022 CR 06719. You're going to be sentenced to 12 months to serve 5 days. Credit for time served. Balance will be probated for you to pay a fine in the amount of $200. That'll be $298 with the surcharges. 20 hours of community service, the family violence intervention program, and no violent or harassing contact with Ms. Dionca Freeman. I'm going to put you in a breakout room with our probation expert. She's going to explain everything you need to know about probation. If there are any questions specific to your situation, please ask those questions. The quickest way to get rearrested is to fail to appear for your probation report. So please make sure you report for probation as directed. All right. Did you have any questions before I put you in the breakout room, sir?
Yes, ma'am. So by me
I'm already on probation. So will this be like two different?
I don't know where you're on probation.
Put some water in the fridge, please.
You judge. I understand he is on probation for another case unrelated in terms of people, but he's on probation with you for another case that is actually, well, for another misdemeanor case.
Mr. Pratt, check with your probation officer, ask them those questions because I don't manage probation. But I would advise, sir, that every misdemeanor you commit in Clayton County is going to come back to me. We don't want to keep meeting like this, sir.
No, ma'am.
Okay? So I would just advise that you govern yourself accordingly because there's no reason for us to just keep coming back in this cycle of probation. We're clear?
Not at all. Yes, ma'am.
All right. You're a grown-up. We need you to make some grown-up decisions and think about some grown-up consequences for our behavior, correct?
Yes, ma'am.
All right. So I'm going to put you in the breakout room with Miss James. And once you're finished speaking with her, you'll be free to go, okay?
Yes, ma'am.
All right. Thank you. All right. Did you have another announcement?
I don't currently judge. I'm just trying to figure out where I am so I can make a few more announcements for you.
Okay. So let me know when you're done. We'll be back.
Can I ask who's handling Miss Love, Sierra Love?
I believe that's Miss Hagler's case. What is the question?
Miss Love, are you handling Miss Love?
I am. I think you have the offer already.
I know, I was gonna ask you a question about that. If we could maybe do a breakout room?
That's fine. I'm not sure if Judge Hayward, ma'am, are you still on? She will have to do it for us.
I got you.
Okay, thank you.
Breakout room number 2.
Thank you.
All right, ladies and gentlemen, while we are waiting for announcements on these 2 remaining calendars, I'm going to call the 1 p.m. calendar. This is the suspended sentence calendar. So for those people who are here for the 1 p.m. calendar, the purpose of the calendar is that you were previously given a fine that needed to be paid within a certain amount of time. You haven't paid it within that certain amount of time. This is an opportunity for you to request additional time to pay the fines and fees. So if you respond to this calendar, I'm going to put you in a breakout room with the staff attorney for the court, Ms. Powell. Ms. Powell is going to discuss with you the opportunity to have more time to pay. This is your one and final time to get a modification and have additional time to pay. If you don't complete it by the end of this period, then the court is going to issue an arrest warrant. For those people who don't respond to the calendar and who are coming to court today for this calendar, they will receive immediate arrest warrants and they will resolve the case once they're picked up and placed in the Clayton County Jail. Okay, so at this time, I'm going to call the SSD calendar for September 16th, 2024, 1 p.m. If you are present for that calendar, please let me know so that we can make sure that I put you in a breakout room with Ms. Powell. Okay, the first person on the calendar. Take a look at the same time. The first person on the calendar is Edwin Alexander. Edwin Alexander. Last call for Edwin Alexander. An arrest warrant will issue. Next is Radiance Baker. Radiance Baker. Last call for Radiance Baker. An arrest warrant will issue. Next is Mariama Bald. Mariama Bald. B-A-L-D-E. Mariama Bald. An arrest warrant will issue. Next calendar is Shadray LaQuise Blake. Shadray Laquise Blake. Last call for Shadray Laquise Blake. An arrest warrant will issue. Next is Mila Burton. Mila Burton. Last call for Mila Burton. Arrest warrant will issue. Kinsey Cantrell Cole. Kinsey Cantrell Cole. Last call for Kinsey Cantrell Cole. An arrest warrant will issue. Jershawn D'Angelo Crawl. Jershawn D'Angelo Crawl. Last call for Jershawn D'Angelo Crawl. An arrest warrant will issue. Gerard Davis. Gerard Davis has 2 cases. Gerard Davis. Last call for Gerard Davis. An arrest warrant will issue. Reginald Liddell Evans. Reginald Liddell Evans. Last call for Reginald Liddell Evans. Arrest warrant will issue. Corey Brandon Henry. Corey Brandon Henry. Last call for Corey Brandon Henry. Arrest warrant will issue. Alicia Elaine Howliett. Alicia Elaine Howliett. Last call for Alicia Elaine Howliett. Arrest warrant will issue. Eric Antoine Jackson. Eric Antoine Jackson. Last call for Eric Antoine Jackson. An arrest warrant will issue. Shazia Irene Lopez. Shaasia. Is it Shaasia? Irene Lopez. Lopez. Last call. Miss Powell, look at that one. That might need a, I think based on what's been done, that might need a different modification. Just send me a chat.
Yes, ma'am.
All right. Elsie S. Morales. Elsie S. Morales. Last call for Morales. Arrest warrant will issue. All right, that concludes the calendar. No one has appeared for the 1 p.m. calendar. No one is in court for the 1 p.m. calendar. No one is online for the one. Ma'am, who's eating? Are you here for the SSD calendar? Ma'am in the blue robe, you're eating something with the glasses. What calendar are you here for, ma'am? You have to unmute. Gray hair, glasses, blue robe, eating something. Ma'am, can you hear me? You're in a house with white walls and brown trim, brown wood trim. Hello?
Judge, I don't know if it makes a difference, but that participant has been on since 10.
Yeah, she was under my name at first.
Yes.
So I'm not sure who she is. All right. All right, so Ms. Powell, that concludes the SSD calendar. Thank you.
Thank you, Judge. I'll get that order to you.
All right, thank you. All right, so Mr. Lynch, Mr. Taylor.
Yes, Your Honor.
We got any announcements?
We're ready to proceed with Ms. Mitchell's cases from the 11 o'clock calendar.
Righty then. Ms. Mitchell, come forward. Raise your right hand for me, Ms. Mitchell. You solemnly swear or affirm any testimony you give in this matter will be true? I'm sorry?
I do.
Okay, you can put your hand out. Come forward a little bit so I can hear you a little bit better. Ms. Mitchell, you're doing a lot. You got 5 cases, ma'am. That sets the record for the last couple of months. Why you can't drive?
Your Honor, on Ms. Mitchell's behalf, I will say that she has taken multiple steps to address her driving
Well, I hope so. Ms. Mitchell, you said that she was late because she had to attend her son's school. If you're driving around with a child in the car and you get a ticket every 6 months, something's wrong with that. That's not something to be proud of. One, it sets a really bad example for your child that mama can't stay out of the courthouse. And 2, you're putting them at risk if you don't know how to drive.
Yes, Your Honor.
I just, I need you to get it together, Ms. Mitchell. I mean, at some point, we got to grow up and be parents and responsible adults. We can't keep running around here like we in our 20s and we don't have a thought in the world about what makes sense to do. Okay. So you're before the court. Guys, put up a separate page for you. You got so many cases. You're before the court on case 2021 CR 06608, improper turn, improper signal, improper turn at intersection, and marijuana 1 ounce or less.
Your Honor, I believe the state intends to null process that case.
Yes, Your Honor. The state is going to null process case number 20216 CR 06608. The state is also going to null process case number 2023 CR 06971. And then finally, Your Honor, the state is going to null process case number 2023 CR 10391.
All right. So the state has announced a null process on 2021 CR 06608, 2023 CR 06971, 2023 CR 10391, and on the remaining case, 2023 CR, wait a minute, this is something. Oh, 202 CR 06971, 202 CR 6608, and okay, so the remaining 2 cases, 2023 CR 10392 for speeding, and 2023 CR 10497 for speeding and improper passing. What is your client plead to the offenses on those cases?
Thank you, Your Honor. To case 2023 CR 10392, we are pleading nolo contendere.
All right.
And to case 2023 CR 10497, we are pleading guilty to the speeding charge and the improper passing.
Guilty to both?
That's correct, Your Honor. So the first one being a nolo, the second one, we're no longer nolo eligible.
All right. So Ms. Mitchell, by interim plea of nolo on case 2023 CR 10392 and guilty on counts 1 and 2 on case 2023 CR 10497, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself, or you should not present evidence and testimony against yourself or incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, Ms. Mitchell?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. In regards to case ending in 10392, on or about August 26th of 2023, Lieutenant Murphy issued the defendant a traffic citation for speeding. The defendant was going 86 miles per hour in a 65 mile per hour zone. The state's recommendation for this case is a fine of $500. Regarding case ending in 10497, on or about June 30th of 2021, Officer Jonathan Carey, Jonathan Carey, issued the defendant a traffic citation for speeding in which she was going 65 miles per hour in a 45 miles per hour zone. And she was also given a citation for improper passing on the left. The state's recommendation for this case, for count one, a fine of $150, and for count two, a fine of $100.
All right. So, Mr. Taylor, anything on behalf of Ms. Mitchell?
Your Honor, I would just like to point out that since these citations have occurred, Ms. Mitchell is taking both a Georgia Department of Driver Services driver improvement class and a Georgia defensive driving course offered by the National Highway Safety Administration. I provided proof of these to the solicitor in consideration for her to consider in making the necessary pleas. I just wanted to make the court aware that Ms. Mitchell is taking big steps to improve her driving, and we don't anticipate seeing her back in our courtroom.
Good, Ms. Mitchell, because I mean, aside from the fact that you got a bunch of cases, you got kids, and they can't afford to have anything happen to you, and you can't afford to have anything happen to them because of your driving. You can only drive for yourself, and if you observe the rules of the road, it's less likely that you're going to be involved in an accident. Okay? All right, so on case 2023-CR-10392, I'll accept your plea of nolo. I'll send you to pay a fine in the amount of $500. It'll be $737.50 with the surcharges. I can give you up to 60 days without putting you on probation, but I also have a probation option because on case 20CR-10497, count one is $150, which it's going to be 200 and something with the surcharges. I can't remember what that one is. But on the next one, on the guilty for count two, $100, that's going to be $150. So we're looking at an additional probably $400 on the second case. That's going to run concurrent, which means the same time as the first case. So I can give you up to 12 months pay only probation to pay all of the fines and fees if you wish to do that. But I just called the SSD calendar. That was the calendar where I gave people 60 days to pay and they didn't pay. So now all of them are going to get arrested for failure to complete an SSD. So please think carefully about how much time it's going to take you to pay this amount of money.
Well, I rather the SSD because I can go to the clerk and pay my money because I have the money at the clerk's office. Well, he said it was not at the clerk.
Your Honor, she posted her own bond, so she anticipates receiving the majority of her bond back, and that will allow her to pay the fees.
All right, so yeah, she put a bond up on one of the cases. The other ones don't have bonds. So I'm going to give you 60 days in which to pay. That should give you time to get your bond back from the sheriff's office and apply that and then pay the remainder. But like I said, please make sure you pay on or before the 60th day, preferably before, because you just never know what might happen. Computer goes down, then behind. So go to the sheriff's office. They'll be able to pull up that you've resolved all of your cases. And then once you do that, then you can take that money and apply it to your bond. It's not automatic. It's like the sheriff won't be able to push a button and pay your fines and fees. You got to get the money. Okay. Because some people think it works that way. All righty. All right, Ms. Mitchell, thank you. And it's been a pleasure to know that you're taking this seriously and that you're doing stuff to improve. Okay.
Thank you.
All right. Great. So head on over to the sheriff's office, ma'am. All right. So Mr. Lynch, we still got too many cases out here. We got Drake, we have Love, we have Madison, we have Duffy, we have Jackson. So let me know what's going on.
Just trying to work through it, Judge. I have asked for some clarification. I mean, I asked about Mr. Drake previously. I'm not aware about.
I sent the chat back to Mr. Taylor in my response, and I emailed him the police report, Mr. Lynch.
All right, so Mr. Cruz, jump back to you. You got an announcement. You want to go on the trial calendar? What's going on? Did Mr. Cruz leave? Mr. Cruz is going on the trial calendar. Miss Val, just put him on the trial calendar. Because I am not going to play these games with Mr. Cruz.
Because he left before the court released him, may the state ask for a bench warrant bond forfeiture on it?
Not doing that with Mr. Cruz again. He'll show up. But he's going to be on the trial calendar.
Yes, Your Honor.
All right, thank you. All right, y'all, let's finish up these last 5 or 6 cases, please.
You're muted, Mr. Lynch, if you're trying to talk to the court.
Thank you. I do have an announcement. Mr. Drake from the 10 o'clock calendar does want to resolve his case through a plea. He will accept the state's offer. However, for count 4, which is a theft charge, Mr. Drake wishes to ask the court to take that under first offender, which he should be eligible for. I understand first offender cannot apply to the traffic offenses, but for count 4, I believe that why it can apply, and I've explained how first offender works to Mr. Drake.
Any objection from the state? Any objection from the state?
No, Your Honor, he's eligible for first offender.
All right, so bring him up. Let's go. Mr. Drake, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Oh, yes, ma'am.
You can put your hand down. Sir, you're before the court on 2021 CR 06103. DeMarco Antron Drake. And no insurance, count 1. Improper U-turn, count 2. No tag or expired or invalid tag, count 3. And theft by taking, count 4. What is your client plead to the offenses before the court, Mr. Lynch?
He would like the court to take nolo pleas for counts 1 and 2. Count 3 will be no pros pursuant to the agreement. Count 4, we would ask the court, well, he's going to plead guilty, but we'd ask the court to take it under the First Offender Act.
All right. So, Mr. Drake, I'm going to accept your plea of nolo to counts 1 and 2. Count 3 will be no pros. Count 4 will be taken as a guilty plea under the First Offender Act. That will be related to count 4 only. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, Mr. Drake?
Yes, ma'am.
All right, factual basis recommendation, please.
Your Honor. On or about November 17th, 2020, officers were conducting a road safety check at East Pleasant Hill Road in accordance with the supervisory sheet approved. And the defendant did roll up to the road safety check. When they made contact with the defendant, they observed him on the other side of the road, actually, which was adjacent to the road safety check. They observed him make an improper U-turn on the crest of the hill. The vehicle then traveled back towards Poplar Point Drive. The sheriff's deputy did enter his patrol vehicle to initiate a traffic stop on the defendant. And once they made contact with the defendant, they were able to run his registration and observed that the vehicle's registration was expired and there was no valid insurance coverage on the vehicle. They then did place him into custody, and after noticing that the decal on the tag was not the one registered to the RQE 3440, they read him his Miranda rights and asked him where the decal came from, and he admitted to stealing it off another vehicle in his apartment complex since his registration was expiring. And all this occurred in Clayton County. The recommendation is for count one is let me make sure.
$100 fine.
Is a $200 fine. For count two, it's a $100 fine suspended. For count three, the state's moving to null pros. And for count four, it is just 12 months of probation, and while on probation, pay a $300 fine, take a theft prevention counseling class, and have no contact with the victim of the decal, which is Nina Abgas. And that concludes the recommendation.
Judge, that was my understanding. We'd ask the court accept it.
And I can spell the victim's name if you need me to, Judge.
Judge, you're muted.
Go ahead. I'm sorry.
You want me to spell the victim's name, Judge?
Yes, please.
Nina is spelled Nina, and Abgas is spelled Abgas.
All right. Mr. Drake, how old are you, sir?
31.
Okay, so you were in your late 20s when this happened. Mr. Drake, we clear that we're gonna get ourselves together and this is not gonna happen again, right?
Yes, ma'am.
Okay, all right. So by entering a plea of no low to counts 1 and 2, and first offender count 4, guilty under the first offender, the state, the court is going to sentence you to $200 fine on count 1. That'll be $298 with the surcharges. I'll run that concurrent with count 4. Count 2 is a $100 fine suspended. That'll also run concurrent with count 4. And on count 4 is 12 months probation, $300 fine, which will be $444 in addition to the $298. So, you'll take an anti-theft course and you'll have no contact with Nina Abgas, or Abgas. You get, do you have any other questions, sir?
No, ma'am.
All right, so when you leave the courtroom, you're going to take a right. You're going to go into the courtroom right next door, 305. And when you enter the double doors, the probation intake expert will be in probably the first set of double doors, either on the right or the left. And Ms. James will speak with you and get you signed up. As always, the quickest way to get rearrested and to mess up on probation is to fail to report. Okay?
Yes, ma'am.
All right, thank you.
All right, yeah, go.
All right, so I still got an inmate, Love. Then I got Madison.
Yes, Your Honor, I'm calling Mr. Madison now. Attorney Lynch is meeting with Ms. Love in the attorney booth.
Mr. Taylor, do you want recommendations on all three of Mr. Jackson's case or just?
Yep. All three of them.
All three of them? Okay. Ms. Hagler, just to let you know, you're not muted.
Thank you.
Can I make an announcement off the 10 o'clock calendar?
I would be happy to hear it.
Judge Sierra Love is in custody. We're going to announce, this is for Sierra Love, one of our, she is in custody. We're going to announce ready for trial, but I would ask that this case also be placed on the next jail calendar next week to see if there's any update as far as plea negotiations or anything of that nature.
Well, at this point, I mean, I'm not inclined to change the recommendation.
And I
So,
understand that, but I'm not necessarily asking whether you're inclined to change the recommendation. She has the right, as you've mentioned to me many times, to do a non-negotiated plea, and I need more time to speak to my client about that. That's why I'm asking it go on.
All right, well, you can give me a non-negotiated plea on the trial calendar. unless y'all can come up with something earlier. But if she's ready for trial, ready for trial.
Well, Judge, this is her first arrest, and the state is recommending a year to serve. And she's not completely
But
understanding.
what she do? Kill somebody? Because I don't know. In the history of me being on this bench, I've rarely given anybody a year to serve.
And I understand that, Judge. That's why
So if you're gonna take a plea based on non-negotiated, do it now, or be on the trial calendar. Because what we waiting on?
Judge, this is sort of a sensitive issue in this case.
Okay, I'm not sure how it's gonna be less sensitive if she's on a jail calendar.
But so, Judge, I can't make the decision for her to plead. That's
Okay. So what you're saying is she is not ready to plead. It's a ready announcement. In that case, then it's gonna be a ready announcement on the trial calendar. And then if you want to plead on the trial calendar, non-negotiated, that's fine. But we're not gonna keep clogging up calendars for y'all to reconsider. And I mean both sides. We're not putting somebody else on another calendar because they're not going taking a plea or because they want to go to trial. We're not doing that.
Okay, I understand, Judge.
We're gonna normalize getting them one bite at the apple and getting it done and moving forward.
I understand, Judge. What if she decides she does want to take a non-negotiated plea? Can I request?
On the trial that's fine. I don't care. I'll take pleas on the trial calendar, but I'm not gonna keep putting her on a calendar just so y'all can keep going back and forth and around the bend with this. A non-negotiated plea is just as viable today as it's gonna be on the date of the trial calendar. If she's not ready to take a plea, then she's ready for trial.
Okay, thank you, Judge.
All right, love is ready announcement. She can go back. All right, what else?
Thank you, Your Honor. I spoke with Mr. Madison on the 10 a.m. calendar.
Yes.
He had some questions regarding basically the minimums on a DUI punishment.
They're statutory, so.
They are statutory. I attempted to explain that to him that when I read him what the minimums were, this was prior to receiving any recommendation from the prosecutor. He was concerned about those and wanted to know if anything else could be done.
Well, I'm concerned about somebody being under the influence of alcohol and operating a vehicle to the extent of impairment. So, yeah, we're not going any lower than the minimums that they have in the statute. If I need to tell them, I'm fine, bring them out. Mr.
Yes.
Madison, can you hear me? It's written in the statute. It's the way the law says. If you have a first lifetime DUI, this is what it is.
Yes, ma'am. I definitely understand that, and I definitely.
I'm not changing it. So if what he says is the minimum, if he read it from the book, that's where we're going with that.
I'm not worrying about that. I was just trying to make sure that me personally, can meet the court standards of actually the probation, the classes. Like I said previously, I'm homeless. I lost everything due to this DUI. I got evicted. My car was repossessed. I don't have anything. It took me $100 and something to actually come down to the courthouse that time. I'm just trying to make sure that I'm able to actually uphold those standards or of that probation and not actually go back into that same thing of basically being jailed due to me not being able to actually follow up with that probation. See what I'm saying? So that's my only concern.
Y'all work that out. What's the announcement? Because this is a 10 o'clock case and it's 2 o'clock.
Your Honor, the state is ready. This is a per se case. The state is ready.
Okay. It's on the trial calendar.
Thank you, Your Honor.
All right, Mr. Madison, we'll see you on the trial calendar. We'll be ready to try it. Thank you. All right, so that concludes the 10 a.m. calendar. 11 o'clock, I got Duffy and Jackson. Talk to me. Y'all, Miss Sonia, my interpreter, is waiting, so I need to move forward. I got a 2 o'clock calendar that I need to run through. I'm gonna run through that 2 o'clock calendar, and then y'all can give me the update on Duffy and Jackson from the 11 after that. All right. Thank you, Miss Sonia.
You're welcome, Your Honor.
Hey, Mr. Taz, is it possible you can give me a call back?
Mr. Madison, he can call you after we finish the calendar. All right, so Ladre Burnett, Ladre LaShawn Burnett wanted on the calendar. A consent order was signed on August 8th.
Your Honor, state removed for rule absolute.
If a
We have a
consent order is signed, we can't move forward.
Yeah, we have a consent order.
Okay, I'm sorry, I didn't see that. My mistake.
All right, so Burnett remains wanted, has not appeared for this calendar. Andrew William Caldwell, that case is closed. Roberto Guerrero, that person is wanted. I do not have a consent order. Ms. Val, can you update me to tell me if there's a consent order? Oh, they already filed for the rule absolute. Rule absolute is pending.
Your Honor,
Yes.
the forfeiture is just when the date you're saying is just when the forfeiture was filed, not the rule absolute.
Okay, Ms. Arnold, I can barely understand what you're saying. Try
Okay,
again.
can you hear me? Can you hear me now?
So I have that Guerrero, it says on my calendar on May 6th of 2024, the forfeiture was filed.
Yeah, not the rule absolute, just the forfeiture.
I still can't understand what you're saying. Can you chat it to me and then I can read it?
She said not the rule absolute, just the forfeiture.
Okay, so I can do the rule absolute on Guerrero.
Your
Hello?
Honor, Your Honor, somebody log in. I don't know, maybe it's him. ¿Cuál es su nombre?
Roberto, es mi pa.
Guerrero.
Roberto
Ah,
Guerrero.
there he is, Your Honor. Roberto
There
Guerrero.
he is here.
Yes.
Mr. Holton Dennis, you're a client. Mr. Guerrero is here. I can put you in a breakout room with Miss Sonia in a moment after I finish the call of the calendar, and then y'all can get all the information. Miss Sonia, if you will express to Mr. Guerrero
Yes, Your
that,
Honor. I tell him.
Mr. Guerrero, I need you to wait for a moment.
Señor Guerrero, póngase en mudo. En un ratito, cuando la jueza termine de llamar todo el calendario, nos van a poner en un grupo privado para hablar con el abogado, ¿ok?
Okay.
Póngase en mudo nomás. Ok. Gracias.
Right.
Gracias.
So Jerome Irvin is wanted, and the forfeiture of recognizance was filed also on May 6, 2024. Are we moving forward with the rule absolute? Irvin, yes. Jerome Irvin. Rule absolute will be granted.
Thank you.
Beverly Leno, case was closed. Lorenzo Middlebrooks Jr. Lorenzo Middlebrooks Jr. Last call for Lorenzo Middlebrooks Jr.
They will move for rule absolute, Your Honor.
Rule absolute will be granted. Jesse Deocean Morris. The
Here.
bench warrant was recalled, so Mr. Morris should be here. Where's Mr. Morris?
Right here.
All right. All right, Mr. Morris is with Mr. Holton Dennis. Do you all need an opportunity to speak with Mr. Morris? Mr. Taylor?
No, Your Honor, I believe a lawyer are not guilty at this time.
All right, Mr. Morris, y'all have his current contact information?
We do, Your Honor. I spoke with Mr. Morris's wife last week and have his contact info.
All right, Mr. Morris, at this time, your attorneys are entering a plea of not guilty, which means your case will appear on the next available calendar, trial calendar, unless it is resolved prior to that. Please keep in touch with your attorney so that you don't end up on another bond forfeiture calendar, okay?
Okay, can you tell him, can you ask the lawyer what address he have? I just want to double check to make sure. And my phone number. I just want to make sure.
If you could chat that to him, Mr. Taylor, Mr. Morris, you'll see a red number pop up on your screen. Click on that red number. That should be the chat from Mr. Taylor. All right, next is Tanasia LaShawn Pope. There was a surety order filed. Ms. Pope will, is she an active inmate currently?
Yes, Your Honor.
Okay, so she'll be on tomorrow's calendar.
So she can go back?
Does she know it?
No, I'm asking if she'll be on tomorrow's calendars. She don't have to come out.
She's gonna come up tomorrow. Unless she's here now. Is she here now?
No, I sent for her to be brought up.
She should be here, Judge.
Oh, okay. Well, if y'all can talk to her, go ahead and talk to her. All right, but there's a surety consent order filed. She has 2 cases. All right, next is Courtney Reeves, Rieves, Courtney Reeves or Rieves, Courtney Reeves or Rieves. All right, rule absolute.
Thank you, Judge.
Carlos?
Judge, I think that bench warrant was recalled on 5/22. So
are they
set
for another calendar?
Yeah, it was called 5/22. I'm not sure why it was on this calendar, but there was no bench warrant active, and the attorney, I excused the attorney from this calendar because it's still a guilty.
Okay,
Courtney Reed.
So it's a not guilty?
Yes.
Okay, so Rieves is going to the trial calendar. That's Mr. Creel's case. Carlos Francisco Romero.
Your Honor, that's a case that we've had contact with the attorney and we've been able to verify that he has a valid license now. So the state's actually going to move to a no process case, and we're going to have a order set aside, a bench warrant drafted up as well.
All right, case for Romero will be no pros, and I'll sign the bench warrant set aside in the no pros as soon as I get off the calendar and start signing. Nicola Denise Sanders, that case is closed.
Señor Romero, se puede retirar. La fiscal le ha sacado el cargo, ¿ok? Su abogada lo va a llamar. Se puede retirar. I'm just telling him he can go, Your Honor.
For Mr.
Romero. Yeah.
Romero, yes, thank you. Angel Jacqueline Simmons. Angel Jacqueline Simmons.
Your Honor, they move for a rule absolute.
Rule absolute for Angel Jacqueline Simmons. Rule absolute granted.
Thank you.
Okay, Ronald Kahim Sumter, that case is closed. All right. James Thompson Smith. James Thompson Smith. Last call. Last call for James Thompson Smith. Rule absolute will be granted.
Thank you.
Brandon Lanier Turner. Brandon Lanier Turner. Turner present?
Yes, ma'am.
Okay.
He's in the courtroom, Your Honor.
Mr. Holton Dennis, that's your case. Is there an announcement for Turner?
Not at this time, Your Honor. Request a conference with my client, please.
All right. Bobby Underwood. Bobby Underwood. Last call for Bobby Underwood.
They will move for rule absolute, Your Honor.
Rule absolute will be granted.
Thank you.
And David Darrell Walker, both cases are closed. David Darrell Walker, both cases closed. Mario Donnell West. Mario Donnell West.
He's there in the courtroom, Your Honor.
All right. Mr. West is also Mr. Holton Dennis, pretrial. Clinton Marcel White. Okay, Mr. White's case, the defendant pled not guilty. Bench warrant was recalled. So that's okay, Mr. White. Your case is pending a jury trial, so you're good to go. Thank you.
A jury trial? Okay.
Yes, sir.
All right. Thank you.
All right, Mr. Holton Dennis, y'all have Mr. White's information, is my understanding. Mr. Taylor, you're muted. Also, it's deposit account fraud. Bench trials are happening. So
Has
if y'all
two cases, Your Honor. He has 2 cases.
Your Honor.
So he's pled guilty, not guilty to both. So both are scheduled to go on the jury trial count. All right, so Mr. White, just remember that you have bond conditions. Do not violate your bond conditions, and including not getting any other charges.
Yes,
All
ma'am.
right. Somebody keeps saying something. Who's saying something?
Deputy Flippin. Hey,
Yes,
I have Miss Beverly Leno in the courtroom. I see it says closed, and she just
Yes.
want to make sure she's good to go.
Yes, ma'am, Ms. Leno, you're free to go at this time. Thank you. All right, so Burnett is still wanted, but there's a consent order signed. Caldwell is closed. Guerrero is waiting to speak with the attorneys from Lister Holton Dennis. Irvin is a rule absolute. Leno is closed. Middlebrooks is a rule absolute. Morris is not guilty, going on the trial calendar. Hope is an active inmate and will be speaking with, retrying with Lister Holton Dennis. Rieves is not guilty and going on the trial calendar. Romero is a null prost. Sanders, closed. Simmons, rule absolute. Sumter, closed. Thompson Smith, rule absolute. Turner is pretrial. Underwood, rule absolute. Walker, closed, both cases. West, pretrial. And White, not guilty, going on the. All right.
Your Honor.
Okay. Yes.
I have a Miss Michelle Sims in the courtroom, stated that she has court, but she's not on the list, and was wondering.
You may have court with another judge. If you could get her case number, and but otherwise I don't have a Michelle Sims on any of the calendars today.
Yes, ma'am.
All right. So all right, so Mr. White, you're free to go at this time.
Okay, thank you.
You're welcome. Rieves is free to go at this time. Morris, free to go at this time. Leno, free to go at this time. Sanders, free to go at this time. Sumter, free to go. Walker, free to go. Romero, free to go. All right. So, 11 o'clock calendar, we still have Duffy and Jackson. What's going on?
Judge, I've been speaking to Mr. Jackson. However, Mr. Jackson is on the state has moved to revoke Mr. Jackson's bond on 2 separate cases, only one of which is on today's calendar. So I was hoping the state could give me a recommendation to resolve both cases that they're trying to move to revoke his bond for in 2 days. I do not have that information, so it's hard to advise my client.
Your Honor, I sent all 3 recommendations to Mr. Taylor in the chat for all 3 cases.
Check Mr. Taylor's computer. All right. And so that's for what, Duffy or Jackson?
For Jackson. No
All
one
right, what's going on with Duffy? All right, can we get a breakout room with Mr. Taylor, Miss Sonia, and Mr. Guerrero? Is it Guerrero? Yes. Because I don't want Miss Sonia just sitting here when she, there's other judges that need her.
Señor Guerrero, ¿dónde está? Is that iPhone 4 maybe? That's him? Señor Guerrero? Ah, yes.
Sí.
Ah, hola. Ahora nos van a poner un cuarto privado, espere.
Okay.
All right.
If you'll place my personal computer in breakout room with Mr.
Okay, so Mr. Taylor's computer is going in breakout room number 4 with Miss Sonia and Mr. Guerrero.
Señor Guerrero, va a recibir una invitación. Ahí está, ¿la ve? Dice, lo están invitando al cuarto número 4. Clique ahí y ahí nos vemos.
All right.
¿Lo
All
ves?
right. So all 3 should be ready to go into breakout 4. Thank you. Thank you, Miss Sonia.
We do have Michelle Sims on the red light crossing guard calendar at 2. Did she leave? You see the red light crossing
No,
guard?
I asked to see if we had her on the calendar. I didn't tell her to leave.
Yeah, she's at 2 o'clock. We only have 3 on that crossing guard calendar that started at 2, and she's position number 2.
I didn't see it as well, unless it's at the bottom of my file forfeiture calendar. I don't see it. Hold on. Yeah, 1, 2, 3, 4. Hold on. Oh, yep, there it is. It is under my bond forfeiture calendar.
Is she still in the courtroom?
She should be. I didn't tell her to leave. I just asked for somebody to check.
Ms. Hagler, do you have a recommendation for Mr. Guerrero's case on the bond forfeiture calendar?
I will be able to get you that in a second. I have to get updated history ran on Mr. Guerrero's case.
Your Honor, I have an announcement on Brandon Turner on the bond forfeiture calendar.
Ms. Satella, stand by. Judge should be on in a second.
Excuse me, solicitors, can you hear me?
Yes, sir.
Are y'all aware that Mr. Taylor is waiting on a recommendation for
Mr. Guerrero?
Mr. Guerrero?
I sent it to him through email. It wouldn't work through chat because it says he's in a meeting.
Okay.
The offer is count 1 is a $100 fine, count 2 is to no pros.
Also, who's handling Mr. Duffy?
I am.
Okay. Is the offer on the discovery what you're recommending? Because he would like to resolve that case today. It's a little bit heavy.
Based on the history, yes, it's what except for I reduced I believe it stayed the same. Yeah, I just took off restitution because the victim said she want restitution.
What about do you want him to do 30 days in jail for criminal trespass?
Yes, I said weekends were okay though.
Mr. Duffy is going to announce ready for trial.
Your Honor, we have 2 announcements from the bond forfeiture calendar. My apologies, Your Honor. We're ready to proceed with Mr. Guerrero, and also I'd like to make an announcement on Mr. Turner. Now, both of these are on the bond forfeiture calendar.
All right.
For Mr. Turner, we're entering a not guilty plea today, and we'd also request that the bench warrant be recalled. He's present in the courtroom.
All right. Not guilty for Turner. He'll go on the trial calendar. Bench warrant set aside.
Thank you, Your Honor.
All righty.
And
for Guerrero?
Mr. Guerrero is entering a plea of guilty to improper turn signal, and the state, I believe, is no crossing the no license charge.
All right. Ms. Sonia, are you ready? See if your microphone has come undone.
There you go. Yeah. I'm ready.
All right. So, Mr. Guerrero, raise your right hand for me.
Señor Guerrero, levante la mano derecha.
Do you solemnly swear or affirm any testimony you give will be true?
¿Usted jura que todo el testimonio que va a dar aquí hoy va a ser la verdad?
Lo juro. Sí.
I swear, yes. Baje la mano.
You're before the court for no signal and no license on case 2021 CR 08047.
Usted está aquí por el caso 2021 CR 08047, que era un cargo de no licencia y un cargo de no poner la señal para girar.
Correcto.
Yes. By entering a plea, you said guilty to number 1.
Actually, that should be no low contender, Your Honor. No contest.
By entering a plea of nolo to count 1 and count 2 will be no prost.
Entonces, usted se va a declarar nolo del cargo número 1 de no poner la señal de giro, y el cargo número 2 se desecha. La fiscalía se lo sacó.
Give up the right to have a trial.
Al declararse, usted renuncia a su derecho de ir a juicio.
You give up the right to have the presumption of innocence in your favor.
Usted renuncia al derecho de la presunción de inocencia en su favor.
You give up the right to present evidence and testimony on your behalf.
Usted renuncia a su derecho de presentar evidencias y testimonios en su favor.
To not incriminate yourself or present evidence and testimony against yourself.
Usted pierde el derecho de autoincriminarse o de traer testigos o evidencias en contra suyo.
And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status.
Y si usted no es ciudadano americano, declararse culpable o no lo podría tener un impacto negativo en su situación inmigratoria.
Do you understand all of these things, sir?
Señor, ¿entendió todo lo que le expliqué?
Yeah.
Yes.
All right. Actual basis recommendation, please.
La fiscal nos va a decir qué pasó y cuál es la recomendación.
Yes, Your Honor. On March 9th, 2021,
El 9 de marzo del 2021,
officers did observe the defendant making a left-hand turn on Lake Harbin Road at Highway 42 without using a turn signal.
ese día los policías vieron al acusado hacer un giro a la izquierda en Lake Harbin Road, intersección con la 42, sin poner la luz de guiño.
And all this occurred in Clayton County.
Todo esto ocurrió en el condado de Clayton.
The recommendation is for count 1 is a $100 fine, and for count 2, the state's moving to dismiss.
Entonces la recomendación son $100 por el cargo número 1 y el cargo número 2 se desecha.
By entering this plea, sir, the court is going to fine you $100.
Entonces, señor, la multa va a ser $100 por el cargo número 1.
Count 2 will be no cost.
Y como ya le dije, el cargo número 2 se desestima.
The $100 fine will be $151.50 total with the surcharges.
Entonces, la sentencia que es $100 con los cargos asociados es $151.50. Ese es el total.
I'll give you 30 days to pay unless you need 60 days.
You know how many days you said?
I said I can give you 30 days to pay, but if you need more, I can give you up to 60 days.
Le voy a dar 30 días para que pague eso, a no ser que usted necesite 60 días.
You also have a cash bond that you could get refund from the sheriff's office and apply that to your fines and fees.
Y también usted tiene una fianza que usted pagó para salir de la cárcel. Ese dinero se lo van a devolver. Usted puede ir a buscar ese dinero.
Okay.
Okay.
So I'll give you 60 days so that you can initiate the refund of your bond.
Así que bueno, le voy a dar 60 días, así tiene tiempo suficiente para ir a buscar el dinero de la fianza.
I need you to chat your email address to clerk, Miss Terrell Holcomb.
Where is... where it says Terrell. Okay. Usted ve aquí en la pantalla que dice Clerk Taril. ¿Ve que dice Clerk Taril?
Ahorita
A ver
no
que su hijo nos ayude. Ahí
Sí,
donde dice Clerk Taril, clique, hay 3 puntitos y va a decir chat directamente con ella. Ahí le pone su correo electrónico. Solamente donde dice Clerk Taril, H-A-L. ¿La ve?
Does the young gentleman know how to use the chat?
Yeah, that's why I was talking with the son.
Yeah.
Thank you, sir.
¿Y dónde estará eso? No lo miro.
¿No ves acá en las fotos? Ahí dice clerk. ¿No la ves?
Ms. Holcomb, can you send him a text message? It's iPhone 4. And then when the red number shows up, he can reply.
Ok. Entonces ella te va a mandar a ti un mensaje ahorita, aquí en el chat del Zoom. Así que vas a ver que se va a prender como un botoncito rojo, que es que te llegó un mensaje. Ahí lo abrís. Y una vez que lo abrís, escribís tu email, tu correo electrónico. ¿Ok?
Ok, sí, pues.
Ok, Honor.
All right. Thank you, sir.
Muchas gracias, señor. Hasta luego.
Okay, don't leave until you send your email address.
Sí, no se vaya hasta mandar su correo electrónico. ¿Ya llegó?
Todavía no.
Todavía no. Después de eso ya terminé yo.
Yes.
Después de eso ya. Ok,
Yes.
ya
So,
nomás tengo que ir allá a pagar eso.
Exacto, y a buscar su dinero de la fianza. No se olvide de la fianza.
Ok.
Okay. I don't know if she sent it already, Your Honor. They say they didn't get it.
Not yet.
¿Cuál es su correo electrónico? ¿Cuál es su correo electrónico?
Okay. Okay, ahorita lo voy a sacar en.
In the process of sending it now.
Ah,
All
ok.
right.
Ya se lo está mandando. Ahí se lo está mandando.
Okay.
Ok. Suerte.
Gracias.
Thank you.
Mm.
Póngase en mudo.
All right.
Okay, Your Honor. Thank you so much.
Thank you. Thank you, sir. Once you've sent that, you'll be free to go. Just make sure you pay it before the 60th day.
Entonces, una vez que le manda el email, se puede ir. Acuérdese que tiene 60 días para pagar. ¿Ya te llegó el mensaje?
All right.
Ya llegó, pero ya lo perdió.
Búsquelo, búsquelo.
Ahí está.
Okay, ese
Okay.
Kirk Taylor.
Yes. Mande ahí su email. Okay.
Okay.
Oh, thank you, Your Honor.
Thank you, Ms.
Adios.
Taylor. All right. So that will complete Mr. Guerrero's plea, but we also have on the bond forfeiture calendar, Hope, active inmate, and West. Hope and West.
Judge, as far as Mr. West, he's ready to resolve his case. If the state previously sent me an offer, I'm not aware of what it is. I just chatted.
I just did to Attorney Taylor. Thank you.
All right, I'm gonna call the civil red light calendar. There are 3 cases on the calendar. Please respond when you hear your name. The first case is Aisha Awayefa. Aisha Awayefa. Last call for Aisha Awayefa. That appeal will be dismissed.
Thank you, Judge.
Next case is Hightower, Edmund Hightower.
Present.
Yes,
Present.
is Mr. Hightower in the courtroom?
Yes,
All right, thank you, Mr. Hightower. And hold on just a second. And the next case is Michelle Sims. So Ms. Sims was there. I hope she didn't leave. Okay, so Ms. Hagler, are you or Ms. Payne handling the red light calendar?
I'm handling Mr. Hightower's, but the state's actually gonna ask that you grant his petition.
Grant the petition for both?
No, Your Honor, just for Hightower.
No, just for Hightower.
Okay, and for Sims?
Well, if she is not on, the state will ask that you deny her petition, her appeal. If she's not on.
What now?
If she is not on, the state will ask that you would deny.
No, she's here. She's in the courtroom.
Okay.
Yeah, she's standing next to Mr. Hightower.
Okay. Well, Your Honor, after review of the evidence, the state is not inclined to dismiss this case at this point, so we will be requesting that she pay the fine.
Okay, so Ms. Sims, the state has reviewed it and they do not wish to dismiss the case. If you would like for me to review the video and make a determination, I can do that for you.
Yes, please, Your Honor, because I do admit coming around the school arm, but
Okay, wait, don't tell me yet. Just let me see it first, okay?
Okay.
All right, thank you. Just hold on a second. Investigator, if you will set that up so I can view it. And Oyefa is, that appeal is dismissed. Mr. Hightower, your appeal is granted, but I need you to send your email address. So what I'm going to ask you to do is if Deputy Flippin, if you will help him chat his email address to Ms. Hagler, I'm sorry, to Ms. Payne, then we'll go ahead and send that to you by email, but your appeal has been granted, sir.
Yeah, he's asking for an understanding of what it means.
Okay, so you've appealed saying that there is a reason why you should not have to pay your fine in this case. The state has reviewed it from the video that they have access to, and they have agreed with you. And so the court is going to grant your appeal, meaning that you do not have to pay the fine and the case is closed.
Thank you.
Deputy, can you actually chat it to Miss Arnold?
Okay, yeah, Deputy Flippin, if you will chat it to Miss L. Arnold. Thank you. So, sir, if you'll just give the deputy your email address and he'll chat that and you'll get the email results in the mail. I mean, by email, okay? All right, and so let me know when you're ready for me to view Miss Sims. Yeah. I'm ready whenever the video is ready.
Yes, Your Honor, give us a few minutes, please. Thank you for your patience. Right here, Your Honor, where my cursor is.
Okay. Let's run it again from the beginning.
Yes, Your Honor.
Go ahead. All right, Ms. Sims, go ahead and tell me what happened.
Your Honor, what it doesn't show is me sitting behind the bus for a few moments and just waiting for the bus driver to do whatever, because she was at an apartment complex and was not making any move. And so I came around the bus and proceeded. And as soon as I did, she put the stoplight out. So it feels like a switch and bait to me.
Yeah, that's the bus drivers don't do that, ma'am. If you see one pull over, that's your cue that they're about to put the sign out. It might take them a minute because they have to yell at the kids who are standing up and acting up. But if they pull over and they're stopped, then the sign's coming out, especially if they're in front of an apartment complex and it's school let out time, because that's what they do. So I don't know that they're just waiting to pull out their sign. They don't get the money.
Okay, I accept that.
All right. All right, so your appeal is denied. We'll go ahead and give you the $200 fine.
It's $250.
I'll give her 200.
Thank you.
All right, so Ms. Sims, if you would give Deputy Flippin your email address, he's going to email you the information. You'll have 30 days to pay. If you go back on the website where you got the citation, you can pay there, or you can come into the 9151 Terra Boulevard where you are today on the second floor and pay.
Okay, thank you so much.
All right, but I'll give you 30 days to pay.
Thank you.
All right.
Ma'am, Deputy Flippin is gone for today. He actually had an appointment.
All right, no problem. Hey, Deputy, how you doing?
I'm Deputy Hernandez.
All right, if you go ahead and send that to Ms. Hagler, just once she gives you her email address, and then that'll be good. All right, so that takes care of the red light calendar. We have Awayefa was dismissed, Hightower was granted, and Sims will be paying a $200 fine with 30 days. Okay, and there's no surcharges on that fine, Ms. Sims.
Okay, thank you.
All right. Mr. Holden Dennis, what we got? We still have Duffy and Jackson from the 11 o'clock. We still have Pope and West from the bond forfeiture.
Yes, Your Honor. For Ms. Pope, we request a continuance until tomorrow. They're on a VOP as well with no bond set, so nothing that occurs today would affect their.
All right, Pope is continued to the jail calendar. Next.
Your Honor, Mr. Duffy is ready.
All right, bring him up. Is he online?
So I had previously made that announcement. I believe he left. I think that I was under the impression that you had heard the announcement, but Mr. Duffy, I do not believe is still in the courtroom.
So he's not ready then.
Well, he announced he's ready to go forward.
Oh, okay. Ready for trial.
Yes.
All right. Yeah, I hadn't heard that. I didn't hear Duffy. So Duffy will be on the trial calendar. And Jackson.
Jackson, I'm hoping to talk to the state a little bit more about the recommendations for his multiple cases.
Jimmy Jackson, or he's going on the trial calendar because
right, and that is so he's on the. There's a motion to revoke bond, so I'm hoping I can get a resolution before Wednesday, or we'll have to go forward on a motion to revoke bond, not on this case, but on his other pending case. Or one of them, they filed 2 motions to revoke bond.
Okay, so here's the thing about motions to revoke bond. Y'all know when y'all are accusing these cases, so sometimes the cases are accused one after the other, even though they're in different years. And the accusation numbers are one after the other. So if we're going to do motions to revoke bond, they need to come at the time that the cases are arraigned, not when they get ready for a trial. Because by that time, they've already been sitting on the calendar. Any punishment that needs to happen for getting for violating bond conditions, well, we've already sat on it for 2 years. So that doesn't make any sense. Let me find my calendar, because I've gotten a lot more emails since I've been sitting here trying to resolve these calendars today, and I'm trying to find the one from Ms. Val. 1 second.
So I have the case numbers in front of me if you want.
Hold on, that's not gonna help me. All right, so this is Mr. Jackson.
Alrod Jackson, yes, Your Honor.
And he has how many cases?
So on today's calendar is 1.
How many cases does he have overall?
3 pending. My understanding is there's 3 pending.
What are the cases?
You mean what are the charge? Like what's he charged with?
Yeah, there's simple battery on this calendar, simple battery, family violence. What are the other 2?
DUI marijuana, I believe, or DUI drugs, reckless conduct.
Yeah, if y'all can't work this out, he's staying on the bond revocation calendar. Mr. Jackson, you just have no respect for the law.
Yes,
No, don't say anything, because this is my time to fuss. I get grumpy in the afternoons because I've been sitting here waiting for these cases to be resolved, and I haven't really eaten. So you're gonna catch all this smoke. I don't understand. Like, you got all the worst cases that we deal with in misdemeanor court, and you're getting them back to back to back. Don't nobody read their bond conditions? The bond conditions that say that you're subject to have your bond revoked if you pick up other charges. Y'all just willy-nilly doing other things. Oh man, I ain't pressed about that bond condition. I mean, for real, sir? How old are you?
I'm 35.
You just turned how old?
35.
Oh, so you good and grown. So this is just some foolishness.
No, ma'am, Your Honor.
Yeah, no, it is. All of these things are things that could be avoided for somebody who's a mature adult.
Yes, ma'am.
Obviously, you ain't had no consequences for the stuff you're doing. So yeah, this will stay on the bond revocation calendar. We'll see you in 2 days.
And Judge, I'm just for Mr. Jackson is hoping to resolve his cases. It's just that with jail time.
Okay, but it hasn't resolved, and we've been here since 11. I'm not gonna stay here all night for Mr. Jackson trying to help him out when he don't care about his own self.
Yes, ma'am.
Anybody who picks up 3 of the most serious cases we deal with in misdemeanor court back to back to back, why should I worry about whether he go back to jail? He's not worried about it.
Judge, I know he is, but he'll come back on the 18th, and I'll try to see if I can speak to the state about it prior to that.
Yeah, we'll work that out. See you on the 18th, Mr. Jackson.
Yes, ma'am, Your Honor.
Try not to get into any more trouble. Pick up another case between now and then.
No, ma'am, I got a daughter to raise, so I'm not trying to get in no trouble. Those charges were
don't tell me. I don't need to know. We'll see it on the 18th when I see all 3 of the cases. All right, so the 11 o'clock calendar is resolved. The last thing I'm waiting on is West.
Mr. West is ready to go forward, Judge.
All right, come on up, Mr. West. Let's get this done. All right, Mr. West, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on State of Georgia versus Mario Donnell West, 2021 CR 08030. For carrying a weapon by a person under 18. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Owen Lynch is with you. Mr. Lynch, what did your client plead to the offense before the court?
He would just ask the court to take a no-lo plea.
All right. By entering a plea of no-lo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, Mr. West?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. On or about December the 7th of 2020, Officer A. Kendrick was in the area of Old Dixie Road and Holiday Boulevard. There is, pursuant to the affidavit in the packet, the probable cause affidavit, the defendant did have in his possession a Glock 19 9mm weapon. When he was in the rear passenger seat during a traffic stop, the firearm was sitting next to the defendant in arm's reach, and the defendant did advise he knew that he should not have had the firearm. Your Honor, at this time, the state's recommendation is 12 months probation, a fine of $100, to complete the gun safety class, to forfeit his weapon, and everything will terminate upon completion.
All right. Anything on behalf of your client, Mr. Lynch?
Yes, Judge, I've explained the recommendation to him. We asked the court to accept it. I have explained to him the importance of gun safety, and he's going to take the gun safety course as soon as possible. And that's all.
How old are you, Mr. West?
20.
You watch too many movies, Mr. West. Y'all young people think that guns are something to play with, but every single day on the news, young Black men like yourself no longer here because of gun violence. You don't even know how to handle a Glock 19. Trust me, I have one. They don't have a safety. So if you fooling around, if that thing falls when you hit a stop and it falls on the floor, you could shoot yourself or somebody else. Just foolishness. So I'm just saying, I don't know what you thought you was doing. Was you doughboy in Boys in the Hood? I mean, you was about to do a drive-by sitting in the back seat with a gun. I mean, what were you doing? I just don't understand. How you grades? Let me ask you a grandmama question. You finish high school?
Yes, ma'am.
You got a diploma?
Yes, ma'am.
What you doing with your life?
I do roofing.
You do what?
I do roofing.
Roofing?
Yes, ma'am.
All right, that's a good job. I'm one for the trades. Yeah, I don't think everybody needs to go to college. We need plumbers, we need electricians, we need roofers. This a steady job?
Yes, ma'am.
Okay, because between now and November, you should be on somebody's roof every day. We clear?
Yes, ma'am.
All right, don't play with guns. Guns are nothing to play with. I'm a gun owner. I emphasize gun safety. I emphasize taking the class. I emphasize keeping your gun secured when it's in your house. I emphasize always knowing where your gun is. We clear? You have any little brothers or sisters?
Yes, I do.
Okay, so imagine one of them getting a hold to a Glock with no safety. Think about it. Okay? Because they still think you're supposed to shoot like this sideways and foolishness. Because they watch too much TV and movies too. Are we clear?
Yeah.
Don't be the cause of somebody else's child not being here.
I got you.
Just out of sheer carelessness, don't be the cause of somebody else's child not being here. All right?
All right.
All right, so sir, I'm going to accept your plea. I'll sentence you to 12 months probation, $100 fine, which will be $151.50 with the surcharges. Gun safety course, you're to forfeit to the weapon, and upon completion of all of these things, your probation will terminate upon completion. And let's hope, Mr. West, that you are doing things that do not require you to be sitting in the back seat of a car with a Glock 19. We clear?
No.
All right, so you're gonna go out of the courtroom, you're gonna turn right, go into courtroom 305. And once you get there, go through the double doors, you'll see Miss James in one of the offices. She'll do your probation intake. Quickest way to get rearrested is to not show up for probation. So show up and make sure you complete everything, and that'll get you off quicker, okay?
I got one question.
Sure, ask me the question.
When the first time I'm supposed to report?
They're gonna tell you.
Are they gonna tell me?
They're gonna tell you, she's doing intake at this point, so she's gonna get you set up with your probation officer and give you all of the rules and your report time.
All right, thank you.
All right. Don't be the reason somebody's child is not here, Mr. West, and don't be the reason you not here. Thank you. All right, ladies and gentlemen, are we complete on all of our calendars?
I believe so, Your Honor.
All right, I'll see y'all on the 18th. Let's try and be more efficient. All right. Talk to y'all later. Thank you.
Yes, ma'am.
All right, calling case number 24-00592, People versus Belvacar. Shkavajian. Oh, I'm not
Can you hear
hearing
me?
you. Yeah, I couldn't hear you there for a second.
Can you hear me now, Judge?
I can.
Okay, perfect. Today is the date and time set for a pretrial. Judge. We did have with the prosecutor. They have offered a reduction to impaired, and my client would like to avail herself to that offer at this point.
Okay. Counsel, we never did get an appearance on this file from you?
There should have been filed one. It was a substitution of, I believe Michael Scott was the original attorney, and I called the substitution of counsel. Should I file another appearance? Or?
No, you did everything right. For some reason, so Monica, let's just make sure that we make a note here, because it's not showing up on the docket as you being the attorney, and so that's a correction we need to make because I just looked in the file, and sure enough, you did substitution. You did everything right, so that's going to be on us, and we'll take care of it going forward. Ms. Belvacar, can you state your name, please? Please unmute.
Yes, Nirmohi Ajit Belwalkar.
Okay, and then I'm going to do both, please, at once. On the Lee file, Mr. Shreeman, your appearance.
Good morning, Your Honor. Joe Shreeman on behalf of Ms. Lee, who is present. Ms. Lee, can you state your name for the record?
Sherilyn Lee.
And Miss Lee is going to be pleading to disorderly, correct?
That's correct, Your Honor.
Okay, all right. So Ms. Belvacar and Ms. Lee, I need you to please raise your right hands. And Ms. Belvacar, you'll need to unmute.
Mm-hmm.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, Ms. Belvacar?
Yes.
And Ms. Lee?
Yes, sir.
All right, please put your hands down. All right. Ms. Belvacar, can you read, write, and understand the English language?
Yes.
Okay. Ms. Lee, can you read, write, and understand the English language?
Yes, sir.
All right. Ms. Belvacar, can you hear and understand me?
Yes.
And Ms. Lee, can you hear and understand me?
Yes, sir.
All right, Ms. Belvacar, have you had a chance to talk to Mr. Kavajian about this case, and are you satisfied with his advice?
Yes.
Ms. Lee, have you now had a chance to speak with Mr. Shreeman about this, and are you satisfied with his advice?
Yes, I am.
Okay. Ms. Belvacar, you're pleading to a reduced charge of operating while visibly impaired. That's a misdemeanor charge carrying with it a maximum possible fine of $300 plus costs and up to 93 days in jail, all at this court's discretion. Ms. Lee, you're pleading to disorderly conduct. That's a misdemeanor charge carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. To both of you, you should understand that before you enter a plea, you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one will be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of these charges, and your guilt has to be proven beyond a reasonable doubt. Ms. Belvacar, do you understand that once you enter a plea, you give up all those rights that I just said that you'd have at a trial?
Yes.
Do you understand that, Ms. Lee?
Yes, sir.
All right, Ms. Belvacar, do you understand that once you enter a plea, there won't be a trial?
Yes, sir.
Do you understand that, Ms. Lee?
Yes, sir.
Ms. Belvacar, has anybody promised you or threatened you in any way in order to give up your rights and enter a plea other than the reduction in charge?
No.
Ms. Lee, same question. Has anybody promised you or threatened you in any way other than the reduction in charge to get you to plea?
No, sir.
In the end, Ms. Belvacar, is it your own choice to do this?
Yes, sir.
Ms. Lee, is it your own choice?
Yes, sir.
Okay, Ms. Belvacar, directing your attention to March 31st of this year, 2024. Were you driving a motor vehicle on Woodward and Lincoln in the city of Royal Oak?
Yes, sir.
Okay. And ultimately, were you stopped by the police?
Yes, sir.
And after interacting with them, did they have you step out of your vehicle, do field sobriety tests?
Yes, sir.
All right, and then were you placed under arrest?
Yes, sir.
Transported back to the Royal Oak Police Department?
Yes.
And did you do a breath test there?
Yes.
All right, counsel, for purposes of this, please stipulate that the amount was in excess of a 0.08.
We would, Judge.
All right, Ms. Belvacar, what did you drink to get to that illegal bodily alcohol content? Beer, wine, liquor, what was it?
Liquor, sir.
All right, and looking back on it now with the benefit of hindsight, would you agree that your ability to operate that vehicle in a normal manner was substantially affected by your consumption of alcohol?
It was.
Okay, satisfied, counsel?
Satisfied, Judge. Thank you so much.
All right, I too am satisfied. The plea is knowing, voluntary, and accurate. I will accept the same. I'm going to order an alcohol screening and assessment. My staff will set up an interview with your client. So, Ms. Belvacar, here's what happens from this point. There's going to be an interview between you and probation. That'll be on Zoom. They'll set that up with you. And they're just going to gather some additional information. They prepare a report that your attorney can get in advance that basically will lay out what their recommendations are when it comes to your sentence. And then you and your attorney can go through that and be prepared for sentencing, which will happen in person with me. Okay?
Mm-hmm.
All right. So
Are
your
we
job.
Are we looking at about 2 weeks out or 30 days,
No,
Judge?
no.
My client. Okay.
Oh, you're breaking up. Can you try that again?
I was just going to let you know my client is currently on day 2 of COVID. So
Yes.
It'll be out in
Sentencing is going to be at least sentencing will be out at least 6 weeks.
Okay.
Okay.
All right.
She is contagious now. I just didn't want to get the court staff or probation or anyone sick if you wanted her to do an interview, in the next few days.
She's got time. So you get better. All right. And make sure that you stay on top of all of your testing.
Mm-hmm.
And we'll see you back here for sentencing. Good luck, ma'am. Thank you, Mr. Kavajian.
Thank you. Thank you.
Judge. Judge.
Yes. What's that?
With the program that I sit with you about unrelated.
Yeah, hold on one second. I'm sorry.
Or are you busy? I can get a hold of you later.
Hang on one second. Oh, all right, we lost him. Okay. All right.
Thank you, Your Honor.
Mr. Kavajian, you're just breaking up really bad. So I want to make sure I could hear you. Can you just repeat what you had to say?
Can you hear me now?
I can. I'm going to stop your video.
Can you hear me now, Judge?
I can hear you. I'm going to stop your video so that it makes it easier, I think, to hear you. So go ahead.
I was just asking if maybe you had time for me to speak with you about an unrelated matter. If not, I'd be happy to just contact Chambers. I wanted to speak with you about your driver's license restoration program.
Oh,
and see
yeah. If
you
you
could give any assistance, get some law students in there to maybe give you more manpower to be able to help maybe more people.
Well, what I would suggest is connect with John Angot, who's our MIDC guy. Because I think that'd be a great opportunity for law students who would be practicing under the court rule to really get a handle on understanding the different challenges that so many people in our community face when it comes to traffic misdemeanors, and how with just the right support, fundamental change can be made. So I would reach out to my secretary, Monica, and she could put you in touch with John and see what we can do.
Thank you so much. Appreciate it.
All right, take care. Ms. Belvacar, you can log off now. Okay, Ms. Lee?
Yes.
Directing your attention to June 20th of this year, 2024. Were you in the city of Royal Oak?
Yes.
All right. And do you plead guilty to the charge of disorderly conduct, that you were engaged in behavior that was disorderly in nature and would constitute a disturbance of the peace in some way?
Yes.
Okay. Satisfied, Mr. Freeman?
I'm satisfied, Your Honor.
I too am satisfied. The plea is knowing, voluntary, and accurate. I will accept the same. Okay, so let's dig into this file a little bit here. Did she finish her probation in Clinton Township?
Yes.
I believe so, yes.
When did that finish up?
A few months ago.
So before
I gotta go
this
back to
happened?
court. I still gotta go back to 29th to get all my paperwork and have the judge sign off on it.
And that you said the 29th district court?
Yeah,
Or you gotta go back on the 29th?
yeah, on the 29th, and he sign off on everything.
Okay, do they know about this?
Yeah, they set the court date up.
No. So, do they know about this incident in Royal Oak?
Oh, yes, they do.
Okay, so did they already deal with that? Did they already give you a sanction or?
Yeah, I already took care of everything.
All right.
I was on top of it.
Where are you at with your sobriety?
I've been clean for 2 years. I get dropped every week at my doctor's office, which I could show proof of that.
And Your Honor, she did disclose to me that she is a peer recovery coach at this time, and she does go to Easter Seals for substance abuse counseling and mental health counseling.
She working?
She is. She's working 3 jobs, to my understanding. She's working as a CNA, and a home health care nurse through the state of Michigan. She works for a bike and tree service, as well as a flooring business.
Well, I think for the demons that she's had to battle over the years, staying busy is a good thing, you know?
Yeah, yes.
Obviously, the allegations here are very concerning, Mr. Schreeman. I mean, she tells me she's 2 years sober, but having that kind of item allegedly in her possession doesn't really
look good.
Doesn't look good.
Doesn't look good for me. I was with a friend that had it, and yeah, I got stuck with it.
So, Ms. Lee,
I was on my way to work, and I had somebody with me. I was driving, and I'm not friends with that person no more either.
I mean, this is if you are, and I don't know you at all, if you are in fact 2 years sober, you know that surrounding yourself with people who are still in the addiction lifestyle is just such a dangerous thing for you. You know that.
Yeah, I was given a ride to work for my boss.
Okay.
Yeah, and I got caught up.
All right, Mr. Schreeman, do you wish to have this matter set for sentencing, or do you wish to proceed to immediate sentence?
I would be asking for immediate sentencing at this time. And considering, her completion of probation in the other court, the fact that she hasn't had any probation violations makes me think that she, has been clean for 2 years. She is seeking treatment. She's drug testing at a doctor. She is a peer recovery coach and attending substance abuse counseling. I would ask the court to consider just implementing costs and fines.
All right, ma'am, is there anything you'd like to say before this court imposes sentence?
I know things don't look good for me on that department, but like I said, I don't really hang out with anybody, or I don't, try to put myself in that position. Like I said, I was driving him to work. I thought everything was fine. We're going to work. So I made a mistake. I made a choice to not drive anybody anymore. Get me in trouble. Been in trouble my whole, in and out of courts my whole life. I'm just tired of being involved with the courts. And I just want to do the right thing and get keep on the right track. And I'm taking care of my mom, my brother, my sister. My sister's got cancer. I'm taking care of my family, and I don't really have no help. That's why I gotta work 3 jobs to take care of everybody.
Do you go to meetings?
Yes, I do. I go to 2 a week.
Make sure you ask for help at those meetings. You know that there are people at those meetings that need to stay sober, right? And the key for them staying sober is to be available for others. So Miss Lee, you got to ask for help, and it sounds to me like a lot is falling on your shoulders. But you've had to battle your own demons, if you have to do all these other things for other people and try to take care of yourself, you're going to fail. You don't want to put yourself last. You got to put yourself first. And that means ask for help. Because
Right.
Ms. Lee, you know yourself, if you are in a good place and you're sober, then any good deed that's been done to you, you'll clearly do for others.
Right.
So get in those meetings and make sure you ask for help. Tell them when you're having dark times. Tell them when you need a ride. Tell them these things. There are people in those groups and those meetings that can help.
I know.
So stop denying yourself that help. Stop thinking that you're not worthy of it. Stop thinking to yourself, oh, because of these choices I made in the past and the things that I've done, that I don't deserve help. All right. We all deserve help. You just have to ask for it. And then the key is, once you get it and you're good and you're doing well, then you can help somebody else.
Yeah.
Right?
Yes.
Okay. All right.
I got a good report for my jobs. I've been with them 27 years with the state of Michigan and 20 years with the tree service. So I keep my jobs responsible there.
All right. Hold on one second. Just trying to figure out. Let's see here. Okay. So I'm going to, it's a sentence of this court. The beginning is going to sound rough. So don't make any snap judgment, just wait. Okay.
Yeah.
All right. It's a sentence of this court that you'll serve 93 days in jail, but I'm going to suspend that time. I'm going to hold that time. Your past suggests that you should get 93 days. I'm looking to your future and hoping that I don't have to give you that time. So I'm going to hold that 93 days, and I'm going to set this for a review in 9 months. It's a $250 fine plus $250 in court costs and $125 in state costs. Now, these are your conditions, okay? You want to avoid jail time? It's real simple. In the next 9 months, there is to be no new criminal behavior, no contact with police, anything like that. You got it?
Yes.
All right. And I'm going to set this for a review in person, June 11th. So you're going to get notice. Are you still at that Sherwood address?
Yes, I am.
You get notice. Put that notice in your phone. Okay.
Okay.
June 11th of next year at 8:30, you got to get in and see me in person. All right. So you have to come into the court and see me in person. Now, Ms. Lee, if you can present proof of meetings, or treatment, or that you're working with a peer recovery coach, if you have that with you and you could show that to me, then what I'll do is I'll cut your fines and costs down to $200. So I'll waive $425 of your fines and costs just for doing what I think you're already doing.
All right. How do I do that? How do I do that? How do I show you proof? I can show you proof. I don't have it.
Yeah, Ms. Lee, I need you to show me proof next June.
Oh, okay. Okay.
Okay.
I'm like,
So just
get it, but I need today to do it. I can call my counselor and everything. Okay.
So basically, right now, it's real simple. In the next 9 months, you're to pay $625 and stay out of trouble. Okay.
Right.
And if you want to save yourself some money, okay, just provide me proof of all the things you're already doing. I'm not asking you to do anything more than you're already doing. I want you to go to meetings. I want you to do your treatment. I want you to work with your recovery coach. You're doing all those things.
Yeah.
If you bring those things into me on June 11th, then I will take your fines and costs down $425 just for doing what you're already doing.
Okay.
Okay. Now, if you don't want to, if you can't get that proof together, then all I need from you is just show up with $625.
Okay.
All right.
No problem.
No new criminal behaviors. Don't give somebody a ride home, that you don't know what their story is. Don't let them into your house. Don't let them into your life. Right.
Right. I'm not.
In fact, I'm going to go even better on this, Ms. Lee. If you provide to me proof of your meetings and I can see that you've been sober for the last 9 months, I will waive your fines and costs entirely.
Oh, okay. That'd be wonderful.
Okay, but that's 9 months from now. So I don't want you to stress out and think, how am I going to stay sober for 9 months and stay out of trouble and all this kind of stuff? You worry about today. Just stay sober today, stay out of trouble today. We'll deal with tomorrow and then the next day and the next day after that, okay?
Okay.
All right, I'll see you, but I need to see you in person on June 11th. Got it?
June 11th, what time?
And that'll be at 8:30 in the morning in person. We'll send notice, put it in your phone. Got it?
I will.
All right. Good luck, Miss Lee.
Yes, thank you so much, Your Honor. You have a wonderful day.
You too.
Thank you, Your
Thank
Honor. Keep up the good work, Miss Lee.
Thank you. All right. Went better than I thought. Thank you, sir.
All right. Good luck.
Thank you.
Yeah, you have a good day.
Ms. Cole, do you need to speak with Sukari?
No, Your Honor, I don't.
Calling case number 24-01091, People v. Zukari.
Mr. Zukari, are you there?
Yes, I'm here.
Yes.
All right, today's date
Good
and time.
morning, Your Honor. Susan Cole on behalf of Mr. Zukari.
All right, Mr. Zukari, state your name, please.
Yeah, Ahmed Zukari.
All right, today's date and time set for a pretrial on reckless driving. You've worked out a resolution where that reckless driving is going to be reduced to a speeding 11 to 15 over, and a driver's improvement course. The speeding 11 to 15 over is a 3-point ticket, but reckless driving, I mean, that's a huge charge with a mandatory suspension of the license. He won't get any of those things. Ms. Cole, after discussing it with him, is that what he wants to do?
Yes, Your Honor.
All right, Mr. Zukari, to the charge of not limited access, of speeding 11 to 15 over, do you plead responsible?
Yes.
All right, count 1 is dismissed. He will have to complete a traffic class. If he does not, then he's going to be potentially subject to the reckless driving being reinstated. So we want to take care of this class. So the fine on the speeding 11 to 15 over is $170. I'm going to order a level 2 basic driver rehab program. Okay, so Mr. Zukari, this is pretty straightforward. This is what I'd like to do, is make sure you understand. We're going to adjourn this 90 days. In those 90 days, you need to take care of the 170, okay? And then you're going to get a letter in the mail with this half sheet notice, and it's going to have the information on the traffic class, okay? So you don't have to go look for one. It's going to be sent to you, okay? Now, when you get it, sign up for that class, take that class. It's an online class. That should make it easier for you, okay? Once you have completed that class, they actually let us know, all right? The agency, you don't have to worry about providing us the information. We get it from them, okay? Now, if you pay that $170 and you take that class, that 90-day review date will be canceled. You don't have to show up for court anymore. It's closed out. Does that make sense?
Yes, and when do I pay the 170?
You can pay that anytime in the next 90 days.
Okay, and I lost the ticket. You know how the police officer gave me a ticket, but I lost it. Like, how do I know to tell them so I can pay it?
Okay.
I can send you your ticket number.
Oh,
or
perfect.
you have a pen and paper? I'll send him his ticket number.
You'll send it to him? Okay, so Mr. Zukari, Ms. Cole is going to send it to you to make sure that you have it so you know how to pay. Now, when you get the notice in the mail for the 90-day date, let's say, for example, you can't get this class scheduled in time. All right, don't stress out. Don't get worried. Just show up at the review and then ask for some more time. I think you can get it done. I feel comfortable you can get it done. But if you ever get jammed up, just show up at the 90-day review and we can figure something out, okay?
Okay, thank you so much.
All right, good luck. Thank you, Ms. Cole. Is that all you have today, Ms. Cole?
That's it, Your Honor.
All right, have a great day.
Thank you. You too.
Your Honor.
Okay, just want to check everybody in. Miss Mullins, I checked you in. Monica, can you see as Miss? All right, so Miss Mullins, we're just trying to find out who your attorney is. All right, so just hang tight. Miss Williams, your attorney has already been speaking with the prosecutor, so I've checked you in. I'm going to move you in the waiting room for just a minute, but my hope is we can get this moving quickly for you. All right, but your attorney is I just have to confirm that your attorney's talked with the prosecutor. Okay.
Okay.
And Ms. Mullins, we're going to figure out who your attorney is and bring you back in just a second. Mr. Glidden, your attorney is speaking with the prosecutor right now, so just hang in there. Mr. Rea, Ms. Bigler is here in the courthouse. So I'm going to go get an update and see what the status is on your case. So just hang tight. Mr. Anderson, I think you've already been speaking with Ms. Chupek. And so as soon as she comes back into the main session, then I will get going on your case.
Judge Manning.
Hey, how are you?
I'm here.
Hey, Beck. All right, we'll start with number 4, James Hodges. All right, we got 24 PI 004157, 101 days without indictment. $9,000 good bond as of July the 5th, 2024. Willful obstruction, felony, simple battery against a peace officer, and simple battery. Wow.
13 cycles FTA in 2017 and 16 of battery, family violence, and 2013 open to drug-related objects. Nothing further.
All right, go ahead, Ms. Beck.
Thank you, Your Honor. Mr. Hodges is 34 years old. He's lived in the metro Atlanta area for the last 14 years. He was supposed to start working at a valet right prior to his arrest, but he's hopeful that he'll be able to get back to that. He is a high school graduate and then also attended 1.5 years of college. We would be asking for a bond not to exceed $3,000. He has been meeting with our social worker, and they're trying to get him into a program. However, we need the bond to be low enough so that we can make both of those things happen simultaneously.
All right, go ahead, Mr. White.
This defendant has been in, as the court noted, 101 days. The last order for bond was July the 5th of 2024. No. Yeah. Which is, what's that, 96 days ago?
Right.
Something like that. And that was a bond reduction. There's been, other than the fact that he'd like to get out and get, somewhere other than jail, I haven't heard anything that there's been any change in circumstance at all or any reason to disturb the bond. Perhaps if the defense had a place for him to go or had a firm commitment or, transport order or something, that might be something we could deal with. But at this point, he's been in really only 100 days. The state still has almost 900 days, almost 1,000 days before, actually over 1,000 days before we need to get this case indicted because he already does have a bond. There is no reason to disturb the bond. And given his history of failures to appear and his criminal history at all, $9,000 is charitable, to say the very least. Nothing further.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1000 Piedmont Avenue. Stay away from all Caribou coffee shops. No further contact with Nathaniel Dalton. I'll do 3,000, 2,000, and 2,000. Best of luck to you, sir. All right, is that it for you, Ms. Beck?
I believe so, because you said Mr. Lindstrom and Mr. Murphy were both indicted.
Right.
Yes, may I be excused?
Yes, ma'am. Have a good evening.
Thank you. You too.
All right, now I got John Davis. All right, let's see. Give me a second. All right, I got position 7, 24 PI 003044. As of June 27th, there's a $1,000 split bond on possession of Schedule 2 controlled substance and drug-related objects. And looks like he's been in 138 days without indictment. Wow.
18 cycles FTA in 22, burglary in 2018, giving false name in 23. Nothing further.
All right, go ahead.
Your Honor, my name is Jessica Gerber. I am one of the new attorneys with the Public Defender's Office here. Recently took over for Mr. Rogalski and wanted to just introduce myself quickly. Mr. Davis, I just met with him.
Can you hear her, Miss Bosky?
I can't hear her, Judge.
Yeah,
I can only hear her very softly.
Yeah.
About that.
There you go. When you lean up, I can hear it.
Okay, I'll just lean on in.
There you go.
He is in his 40s. He is 40 years old. As we heard from pretrial, he does have a couple cycles that he's facing. Currently, my understanding is that he is up against not having an ID, and that has been a barrier to him being able to become housed. So he has been really trying. Most recently, he was arrested just looking for a place to sleep, unfortunately, really close to where we're at in Atlanta. And so even though where we're at here at the 100 Peachtree building, actually, and so even though he has only been in, he hasn't quite gotten to a 90-day mark since the initial bond was consented to, we would ask that Your Honor consider something nominal in his case. He has unfortunately not been able to work. He's certainly open to some type of rehab program, but because of his lack of an ID, which I will work with the social worker to get rectified as soon as possible, but that has limited us in our resources. However, we do believe that given his insecure housing, Your Honor, that he would be able to make it back to court. He stays around this area, and we believe that a nominal bond is sufficient to meet the purposes of bail, given that Judge Brooks determined that he was bail eligible back in June.
All right. Go ahead, Mr. White.
Judge, this is a consent bond. And it's a consent bond from, I believe, June 27th of 2024. And it is, in fact, a nominal bond. It's a $1,000 bond. Doesn't get much more nominal than that. So he has everything that the defense has requested, and he has everything that the defense agreed to. There's been nothing to show that there's been any reason to disturb that agreement. And given his history, given the fact that the current policy of the Superior Court is that if someone is unhoused, as my learned colleague put it, then they will not issue bench warrants or otherwise attempt to bring the person to court. Simply, they'll put the case in judicial hold, and the person continues to drift if he doesn't appear in court. Therefore, it is extremely unlikely that if he is released just to the street, literally to the street, we will never see him again until, fortunately for the state and for the people of Fulton County, he commits felonies frequently enough that it'll probably only be a year or so before he's back before us with a new felony, and then we can hopefully deal with this one as well. Judge, $1,000 bond is what was consented to. There is no reason to disturb the bond. There is no reason to disturb the consent. The state objects to any lowering of the bond. And since the state did consent, the state will not request to raise the bond at this time, although that would certainly be the appropriate action, nothing further.
It does look like previously it was on a pretrial and they surrendered. Am I right, Bostic?
This was a pretrial surrender, Judge, which is why there's a consent from June.
All right. So no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Must supply an address where you'll be living upon release. $900, and all you leave the second count at UJR through the jail. Best of luck to you, sir. Is that it for you, ma'am? Or you got?
Yes, Your Honor, that completes my business. May I be excused?
Yes, ma'am. Have a good evening.
Thank you, Judge.
All right, I got Zatar Hunt. This Kennebrew. All right, so we got position 8, 24 PI 004231, 99 days without indictment. There's a $15,000 good bond as of July it's a $15,000 split bond as of July the 8th, 2024. Use of facility and committing use of communication facility and committing crimes. PGC possession of controlled substance in Schedule 1 or 2 is 5 fentanyl pills. With intent to distribute, possession of controlled substance in Schedule 1, possession of controlled substance in Schedule 1. Rah.
6 with the U.S. Marshals, conspiracy to show defraud in 2017, probation violations, possession of firearm in 05, Georgia, 25 cycles, cocaine with the intent that's old, IM that's old from 07, FTA in 24, 23, and 02. Nothing further.
All right, go ahead, Ms. Kennebrew.
Yes, Your Honor, thank you. Mr. Hunt is 43 years of age. He does have a valid address here in the Metro Atlanta area where he resides with his wife of 14 years. He is from Georgia, so he does have ties to the community. He did attend Washington High School and he graduated in 1997. He was working prior to being arrested at a cleaning services for over 2 years doing commercial cleaning. He also has a child that does reside with him. We would just be requesting that the bond is lowered. He has been in custody over.
Let's just pause a sec. The judge said that it's part of getting old, so I'm guessing she had like laser surgery or something on it. I don't think it was an injury.
His bond is currently $15,000. We'd be requesting that bond be split in half to $7,000.
All right, go ahead. Oh, is he gonna live in Fulton County?
Yes, Your Honor.
He doesn't live at the 2451 Old National Highway, does he?
No, Your Honor, not at that address.
All right, go ahead, Mr. White.
Judge, as the court pointed out, this was a bond that was granted July the 8th of 2024. Given the quantity of Schedule 1 narcotics here, certainly 15,000 is a very low bond. He's only been in for a little over 100 days, meaning that the state has more than 1,200 days to indict the case before there's any problems with the indictment now that this defendant has a bond. Therefore, there is no reason to disturb the bond. It's not like he's been in for an extended amount of time, and it's not like the state has not been diligent or is in danger of violating the statute of limitations. Judge, given the fact that he does have 6 cycles with the federal government and 25 cycles with Georgia, including FTAs in this year and last year, he is a very, very poor risk for bond. The state's position is that there is no basis for reducing the bond. In fact, a more appropriate action for the court would be to go $15,000, minimum of $15,000 on the use of communications facilities, a minimum of $15,000 on the Schedule 1 or 2 with intent to distribute, and then a minimum of $10,000 each on the remaining 2, which would be a minimum of $50,000 bond. That would be much more appropriate in this case. I won't address the fact that the IALA factors mitigate against any bond at all, nothing further.
If I may respond, Your Honor.
Sure.
Bond is not to keep the accused in custody. So while the state may have over 1,000 days to indict the case or to move the case, the client is not to be held in custody for 1,000 days while they decide whether or not to indict that case. Bond is simply to ensure that my client will return to court and will appear for his court appearances. We don't know the factors behind the FTA, so I won't go into that, but we would just like for the court to keep that to take that into consideration and to keep that at the forefront as well. Thank you.
No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 2451 Old National Highway. Let's see. You say he's going to live in Fulton County, right?
That is correct, Your Honor.
All right, so I'll leave it at UJR jail, 5,000, 4,000, and 4,000. Best of luck to you, sir.
Thank you, Your Honor. And that concludes my business with the court. May I be excused?
Thank you. Yes, Ms. Kennebrew. Good to see you.
Good to see you as well.
All right, I got
I'm sorry, Judge. I don't mean to interrupt. I have a quick question for position number 7, Davis. He also had a
who?
A UJR through the jail. Mr. Davis, position 7.
I believe the misdemeanor was a UJR through the jail.
900 and then a UJR through the jail, right?
Okay, thank you. We're completed here, Stacy.
Thanks.
Thanks.
All right.
Bye.
What about Lateef Ferbert? Wave your hand if you're Mr. Ferbert. Nope. We got Michael Edge. There we go, Michael Edge. All right, we got position 3, 24 PI 004130, 102 days without indictment. There's an $80,000 split bond as of June the 11th. Ag assault. Yeah, 3 ag assaults, possession of a firearm or a knife for the commission of or attempt to commit certain felonies, battery, cruelty in the third.
Michael Edge.
Position 3.
Yeah, I got 14 cycles. carrying a weapon in a public gathering, furnishing alcohol, and 02 DUI, battery, family violence, and 21 couple of probation violation in the military, wrongful use marijuana, 6 cycles in Alabama.
That it, busted?
Yeah, and there's a battery, family violence, and a cruelty in the 30 from 2020.
All right.
Nothing further.
All right, go ahead, Mr. Showalter.
Michael Edge is 40 years old. His address, if release, would be 3571 Clubhouse Circle East, Apartment C, Decatur, Georgia. That is an address with family that the complainant is not residing at. He's been in Atlanta for 14 years. He was previously working as an automotive technician at All Start Auto Lights. He was working there for a year. He's a high school graduate. He is an Army veteran. He served there 2002, 2004. And he's been in over 100 days. So the split bond, he is entitled to a monetary bond on all charges. 80,000 is something outside of the range of somebody who's been incarcerated for months. He's not getting any richer. So I would ask for, they got 20,000 on all the misdemeanors there. I would ask for 5,000 on each charge if we're going to be doing it like that.
All right, go ahead, Mr. White.
Can you hear me, Judge?
I can.
Okay, that's good because my Zoom is acting up. I can't see anything right now. So as long as you can see and hear me, Judge.
I still look as stunning as ever, so don't worry about it.
Well, all right. I appreciate that, Judge.
All right.
I have no explanation for why we didn't get this indicted. This is a family violence, and I was unable to research before. I just ran out of time. He has 4 prior family violences and then this is actually his 5th.
Is the same victim?
And that's why I was not able to figure that out before. I just ran out of time before I could figure out if it was all the same victim. But Your Honor, it's just, I don't know why it's not indicted. The state would request that the court include with any bond a strict 24-hour house arrest enforced by an ankle monitor. The only exceptions being in-person court appearances and medical emergencies when taken from his home in an ambulance. A strict stay away, no contact of any kind whatsoever with the victim, either the primary victims or the children who are the subjects of the cruelty to children of the 3rd degree.
All right.
Nothing further.
Any victim contact, Ms. Rhodes?
Yes, Your Honor. The victim is on Zoom. Ms. Smith.
Does the victim want to speak, or does the victim tell you something to say?
When I made contact with her, she said it was okay and that the defendant is her husband and she's okay with contact. But last time I talked to her, she said she would not mind addressing the court.
All right. Well, I don't necessarily feel the same way. So we'll have no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1472 Normanberry Drive, East Point. Stay away from 3478 Washington Road in East Point. And Mr. Dukes, a 24-hour curfew. The only reason, period. Court, medical, and to see his lawyer. That's it. That's the only 3 reasons he leaves his house, because he's going to stay out of Fulton County. Sir, do not darken the door of Fulton County unless you are coming back to see Mr. Showalter or to come to court. That's the only reason you come to Fulton County Court, and to see your lawyer. Must supply an address where you're going to be living. No further contact. Absolutely no further contact with LaShonda Smith, LASHAWNDA, Smith, Adrian, ADRIAN, Allen, ALLEN, and Corshawn Smith, CORSHAWN. You will have that county paid ankle monitor with that 24-hour curfew. And sir, mark my words, if you do not keep that ankle monitor charged, or if it sees you leaving your house and you're not at a hospital or seeing your lawyer, your bond could be revoked. All right. So 30,000, 30,000, 30,000, 30,000, 20, 20, 20, and 20. Best of luck to you, sir. You can lead the booth. Now do I have Lateef Ferbert? Wave your hand if you're Mr. Ferbert. Do you see him, Mr. Pink? All right, there we go.
I see him.
All right, thanks. All right, so we got position 1, Bostic 24 PI 000949, 92 days without indictment. Looks like as of April the 22nd, there's a $2,500 good bond. It was a consent bond. And the way it looks, somebody's already posted that bond, Mr. Pete, is on that case for cruelty in the first, simple battery, family violence, and terroristic threats and acts, or do you show something else?
Judge, to tell you the truth, I just filed an entry of appearance on this case. Miss Parisa Safarina was the previous attorney. I believe she filed this before I filed an entry.
All right. Well, let's see. Bostic, pre-trial.
Second judge, I was looking at something with him. 241 0328.
Sorry about that, Judge.
No, that's
yeah, Judge. The indicted case is what's holding him in custody, I think.
So has he posted this bond though?
Yeah, it looks like Red Eye Bond is on this case, the indicted case, the 24 SC 004153. And that bond may not be paid, and that's 15, 20, I'm at 35. That's a $40,000 bond on that case. That's
So
assigned to Judge Adams, armed robbery, ag assault, firearm during an obstruction, and a simple battery.
So that is it, Mr. Pete. It does look like he posted that. Sometimes the stuff on there is wrong, but I just,
And because this bond is just $2,500.
Yeah,
that's correct.
That's the Red Eye bonding made that. So it's the indicted case that's holding him.
Yes, Judge, and I'll be dealing with that.
Okay, so since he's made this one, but if anything comes up, shouldn't, but let us know, we can put him back on, okay?
Yes, thank you, Judge.
All right, thank you. Thank you, sir. You can leave the booth.
May I be excused, Judge?
Yes, sir. Have a good evening.
You too.
So, Ravello's on next week, right?
This is your warning so that you don't suddenly have nothing to watch. There's about 13 minutes left of this. And then I need to say goodbye because I'm busy getting ready to fly back to my hometown tomorrow. So this ADA isn't actually the one that rubs me the wrong way. There's a female ADA, and then there's a lawyer, and they're always at each other. Always, always, always. I've actually got like a compilation going where they're like, Judge, can you please tell her not to interrupt me? Judge, she said blah, blah, like siblings, like stop breathing on me. To what? What's to what, Steve? Sorry, there's a bit of a delay. There was something I was just about to do. Now I can't remember. I'm going to push play and then I'll just keep an eye.
That's correct, Judge.
Okay, let's see. We got one more, Mr. Cordes. Hold on. All right, we got Philip Matthews. Mr. Matthews, if you turn your camera on, thank you. All right, so this is a motion to remove an ankle monitor. It is Philip Matthews, 23 CP 219507. Mr. Fortis, it's aggravated assault. Mr. Phillips, turn your camera back on. Mr. Phillips, turn your camera back on.
Just a second on this.
It says the host has stopped.
There you go. Turn it back on.
Okay.
85. But he's been out a year. He got out 6/19/2023. Nothing to add. He's only had one arrest before this, and that was back in 2010. Nothing further.
All right. Go ahead, Mr. Fortis. It sounds like he's had it on over a year.
Yeah, Judge. The issue is twofold. Number one, regarding the ankle monitor, which has been over a year, Mr. White and I consented that should be removed. The issue where we're at an impasse is contact with his wife, Ms. Flores. Ms. Flores is on the call. I can stand in my place that I've spoken with her and that she wants to have contact. They haven't had any physical contact since June of last year. There has been some phone calls, only in that he has two minor children, 4 and 2. She moved to Texas. So in order for him to not be an estranged father, there has been phone conversations with the children. But at this point, over a year later, going on a year, 3 and 4 months, I mean, to keep them apart physically just doesn't make any sense. It's basically severing their relationship and making it more difficult. So we're just asking that there be no violent contact at this point. And I know that Mr. White has a different opinion on that, but I'll reserve based on what he may say.
But you said she lives in Texas now?
She had relocated to Texas. He is he's in the cabinetry business for carpentry. So he wants to relocate there with them at some point, but obviously given the bond requirement, he's unable to do so. But he's unable just to physically see her for that matter.
All right. What do you say, Mr. White?
Judge, although the state is not opposed to the ankle monitor since it has been on over a year, and it hasn't been indicted yet, the state is opposed to allowing contact. This defendant, although there is a strict no contact, this defendant, by his own admission, by the representation of counsel, has violated that bond condition already, and has been in contact with the victim in this case. A year isn't all that long, especially given the situation that we're in. Still trying
Do you have children, sir?
Mr. Phillips, please mute yourself.
And Your Honor, this defendant, I'm just going to end with this, has shown through his behavior, not only in violating repeatedly the bond order, maintaining what can very well be characterized as almost constant contact with his victim, and has shown, and this forum, disdain for the court. The state is opposed to anything that would put this victim more at risk than she already is by someone who has so little regard for this court. Nothing further.
Judge, can I say, I'm sorry, go ahead.
Go ahead. No, go ahead.
What I was going to say is early on in these cases, what the DA's office always says is there needs to be a cooling off period. Because nobody really knows what happened other than Mr. Phillips and Ms. Flores. However, now we're at the point where it's becoming a frozen situation. I mean, she wants contact. He wants contact. It's been over a year. They haven't had any physical contact. They have 2 minor children. He hasn't seen them because she's the only one that can transport them, or him transport himself to her. That has not happened. Yes, there has been phone calls only for the sake of the children, not being disrespectful to the court. But the bottom line is that the victim in the case who's on the call wants contact. He wants contact. And we're a year and 4 and 5 months into this without indictment. So, and there's no criminal history.
So, Mr. Portis, how old are the children?
I believe 4 and 2.
Okay.
It's a long time without a father.
Is there a third party that could do something as far as exchanging the children?
I mean, that can't happen now that, obviously they're in Texas. The only way that can happen is for either him to physically go there, and they're trying to get their relationship, their marriage back on track. I mean, this isn't a boyfriend-girlfriend situation. It's a marriage. I mean, she wants no violent contact. And I just think a year and 4 or 5 months is long enough. I mean,
when was his arrest date?
It was back on, I think the court had said that it was back on June the 19th, and that was the date of the incident back in 2023. So we're coming up on 16 months.
I'll include this on my email tonight to the state. Here's what I can allow. Here's what I'll do just right now, only because I understand that she wants contact, but then I'm also kind of saddled with trying to protect people. So what I'll allow is, especially with the children, I get it. And so last time I brought this up, my God, we were on for like 45 minutes because these people couldn't get it. Zoom or FaceTime, and then both of y'all can record it if something comes up, and that would be evidence of good, things that are happening or whatever. Do that. I'll include, I always include Mr. White. I'll include you too, Mr. Fortis, where I send an email to them. See, we can't get on the, get on something and get it indicted. So we can have, and I say Zoom or FaceTime, anywhere you can record it, because I don't know if the kids were there, when this happened, and if there was a defects case or anything like that. But
They were not there. Well, I think one of the children's, based on the police report, were there when the alleged incident occurred.
How about we start with that? And
well, Judge, the only problem with that, and I'm not trying to get explicit on it or whatever. I mean, when I say they haven't had any contact, and when I'm talking about physical contact, like there's been no physical contact for 16 months for a husband and a wife. I mean, they need to have contact of some sort.
Well,
I mean,
you see, I could not disagree. However, I go back to barely 30 days ago when a lady filed a TPO and she dismissed it and filed for divorce, and guy went over to her house and killed her. And I have to live with that.
What about if we structure it this way, that they can have physical contact, provided that, maybe one of their parents are there as well. You know what I'm saying? Like they can see each other, and if they're in the house together, there has to be an adult third party. I mean, I know that that's hard to enforce, but it's almost there wouldn't be anything stopping her from driving from Texas to Georgia to see him. I mean, the state wouldn't know about that either if that's what she want to do. So they have been complying with that aspect of the court's order. So, I mean, I understand what the court's concern is, which is always the concern in these cases. But at this point, I just think that it's having a detrimental effect on their marriage and his ability to parent. It's basically severing the relationship between not only his marriage, but also the relationship with his kids.
Let's see.
Can't go to ball games, can't go to school functions, all the things that all parents want to do.
So I'm just reading the warrant, and it says he called physical, substantial, and visible bodily harm resulted in strangulation of another. Victim's face was struck with both open and closed hands, causing her face to become swollen, laceration on the side of her mouth, and hands and arms were pressed against her mouth and neck area, causing her to block out momentarily. See, bruising on the left side. Elsa advised that she continued to get hit by Mr. Phillips while attempting to shield and remove her child from the immediate area.
So, what about some sort of amendment to the bond, Your Honor, regarding an evaluation, and then after that evaluation, or I don't know what it is, the 8-hour family violence, I think it is, or domestic violence course or something like that. Then after that, there can be contact.
You talking about like an FVIP class?
Yeah, but not the 26-week. I think there's one that's about 8 weeks or 8 hours or something like that.
We'll take the ankle monitor off right now, Mr. Allen. Find like a 6-8 week domestic violence class, and we'll reset it for that. Okay. Until then, though, you can have Zoom talks. Both parties record it with your kids. I know it's a 2-year-old and a 4-year-old, and their attention span is probably that less than a gnat, but still, I want you to at least them to see you. I know it's an important time, and they've got what's the name of this place? Men Stopping Violence. I think they're Mr. Portis.
That's what I was thinking about. Can he do that? Can we do the Men Stopping Violence?
Yeah, then send it to myself and Mr. White and let us see what I think they do evaluations there, what they say.
What I would ask, and then I'm sorry, but can at least him and her have verbal contact?
Well, that's what I said. They can have Zoom or FaceTime, and I suggest both of them record it. I suggest that.
Understood.
So if somebody says, "Oh no, the judge allowed this, and now he's screaming at me," well, if she's recording it, she's got proof of it. If he's recording it, he's got proof that she's lying. I didn't scream at her because I record it all the time. Makes sense? Zoom, FaceTime, whichever they.
I'll draft a proposed order. I'll submit it and I'll send it to Mr. White.
Mr. White, go to Second Chance Bail Bonds. You listen to me, Mr. Phillips. Where is it? It's over.
Yes, Your Honor.
Yeah,
Yes,
go
Your
back
Honor.
there and they can take it off. I thought I had the anyway. I think it's over there. Yeah, they can take it off. But reach out to the Men Stopping Violence, and of course, most of them know me over there, and just get something from them. Okay.
Yes, Your Honor.
All right, just hang in there a little bit longer.
Thank you, ma'am.
All right, thank you, Mr. Fortis.
Thank you, Judge. Hope your eye gets better.
Oh my gosh, getting old is not for the weak of heart.
Oh, please, I'm right there with you. Have a good one.
All right,
bye,
thanks.
Mr. White.
Thank you, Judge. Thank you, Mr. Fortis.
Thank you, Mr. White. Looks like that's it.
All right. Oops.
Hello.
I'm not doing that. Let me just make myself. Okay. So, first of all, if the court has to tell your partner not to have violent contact with you in order for them to not have violent contact with you, probably a good sign to leave. Also, he allegedly choked her, and you can't hear me. One sec.
How about now? Is that better? Just wait for the thing. Now it really is blurry. Okay, cool. So I said if the court has to order for someone to have non-violent contact with you, your partner, then they're not a good partner to have. And also he choked her, and people who are choked by their partners in like a power play are 750% more likely to be killed within the year. So I don't disagree with the judge at all. I think also having one of their parents there, like they're in their 30s. Am I frozen? Seriously? No. All right, I'm gonna say goodnight. I will see you guys soon. Thank you so much. I don't know if you can hear me or not, but I don't know what's going on. StreamYard's on it today. Bye.